matter, analogous matter. This matter about the appeal has been preferred against the order. Support of the petitioner. The institute has prepared appeal. Without giving any paper book, the matter is hanging since 2018. That's why the petitioner is getting the award, which is declared by the elect.
What do you want? To prepare the paper books? You want to prepare the paper books?
Kindly read the matter and if
We don't have time to read the matter. What is your mentioning?
my mentioning is to enlist the matter for hearing of this matter.
It's not ready for hearing. How can we do that? Yes.
That should be given to
My lord, inclusion, my lord.
To be mentioned, right to be mentioned and hand it over.
May I
Yes.
be permitted
Right to be mentioned there.
May I be permitted to mention, my lord, one appeal hearing?
Ma'am, can you please use the microphone?
May I be permitted to mention, my lord, one appeal hearing, my lord, of 2017. It's ready for hearing, my lord. There is no respondents, my lord. It will take-
Modulation of voice won't help you.
But may I have a
We are not being able to.
Lordship,
We are
anything.
not being able
Let
to.
it be listed, my lord. Let
No.
it be listed.
No,
my
that
lord.
is precisely what we are not doing. We are disposing of matters on the list. So
Lordship, it will take only 10 minutes, my lord. He's a septuagenarian bed.
multiply 10 into all the matters. Yes.
But may I have a lordship's kind leave to mention a matter? My lord will recall, my lord, this is that matter where your lordship has referred this to a special bench, my lord, on that question whether a bench having determination, not having determination passes an order if it's a null. But that has been answered now. Possibly your lordship's order has to be recalled, my lord, because the bench has answered it's a nullity, my lord.
I love one-page application.
As your lordship says, my lord.
One-page application.
Placing that order on record, my lord.
Placing that order on the record. For
Great.
that,
I'll do that. I'll come back.
do that, and because you have to formally seek a recall on the ground of that order, we'll just do that.
I'll come back with that. Grateful.
Yes.
My lord, inclusion.
Of
Inclusion for admission.
admission hearing. Admission of what appeal?
FAT.
If it is not required to be admitted, sorry, refused. Yes.
Lordship, may I be permitted to mention a matter? An application hearing for a stay application.
Yes. Yes, sorry, you missed your turn.
For application or inclusion.
Application, yes.
Lord, may I have a lordship's leave to mention a Port Blair matter? This is in my application
Stay
for
application.
release of the money which has been which is lying in court.
What is it? Application or what?
It's an application for release of the arbitral money which is deposited in
There is
court.
no circuit now.
No, but there is no circuit now. 18th July, my lord, I am told, there is one circuit bench of your lordship, my lord. And the files are
Port
lying.
Blair, we don't have it.
I'm told, my lord, 18th July
18th July, we have nothing.
at 1 p.m. my lord, I'm told when there's
Oh,
one
another matter has been
there's
fixed.
one
Right.
matter.
Very
But if it could be listed, then
Thank you. Yeah.
I'm grateful, my lord.
My lord, order 41.
18th July. 18th July you should go.
My lord, order 41, rule 11 matter for inclusion in this.
Yes.
I'm grateful. Water 41 matter for me.
First appeal is not first learn whatever. It is not required to be admitted. Ask your the learned friend behind. Yes.
No, last Thursday, my lord, your lordship delivered the judgment. And
Yes. What is the correction you wanted?
the
Mr.
correction
Chakra?
will kindly come to para 15, my lord. Para 15.
Para 15. Yes, para 15.
It expected that the sale deed as directed by the trial court shall be executed at the earliest by the defendants, etc., within an outer limit of 60 days. But facts is that subsequent to filing of this appeal, I put the decree in execution, and through executing court, it has been already executed and registered. At this stage, they move the stay petition.
So then this direction
Redundant.
is redundant.
Redundant. But
Redundant.
one thing, Lord, at that stage, they moved the stay petition because possession was not yet taken. That's why this.
So we
stay
have
was done.
clarified that in the event of non-compliance, executive court shall proceed. If it's already over, then
Yes.
this is redundant.
Yes. But non-compliance, not first line of para 16 in that case should be deleted also. Execution.
Both are
should
redundant.
proceed.
If that is redundant, this is also.
Yes.
No order needs to be need. একটা order. Learned counsel for the plaintiff stroke respondent number 1 points out that the decree has already been executed, and as such, the direction in the judgment dated July
Decree
10.
not decree has two parts. One is possession.
The direction learned counsel appearing for the
Execution
plaintiff
is the
respondent number 1 submits that the
Execution.
portion of the impugned decree whereby sale deed was directed to be executed has already been complied with previously. So
By
as
through
such,
court, executing court.
as such, comma, the has already been complied with na kore has already been executed. As such, comma, the direction in that regard in the judgment dated July 10, 2025 is redundant. Full stop. It be so, comma, no further order is required to be passed in that regard, since the appeal has already been disposed of. Yes.
But possession is required to be taken, Lord. That will be through court, Lord, execution.
Execution course will proceed in any.
Proceed.
Yes, yes. Next.
Lord, I'm getting. I'm getting.
2, 3. Yes, Mr. Dutt.
My lord, may I, my lord, at the very outset, my lord, make a request? My lord, I was trying to get ready in the matter, but my lord, I found that my lord, the paper book is incomplete.
Paper books?
Is incomplete. My lord, there are my lord, documents which are referred to in the arbitrator's award, my lord, which do not find my lord place in the paper book. The cross-examination is not on record. The matter has come up from Barashat court. Now, my lord, the
You've
difficult.
already heard it in part, and
I realize that. I realize that. My lord, I
you want to rely on further papers, Mr. Shah, you can just circulate among the
Well,
other side.
I will do that, Miller. I do not want to disturb the proceedings at all, Miller. I feel very embarrassed in making.
No question of your embarrassment.
Miller, I am.
There
Miller,
are papers
I
we
have
have to
Miller, sent someone to the Barashat court. Miller, they are trying to get it out from the records. Miller, if I can get it, well and good. If I can't get it, I will proceed on the basis of whatever there is.
So how much time do you look?
Miller, I just require Miller 1 week's time. Miller, I will next
1 week means we'll have to keep it after in sometime in August, because we are not there.
Oh, I
This
see.
bench will be going.
Miller,
to
I
the
was
August.
just praying, Miller. I have already sent people to the Barashat court. If you can get the records, well and good. If I do not get the records, I will not waste your lordship's time. I will proceed on whatever.
Very well. Mr. Dutt, then we keep it in the first Tuesday in August. Learned Senior Counsel appearing for the respondent submits that certain papers which are relevant for the purpose of the present adjudication, comma, have been omitted from the paper books. Push up. Learned Senior Counsel accordingly seeks some time to furnish those papers, comma, if available. Push up. Next para. Accordingly, such leave is granted to the respondent. Full stop. The respondent may rely on further papers, comma, if germane, for the adjudication on the next date of hearing upon prior circulation to the learned advocates for the appellant. Full stop. The matter shall next be placed under the same heading on August 5, 2025.
I do not know, my lord, whether it will be, my lord, proper for your lordships to seek a direction from your lordship to the lower court to provide the lower court records.
Because we won't pass that, Mr. Shah, because simply we don't know lower court records you are saying.
Yes, because my lord, if
That
the
will take
records
more time.
come, then my lord, everything will be there before your lordship.
Records, you don't know whether in 2 weeks it will be coming.
Very
It's
well.
of a part matter difficult.
No, no,
Better to take certified copies out.
very well.
from all.
Very well.
Because you know how the process works.
So I had only one indulgence.
Yes,
to
Mr.
speak, Miller. If it, your lordship has heard me substantially, it
Yes.
will be marked as part of.
It is already marked. That is what you
Especially
said.
assigned.
Bench may change minutes. That's the reason why. Otherwise, I have to start.
If the new judges are coming with the bench changes, so should we cancel the Potter?
No.
Because really, Mr. Dutt, you and Mr. Shah, yes.
I can, my lord, assure your lordship that my lord, no further accommodation will be, my lord,
No,
sought.
not that. Not that.
Irrespective
If
whether
the
the
composition
bench
of
is
the bench
available.
changes by chance, then we do. I don't know whether I'll retain my division bench even, because if you see the number game, I'm the penultimate division bench. So if 2 judges come at the top, we don't know what will happen.
Well, let it be as it is, my lord. I do not want to lose your lordship's bench.
Anyway, yes.
My lord, I'm for the petitioner, my lord. In the last petition, my lord, the matter has been restored.
Matter was
Matter was restored, my lord.
restored. Yes.
Restored, my
That
lord.
restoration is.
Yes, my lord. Today is the fix for hearing on the condemnation of delay application.
Yes. I'm opposing the condemnation.
That is Can 1. Yes.
Yes, my lord.
Move it.
Mr. Ishan Shah is appearing, my lord.
You're also there.
There is 262 days delay, my lord.
What is the ground?
Just
If you told us earlier, we would hold the senior Mr. Shah at ransom for Mr. Shah to come quickly. He was there in the previous matter. But anyway, since you have missed that opportunity, you move them. Delay was wholly beyond the control means no ground. Change of advocate. No ground.
Yes, my lord.
Even if Mr. Shah comes, there will be no ground. Something worth, I mean, recording in your order has to be given by way of ground. See paras 9 and 10, which are your explanations?
Yes, my lord. Certified copy applied, my lord. 23rd July 2012, made available on the 16th of May 2013. Thereafter, my lord, change of advocate obtained.
It's a wasting time, Mr. Shah. We are putting it on your mouth. We are granting you leave to file a supplementary affidavit.
Yes, my
There
lord.
are
Please.
several supplementary affidavits,
Already said.
opposition reply all on
This
record.
is section 5.
We are taking this very.
Not to the section.
This is section 5.
Like given.
Opposition reply are over. There's supplementary also, supplementary affidavit also.
No explanation at all.
Lord, lordship sees, my lord has a
So, at
discussion.
the change of advocate, yes, you may fancy a different advocate. But that is not by itself a ground.
My lord, if
And it's so blatant, Mr. Shah. Just look at para 9.
my lord, delay is substantial, but also, my lord, there is.
No, not only,
point.
even if 1 day's delay, that principle.
Yes, my lord.
Number is not important. But
Yeah.
yes, if it's too long, then 262 is not so long. But the ground, there has to be some semblance of a ground. You say somebody, you name your advocate, he applied for certified copy, which was made ready. Soon thereafter, you obtained a change of advocate and filed the present appeal on 17th May.
Paragraph 10, my lord, no contemporaneous knowledge, my lord. I have one judgment.
Yes, you say that there has been a delay of 262, but such delay was wholly beyond the control of a petitioner. No contemporaneous knowledge about the impugned judgment. Why?
My lord, may I hand up, rely on.
You cannot
one
just say I did not have knowledge. You are
Let-
playing the ostrich. You don't have knowledge, your choice, you don't have knowledge.
May I rely on one judgment, my lord.
We love to distinguish things.
My lord, 2009 Supreme Court cases 733.
What is the ratio laid down?
My
Let
lord,
us
here
come to the
also
ratio.
condonation of delay sought on the ground that, my lord, the appellant was not aware of the passing of the order impugned for some time. What should we kindly take, my lord?
Please see, read paras 5 and 6, Mr. Shah. Just read para 5 and 6.
Appellant was kept under the impression that the appeal had already been filed. When the appellant tried to contact his advocate to know about the progress of his case, he did not receive the satisfactory
So
information.
these things were there.
Yes. My lord, to see, my lord, the appeal has merit, my lord.
This was before Justice Trivedi and Justice Pardewala came to the scene. Now the law is different. And as a matter of course, definitely not. And here it was said, though the period of delay is unduly long, circumstances are also very unusual. We don't find any even usual circumstances are not there. Usual grounds of section 5.
My lord, if your lordship, as your lordship.
There, the impression was given. They were not negligent. They went to the advocate. Impression was given that it was being filed. Came to know the progress of the case. Did not receive satisfactory information. Then found, engaged another advocate. These things are there. Here you say, just see what you have said. 2 sentences.
9 and 10, yes, my lord. No
Obtained a change of
knowledge the
advocate.
impugned judgment. Paragraph 10.
What was the fault of the previous advocate? Had no contemporaneous knowledge. Why didn't you have knowledge? Your choice not to have knowledge.
Kindly allow me to, my lord, file a supplementary affidavit.
No, Mr. Shah, not at this stage because opposition and reply has been exchanged. Now, you are aware of whatever is there. And one supplementary affidavit is also there.
We have filed supplementary to
Oh.
that. They have given their opposition.
No. Pleadings are over, Mr. Shah. Sorry, no. No explanation.
Supplementary position also.
We are sorry to do it, but section 5, yes, we feel guilty.
May I come back, my lord, on another occasion, my lord, if I can.
Come back for a different matter, Mr. Shah. You would be most welcome in this court, but for a different matter. No, there is nothing.
Lordship will kindly.
Sorry,
consider,
Mr.
my lord,
Shah, you are
the
passing
appeal
around.
has merit, my lord. That is all I can say, my lord.
That also is not a ground nowadays. You know that also.
I do.
That's why we said that. before the two judges we named of the Supreme Court came to the picture, came to the scene rather, then that was the law. But these two judgments have changed the scenario. Parawise it has been written. We don't recollect by memory. I mean, but merit cannot be one of the grounds. Now it has been stated. And those judgments consider the previous judgments. Previously also tangentially it could be a ground. What is the merit? Now that we are curious. Yes,
Yes, my lord.
In you have has to be very precise.
Dispute arises out of a share purchase agreement, my lord. There were share forms, share transfer forms that we applied to the ROC for extension or revalidation. That act of the ROC was challenged in the writ petition, and that writ petition succeeded. Appeal is against that writ petition, order in writ petition.
That is not, there is no merit in that.
My lord, merit is that there was no requirement at all to revalidate. So it was an order exercise in futility that was being challenged.
No ground, no ground, sir. You have got your opportunity to. I mean, we see an affidavit in opposition, supplementary affidavit in opposition, so many things, Mr. Shah. What have you stated in your opposition?
Additional point that they have come up with a false case. In a section 5, if one comes with a false case,
What is a false case?
because they have said that they were not aware of the writ petition being disposed of. Kindly see their paragraph 6.
Yes,
Paragraph 6.
yes.
So they mention the matter. Respondent suddenly mentions the matter. This is a neither your petitioner nor your petitioner that the advocate had any knowledge about hearing of the petition or about the impugnation. Pursuant instructions of the petitioner, that then advocate petitioner Deepak Jain sent a notice herein that the matter would be mentioned. There was no interim order there. Why the respondent suddenly felt the necessity to mention? And then paragraph 7, pursuant to such notice, the learned counsel of a petitioner, Utpal Bose, mentioned the matter before Justice Patheria itself when the learned judge was pleased to point out that the petition already been disposed of. Thereafter, your petitioner, the then advocate.
That is how they came to know of the dismissal.
Well, they were, why would a respondent suddenly mention a matter? I'm asking myself, when there is no interim order, unless they knew and they wanted to cover up that delay and then to come to another advocate.
Mr. Mitra, in paragraph 4, they have stated candidly that their advocate had missed the matter.
Now then, my lord,
that is the main ground.
So we
Missed the matter, maybe bona fide.
But so we in the supplementary affidavit we show there's another appeal pending where this order was brought on record, and only
Before filing of this,
yes, before they're mentioning also.
shows that.
My lord, in the reply, page 3, paragraph 4, my lord, we have said miss the matter. My lord, it is omission.
My lord,
My lord, we can
paragraph,
cannot
kindly
be
give your
previous
lordship.
batches of that.
So that is an additional ground. Supplementary affidavit.
Supplementary.
Paragraph 12, page 8. And advocate's lapse is no longer a ground. That is the Patapatti judgment of Justice Bila Trivedi and followed by a lordship. Paragraph 12.
Yes, but unusual cases. Yes.
But they are, on facts, this is a very strong case also. Very strong case. They apply for extension. There is a statutory requirement to get the form extended.
Now, what is annexure A? 12, page 12 of
Page 12 or page 8, page 8. Paragraph 12, sorry.
oh,
Page 8.
paragraph 12. Yes, I say that the judgment.
So what was the need to mention after that? And they have themselves said, because
No, they relied on this judgment. You relied on this judgment in a different matter.
yes. And in fact, they have said in that section 397 appeal, this issue was very much there. And so why would they mention on 3rd? Why was the charade of mentioning? And knowledge from mentioning.
So the judgment and order dated 23rd July is the order.
Yes, it's
impugned
the order under challenge.
It was brought on record in the appeals. Who brought this on record? You brought this on record.
we.
Answering response on 2nd May 2013.
So why go to the charade of mentioning thereafter? If at all this mentioning happened. And I have got those judgments when one comes with a dishonest case in a court of equity where section 5, that's Supreme Court has said, you create the charade of mentioning just for respondent mentions What for? Why would I mention them, assuming I knew that I didn't know about the matter? Matter is lying stale and no interim order being enjoyed by the other
Could be a
side.
dumb charade then.
Yes, exactly.
On that aspect, at least, may I come back to address your lordship?
No, you
Around
cannot
that
come back
question.
on this matter, sir. No question of escaping the court now that we have. I mean, we don't have any particular fun in dismissing Section 5 matters. But after being heard, I mean, at the time of hearing, no, don't come back.
I mean, I have got the judgments
Answer-
of.
Yes, what is your answer in your reply to this?
Just see this. Now reply the. এটা reply না এটা reply বার করো reply টা হ্যাঁ ওটা section 5 বার করো তো এটাই তো.
But Mr. Mittu, we have to see whether this copy of this supplementary affidavit was given to them.
And yes, it is annexed here, and they have not denied that fact. They have not denied that fact in their opposition.
My lord, we have not used any opposition.
They
of
have
respect
used
to
an
the
opposition to the supplementary affidavit of paragraph 8. Now I'm just. And this change of advocate is a complete charade. In other proceedings, there the same advocate is going on.
Still,
Yes. I don't want to go into advocate's path. I don't want to go into. Actually, this is the reply. I've hand. Paragraph. Slightly marked paragraph 8.
reply to the this supplementary.
This paragraph 12.
merits এ নানা রকম বলেছেন আপনি। Merits এ বলেছেন।
Not the case, it will not serve.
কিছু উত্তর দেননি। এগুলো না বসলে হতো এতগুলো। My lord, I have not had the previous occasion to consider this reply. I am the changed advocate in this case, my lord. Your lordship will kindly allow me to just consider this and come back. Since there is an allegation, my lord, of dishonest statement being made to court.
Yes, that was there. That allegation is there from when they used the supplementary affidavit. You knew about that before coming to
Kindly make it
argue
not
this.
today, my lord. Let me come back just
No,
tomorrow, my
sir.
lord.
Whatever is there on record is there on record. You have had ample opportunity to use your affidavits and supplementary affidavit, opposition to that. Not as a matter of course, Mr. Shah.
And well, I will also show my lord, because here there's a lot turning on this. So, my lord, the matter was heard on 3 dates. They did not appear. They'd given their affidavit in opposition to the writ petition. And they were.
In this reply, they say the appellant for the first time learnt about disposal of the writ petition only on 3rd May,
Yes, my lord.
which is the next day after you affirm the supplementary affidavit, which is credible. And that is what they have stated in para 10.
Yes, same thing.
No, you say in paragraph 12 of your supplementary affidavit, Mr. Mitro, that you affirmed a supplementary affidavit where you disclosed about this order. That supplementary affidavit was affirmed on 2nd of May 2013. So they say they derived knowledge on 3rd of May 2013, the next day.
When they mention the matter, why? Well, my question is, why would somebody play this dumb charade game? Why would
We
somebody?
don't know when the supplementary, you have not stated when the supplementary
That is the day
affidavit
after
was
they
affirmed.
acquired knowledge.
You say that you affirmed the supplementary affidavit on 2nd May, and they say they mentioned on 3rd May.
Yes, but what I am on, my lord, is that on 3rd May, why this dumb charade game? Why
Not
does?
sure, the
That
3rd
is the
May
day
they
on
might
which
have
you
mentioned for
acquired
inclusion in the
knowledge.
My lord, why should somebody mention
coincidence.
as a respondent, where there is no interim order, but matter is pending, unless they want to create a ruse for
There was
filing.
no interim order.
There was no interim order in the writ petition pending for last 3 or 4 years. Pending for last 4 years. Suddenly they mentioned. Third, 11 a.m. The matter is notice is given, and it mentioned that
Now we cannot disprove also that they had mentioned the matter on 3rd May.
no, I am not saying that
If
they-
you
that
can't
they-
disprove that, then the worst thing against them is that
they knew and they mentioned just
they
to
knew on
get
3rd
the
May.
ground. Get the ground.
Either way, they knew on 3rd May. Even if you affirm that a supplementary affidavit disclosing this on 2nd May, they must have known on 3rd May, they should have known. Now, 3rd May, their knowledge on 3rd May is not disputed. And then they,
Why will they mention? Is this a ground?
Suppose we discard that mentioning.
My lord, page 8, paragraph
Well,
8
if
of my
they
review.
discard the mentioning, then in that
We are
case,
saying that if it, unless it is disproved, we cannot say that they have
Very-
practiced fraud upon court.
let us discard.
Not proved. At best,
Let us
not proved.
discard the mentioning.
Let us discard that.
There is
Then also
pure-
they have knowledge on
there is
third
pure advocates lapse. Pure because the advocate, they have a team
based
of
on that particular day in the list.
Well,
Regularly happens.
So, well, 3 days. Logically takes a look at the 3 days the matter appeared. They had given their affidavit. 3 days they appeared. Well, I will be citing those.
My lord will kindly consider
Judgments
page 8
also,
of my
lordship.
affidavit in reply to the supplementary, my lord. Page 8, paragraph 8.
Yes, we are there. It has been handed over.
Yes, my lord.
So
Where?
you said you didn't have the reply to
I
supplementary
have-
affidavit.
It's being handed to me now, sir.
Yes.
And the order records was heard on 3 days.
The impugned ex parte judgment of the order dated 23rd July 2012 passed by the learned single.
You reiterate that you had knowledge on 3rd May. Mr.
Yes.
Shah, you say that
That's
you
right.
mentioned the matter.
Mentioned for early hearing at the end of the day, that day, 4:15
And the
PM.
matter was heard on 3 days, the order itself records. And their application itself records, section 5 application, that the matter was heard for 3 days. Paragraph 4 of the section 5. Can you see paragraph 4, page 3? Paragraph 4, page 3 of the section 5 application. दाओ टैक्स तुम्हें तुम्हारी पतापति दाओ
Yes, yes.
So
They should have immediately taken information.
so assuming it is an advocate's lapse, but that's
No,
not a
even if 3rd May was their knowledge after that, but yes, right, you are right there because it was in the process of being heard
yes.
and it was fixed for orders on July 16. Now, even if they missed the matter on that date, they should have immediately inquired as to, and this is filed 1 year after that, almost. Mr. Shah, Mr. Mithra has a point there. We accept your contention that you came to know on 3rd, rather on 3rd May something happened. Either you mentioned or they,
Yes, my lord.
but your paragraph 4, 29 June, 6 July, it is being heard. You admit that the next day fixed for orders was 16th of July. 16th of July, let us suppose you miss the matter. It was fixed to appear on 16th of July. Even if you miss the matter from the list, won't you inquire immediately? There was no occasion for missing the matter in the list. It was pre-scheduled to appear on that date. Now, if you are in our position, what would you do?
I appreciate, my lord. Latches of the advocate is the only thing that has been stated, my lord. The litigant cannot be made to suffer for
No.
latches of advocate. Beyond that, my lord, we have little explanation to offer. But, my lord, this is well settled position that, my lord, for the latches of the advocate, litigant cannot be made to suffer.
Position has changed now, Mr. Shah. It has changed. If you can formally cite the judgment.
Formally citing
I forget
the
this
judgment,
citations.
Patapati and also my lord judgment following this. And
No, not my judgment. Single bench judgment is
Supreme
not mine.
Court. This
So
is the
only
Supreme
Supreme Court.
Court judgment.
Your learned friend knows that.
Division bench judge, your lordship.
All right.
Division bench,
No,
my lord.
that's Supreme Court judgment was the instigator because we don't love to do this.
The Supreme Court judgment. Okay, the copy now. Rajnishta,
No, sorry, it was Justice Mittal's judgment.
Rajnishta da.
How many? Para 26 probably
Rajnish da.
there should be an entity.
And Justice Pardiwala's judgment.
Yes, that was also.
Justice Pardiwala's judgment. Ode copy da. Ode copy da. Ode da. That is lawyers paragraph 10. It appears that the entire blame has been thrown on the head of the advocate who was appearing for the petitioners in the trial court. We have noticed over a period of time a tendency on the part of the litigants to blame their lawyers of negligence and carelessness in attending the proceedings before the court. Even if we assume for a moment that the concerned lawyer was careless or negligent, this by itself cannot be a ground to condone long and inordinate.
Mr. Shah, I go through paragraph 10 of
Yes, my lord.
And this, rightly or wrongly,
Rajnish Kumar.
Rightly or wrongly, our division bench has followed this judgment.
No, our division bench has to follow this.
So
No option.
So may I show our division?
Our division, no.
Very well.
Let the blame be on the less cited the better.
11 Supreme Court 1237. 114 days delay.
And in this case, Mr. Shah, actually,
534 days delay in
you
this
you
one,
in
or
your
long
application,
inordinate delay.
in your application, you say must be true to knowledge. Let us see. Must be true to knowledge. Para 4. No. Based on records.
Rajnish Kumar, my lord, 534 delay. In that context, it was
No, no, no.
litigant could have.
The para 10 is independent of that.
And may I show
Para 10 is independent of the
Yes,
time.
but long inordinate delay. In that case, the inordinate delay was
What is
534.
inordinate? What is long? For some, 10 days is inordinate. Depending on the matter.
239 days delay before the trial court, before the appeal court, paragraph 3, division bench dismissed. Then SLP, this judgment, SLP 114 days delay, again dismissed.
No, this is not a precedent.
So number of days is not, I say the number of days is not the factor. And the length of delay is also not a factor. Length of delay is immaterial.
What were you doing in between? I mean, the matter was being heard for 3 days, 2 days at least, Mr. Shah.
Yes, my lord.
We don't find anything in your petition that you had been taking information or any explanation for that. If my matter is going on in court today, Mr. Shah,
Yes,
obviously your client will ask you in the evening, your advocate on record, what happened to my case?
yes, my lord.
Even if your advocate on record doesn't inform. Unless you're doing a pro bono matter, pro bono matters clients ask all the more, actually. They are more vigilant in pro bono matters.
Yes,
But
my lord.
you should at least ask your advocate what is
Yes,
going on in my matter. It is
Advocate did
appearing
not
before.
contemporaneously.
See,
but
Mr. Shah,
that
let
is
us be practical also.
Yes.
2 days matter is going on for
Yes.
hearing. Third date is fixed for order. Now, those 2 days, advocates must have asked for fees at least. So you
Bills are not immediately raised. Always,
must have
my lord.
not immediately read, but must have informed you previously, the client.
That is what is
Advocates
not
inform the
informed
client
there.
that your matter will be taken up today, so that later on they can raise bills.
In this case,
Clients will obviously, the first thing that the advocate on record will do is to inform the client your matter is on the list, is being heard.
yes, my lord. Typically,
So,
that is what would happen, but in this case, my lord, that is unfortunate. What we say has not happened, has not transferred.
nothing.
They did not have, my lord, contemporary knowledge.
Sorry, Mr. Shah. The present application bearing can 1 of 2013 within bracket old number can 5429 of 2013 is has been filed for condonation of the delay of about 262 days in preferring the instant appeal. Push up next para, learned counsel appearing for the appellant stroke petitioner submits that there were no latches on the part of the petitioner in the delay in preferring the appeal, full-stop, by placing reliance on the averments made in the condonation application, comma, it is pointed out that the writ petition, comma, from which the present appeal arises, comma, was being heard before the concerned learned single judge and was fixed for orders on July 16, 2012, comma, on which date the erstwhile learned advocate appearing for your petitioner had missed the matter from the list inadvertently and had not appeared in the hearing. Full stop next para. Subsequently, comma, it is contended, comma, when the matter was mentioned before the said learned single judge for being included in the list on May 3, 2013, comma, and the matter thereafter was and the matter theke kete dao, comma, the learned single judge was pleased to point out that the writ petition had already been disposed of by her. Full stop next para. It is contended that immediately thereafter certified copy was applied for in respect of the said judgment, and upon obtaining the same, comma, a change of advocate was taken and the present appeal has been preferred. Full stop next para. As such, comma, since there was no contemporaneous knowledge on the part of the petitioner regarding the disposal of the writ petition, comma, no steps were previously taken before May 3, 2013. Full stop next para. It is further argued by learned counsel for the petitioner that it is a well-settled principle of law that the litigants cannot suffer for the laches of their counsel. Full stop. Moreover, comma, it is argued that in cases of condonation of delay, comma, particularly since the period of delay is not so long, comma, a lenient approach is taken by courts. Full stop. Next para, learned senior counsel appearing for the respondent vehemently opposes the prayer for condonation, and by placing reliance on the supplementary affidavit filed to the affidavit in opposition by the respondent to the condonation application, comma, points out that the allegation that the averment as to the matter being mentioned before the concerned learned single judge on May 3, 2013 is a charade. 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 Full stop. It is submitted that since there was no subsisting interim order being suffered by the respondent, comma, there could not have arisen any occasion for the respondent to so mention the matter. Full stop. Next para. Furthermore, comma, learned senior counsel places reliance on paragraph 12 of the supplementary affidavit of the respondent to show that that a supplementary affidavit had been affirmed on May 2, 2013 in connection with a different matter, comma, being APO number 346 of 1996 with APO number 347 of 1996, comma, a copy of which was served on the present appellant. Full stop. Next para, thus, comma, the appellant had full knowledge of the dismissal of the writ petition, of the disposal of the writ petition on such date, independently of any mentioning being done. Full stop. Next para, thus, comma, it is submitted that the equitable relief of condonation of delay ought to be refused in view of the attempt on the part of the petitioner to mislead the court by stating that it derived knowledge of the disposal of the writ petition for the first time upon mentioning the matter before the concerned bench. Full stop. Next para, learned senior counsel cites the judgment of such and such reported at 2024 SCC Online SC 513 for the proposition that the law of limitation is based upon public policy and there should be an end to litigation by forfeiting the right to remedy rather than the right itself. Full stop. A right or the remedy that has not been exercised or availed of for a long time, comma, it was held, comma, must come to an end or cease, CEASE, to exist after a fixed period of time. Full stop. It was further held that although a justice-oriented approach ought to be taken to do substantial justice, comma, the same cannot be used to defeat the substantial law of limitation contained in section 3 of the Limitation Act. Full stop. Courts, comma, it was held, comma, are empowered to exercise discretion to condone the delay if sufficient cause has been explained, comma, but that exercise of power is discretionary in nature and may not be exercised even if sufficient cause is established for various factors such as where there is inordinate delay, comma, negligence and want of due diligence. Full stop. It was observed by the Supreme Court that merely some persons having obtained a relief in similar matter does not mean that others are also entitled to the same benefit if the court is not satisfied with the cause shown for the delay. Full stop. More importantly, comma, it was held that merits of the case are not required to be considered in condoning the delay. Full stop. Thus, comma, it is argued by learned senior counsel for the respondent that the argument of the petitioner that the merits of the appeal are to be looked into cannot be accepted. Full stop. Next para, learned senior counsel further cites Rajanish Kumar such and such reported at 2024 SCC Online SC 3380. নামগুলো দেখে দিয়ে দিই।
My lord, may I have your lordship?
Full stop. Next para.
May I have your lordship's kind leave, my lord?
Oh yes, yes. In the said case, comma, the Supreme Court had observed, comma, inter alia, comma, that it appeared that the entire blame had been thrown on the head of the advocate who was appearing for the petitioners in the trial court in the said matter. Full stop. The Supreme Court laid down that it had noticed over a period of time a tendency on the part of the litigants to blame their lawyers of negligence and carelessness in attending the proceedings before the court. Full stop. It was held that even if the court assumes for a moment that the concerned lawyer was careless or negligent, comma, this by itself, comma, cannot be a ground to condone long and inordinate delay, as the litigant owes a duty to be vigilant of his own rights and is expected to be equally vigilant about the judicial proceedings pending in the court initiated at his instance. Full stop. The litigant therefore should not be permitted to throw the entire blame on the head of the advocate and thereby disown him at any time and seek relief. Full stop. Learned senior counsel also cites such and such reported at AIR 2011 SC 1237 for the proposition that even a delay of 114 days was refused to be condoned in the said case by the Supreme Court, whereas in the present case, comma, the delay is of 262 days. Full stop. Next para. Upon hearing learned counsel, comma, we are of the opinion that that whether the length of the delay is inordinate is a matter of perception and depends on the facts and circumstances of each case. Full stop. In the present case, comma, we desist from making a comment as to whether the delay of 262 days was inordinate or not, comma, since the the nature of the order impugned in the appeal and the urgency, comma, if any, implicit in the necessity to prefer an appeal are not before us at this stage. Full stop. Next para. However, comma, it is well settled that a negligent litigant cannot be given the benefit of the liberal approach taken by courts while deciding condonation of delay applications. Full stop. As held by the Supreme Court in Pathapati, P-A-T-H-A-P-A-T-I, Subba Reddy Supra, comma, although the courts may exercise discretion to condone the delay if sufficient cause has been explained, comma, the power is discretionary in nature and may not be exercised even if sufficient cause is established for various factors including want of due diligence. For sub next para, although in the judgment of Rajneesh Kumar Supra, comma, the Supreme Court considered the long and inordinate length of the delay, comma, irrespective of the same, comma, it was independently held that the litigant should not be permitted to throw the entire blame on the head of the advocate as a matter of rule and thereby disown him at any time and seek relief. Full stop. In the judgment of Union of India versus Nripen Sharma Supra, comma, however, comma, no proposition of law as such was laid down, and as such, we do not find that the said judgment operates as a binding precedent in the present context. For the next para, in the above backdrop, comma, looking at the circumstances of the present case, comma, we do not find that the aspect of diligence being exercised by the appellant has at all been reflected in the application at all. Full stop. Next para, in paragraph number 4 of the condonation application, comma, the appellant boldly states that the writ petition, comma, from which the present appeal arises, comma, was being heard before the concerned learned single judge on several occasions, including June 29, 2012 and July 6, 2012. And thereafter, the writ petition had appeared for orders on July 16, 2012. Full stop. In view of the very fact that the writ petition was in the process of being heard on subsequent dates, comma, there could not be any reason whatsoever for learned counsel for the petitioner appellant to be unaware of the fact that the matter was fixed for orders upon such hearing on July 16, 2012. Full stop. Even if you take the best case of the appellant stroke petitioner, comma, the advocate of the appellant might have missed the matter from the list on the said date. Full stop. However, comma, the said factum itself shows that shows utter negligence on the part of the said learned advocate, comma, since in an ongoing hearing, comma, it is the incumbent duty of counsel to attend the matter on the next date fixed. Full stop, next para. Even that apart, comma, we are unable to accept that the petitioner, comma, being a company engaged in development, comma, was represented by so naive people, naive in IV, naive people, that despite being aware of the hearing going on in the matter, comma, they failed to take any information as to what happened on the next date fixed for orders, that is July 16, 2012, contemporaneously to the disposal of the writ petition. For sub next para, we are also unable to accept that any advocate worth his metal, comma, would not be informing his client about the ongoing hearing of a matter on several dates, comma, for instructions, comma, material or otherwise at the relevant point of time. Full stop. Thus, comma, the court cannot be taken to be so gullible to accept the contention of the petitioner that there was no occasion for the petitioner itself to take information as to the outcome of the ongoing hearing of the writ petition, particularly since the next date was fixed on July 16, 2012, when the matter was writ petition was disposed of finally. Full stop, next para. Thus, comma, the negligence on the part of the petitioner itself, comma, even apart from its advocate at the relevant point of time, has not been explained away at all in the condonation application or the reply filed by the appellant. Full stop, next para. Even if we give the benefit of doubt to the appellant, insofar as the matter being mentioned on May 3, 2013, comma, May 3, 2013 could not have been the first date on which the petitioner became aware of the disposal of the writ petition long back on July 16, 2012, if it had a wee bit of diligence. Full stop, next para. Even otherwise, comma, it appears to be too much of a coincidence to us that a supplementary affidavit is affirmed by the present respondent in a different matter on May 2, 2013 and served on the appellant, on the present appellant contemporaneously, and out of the blue, comma, the respondent mentioning the matter for inclusion in the list after 1 year from its previous date of hearing, precisely on May 3, 2013. Full stop. Next para. Such coincidence itself also indicates that the mentioning was done merely to furnish a cause of action for the present condonation application. Full stop. Next para. Thus, comma, in the circumstances of the case, comma, the ratio laid down in Rajneesh Kumar Supra is squarely applicable, and it is quite transparent that the appellant stroke petitioner is trying to shift the entire blame on the erstwhile learned advocate for the petitioner for the negligence on the part of the petitioner itself in not taking any information, although the matter writ petition was taken up for hearing consecutively on June 29 and July 6, 2012 itself. Full stop, next para. Before parting with the matter, comma, we cannot but also notice that even as per the pleadings in the condonation application, comma, after coming to know of the disposal of the writ petition at the relevant period, comma, the appellant chose the self-same erstwhile advocate to apply for certified copies and get the same, and only thereafter chose to have a change of advocate and engage someone else. Full stop, next para. Hence, comma, even after knowing of the dismissal of the matter, the appellant had reposed faith in its erstwhile advocate inasmuch as the obtaining of the certified copies and advice to prefer an appeal was concerned. Full stop. In para, in view of the above circumstances, comma, we are unable to accept that sufficient cause and or diligence has been made out on the part of the appellant for prompting us to condone the delay of 262 days in preferring the appeal. Full stop. It is trite law that the number of days is not so important and a factor, but the appellant has to show its diligence at the relevant point of time in conduct of litigation to get the benefit of condonation of delay, full stop. That being lacking in the present case, comma, we are unable to allow the application, full stop. Accordingly, can 1 of 2013 within bracket old number can 5429 of 2013 is dismissed on contest without comma, however, comma, any order as to cost, full stop. Consequentially, MAT 841 of 2013 stands dismissed as time barred, full stop. All connected applications, all connected other applications, comma, if pending, comma, stand disposed of as well. There cannot be an interim order subsisting in this.
Well, it's only one correction, my lord. I did not want to interrupt because your lordship was
Yes.
dictating. My lord, the order is dated 23rd July.
Oh.
It was 4 orders on July 16, but the order is dated 23rd July.
একটা কোথাও না বোল্ড লেটারে 23rd জুলাই কথাটা লিখে দিও আমি ঢুকে I'll put that we'll put that in our
Very well. Great.
23rd জুলাইটা বোল্ড লেটারে করে রাখো বাট 16 জুলাই যেখানে আছে যেখানে পাবে সেখানে ব্র্যাকেটে 23rd জুলাই লিখে রাখো দুটো জায়গায় ঠিক আছে একটা জায়গায় ভুলে থ্যাংক ইউ
Great.
থ্যাংক সরি টু ইউ থ্যাংক ইউ টু হিম ইয়েস নেক্সট 5 and 6
And acquisition matter, I'm covered by your lordship's judgment, my lord. And the order 41 rule 27 leave was granted.
Our judgment, this bench judgment.
19
Our
June.
judgment is not broad enough to cover you. What is the matter, Mr. Bush?
No, my lord, the land acquisition proceeding was started, my lord, way back in 2007, 2006, my lord, certain deeds, my lord,
Other side is not appearing in the matter at all.
appeared, my lord.
Previously appeared.
Yes. In other matters, they appeared, my lord. I have handed over, my lord, the affidavit of service and, my lord, in my application under order 41 rule 27, the last page, my lord, it contains the judgment dated, my lord.
Mr. Basu should another chance. Who appeared for them?
Mr. Parthapratim Rai.
Mr. Parthapratim Rai, we don't know whether he is the advocate on
Oh,
record.
not in other matters, my lord. In these two matters, my lord, he
In
did.
these two matters, nobody
No,
appeared.
no. Even then, if your lordship says, my lord,
No, we were wondering about that, whether we should, because otherwise, if you get an expertity order again, a recall application,
no, I
that
don't want to.
new
do that.
fresh exercise.
I don't want
If
to.
you give a notice, that is cut off.
My lord,
Already given a
the
notice.
appellant, my lord, they were served, I'm told. The affidavit of service is there, indicating, my lord, that this was served. The clients, the
Notice that it should be
the
appearing,
respondent.
appearing in the list. We'll just check that.
এটা লিখেছেন না appear করবে বলে list এ?
Yes, yes. Yes, you can move on.
Yes, my lord. Now, my lord, the land acquisition proceeding, my lord, that was commenced, my lord, 2007, 2006, my lord, certain deeds were considered. With that is why, my lord, the award was passed in respect of certain lands, my lord. We are the requiring body, my lord, Steel Authority of India. Now, my lord, what happened? 2011, 3rd September, decree was passed. My lord, reference code was approached under section 18 by the respondent. Now, my lord, we were not paid party. We applied under our order 1 rule 10(2). This was allowed. Now, my lord, thereafter, my lord, we lost. My lord, evaluation was made based on, my lord, the only one deed, my lord, that was made available with the authority. Now, my lord, we questioned
Made available by the state or?
by the petition, the respondent, and as well as, my lord, the adjudicating authority, reference court, as well as, my lord, the court, my lord, who passed the decree, my lord, 3rd September 2011.
Three entities cannot produce a single deed.
Only
produced the
one
deed?
deed produced by, my lord, the respondent.
land
Yes,
users.
land users. Now, my lord, that decree was challenged before your lordship's court. Now, my lord, we lost on account of the delay that was not condoned. Now, we preferred the appeal SLP. The Supreme Court condoned, my lord, then the matter remitted back to your lordship. Now, my lord, 17th April 2025, the last order, my lord, passed by your lordship, that we sought for leave, my lord, that order 40, an application to be moved under order 41 rule 27 of the Code of Civil
You
Procedure.
wanted to produce other deeds.
Other deeds, 5 deeds, my lord, because that was not made available with him, because the deed was not executed by us. Now, your lordship had taken pain to deliver a judgment on this, or the order 41 rule 27 principle, as well
So
as.
there were similar matters heard by us previously.
Yes, absolutely, similar matter.
Oh, in those matters we have disposed of already.
Yes, so that judgment has been given, my lord, page annexed F.
Oh, covered means literally covered by in this matter itself.
হ্যাঁ দিয়েছে পেজ 94 ঠিক আছে পেজ 94
Page কত?
No, where is the
In the application,
In the application, my lord, annexure F,
can number three.
can number
Three.
3.
Can 3. Yes,
Yeah.
can. Annexure?
Annexure F,
Page
F.
95.
page 95. Now, my lord, the additional evidence whether appellant should be permitted, it starts at page 19. That is an internal page, my lord.
Hmm. 98.
95.
98 is the
95.
judgment.
Yes.
So the
it starts
same
from
could apply
95.
here also.
Same, just. Only, my lord, in respect of 160 FA, my lord, the date of decree is 12 July 2003. 13. And in the first one, and the measurement of land will be varied. Should I, my lord, indicate and you'll hand it to
Just hand over in the
Hey,
slip of
Milan,
paper. That will be best, Mr.
ওইটা
So
করে-
then we'll have to just follow our
yes,
judgment.
yes, yes. করে দেখুন এতে
Those were regarding the same acquisition process.
same
Acquisition
acquisition.
process.
Learned counsel appearing for the petitioner submits that similar appeals, arising out of the same land acquisition process, have already been disposed of by this court by a judgment dated June 19, 2025. First of next para, it is submitted that the questions involved in both the appeals being exactly same, a similar judgment be passed in the present matter. First up, learned counsel places reliance on the application under Order 41 Rule 27 of the Code of Civil Procedure filed by the appellant to produce 5 further sale deeds of contemporaneous period as the notice of acquisition in order to substantiate his submission that the impugned judgment, based on a sole sale deed, that too executed by the father of one of the
The
parties,
father, yes.
by the father of one of the parties, could not be a valid determinant for assessment of the compensation. First up, next para, the affidavit of service filed today be kept on record. First up, it transpires therefrom that a copy of the application for additional production of additional evidence, as well as of covering letter containing notice that the matter would be taken up before this bench, has already been served on the respondents. But despite the same, the respondents choose not to appear at the time of call. Full stop. Even on July 8, 2025, the previous date on which the matter was called on for hearing, none had appeared on behalf of the respondents. Full stop. Hence, we have no other option but to close arguments in the matter. Full stop. The matter is reserved for judgment. Mr. Bose, just furnish those copies,
Yes.
the dates, and we'll keep it on record.
Yes, my lord. Yes. My lord, your lordship has recorded, my lord. I induce your lordship to believe, my lord, it's a wrong fact that if not the father, by one of the close relatives of the respondents.
No, he was the father, Vishwanath something.
Vishwanath Machi.
Vishwanath Maji was the father of one of the claimants in one of the matters.
But Dinobandhu Maji's father is not Vishwanath Machi.
We said one of fathers of one of the
Parties.
One of the parties, my lord.
father of one of the parties, jeta bolechi, father of one of the other claimants
তাই না?
in respect of the
বুঝতে পারছিস?
other land losers
তোমার ইয়ে করেছে,
in respect of the self-same land acquisition proceedings,
হ্যাঁ, সেটা কি হয় দীনবন্ধু?
who is not a party to the present appeals.
Relative, সেটা দিয়ে বলেছি।
Other land
Relatives,
loser
yes.
in connection with the same
Yes,
land acquisition
yes,
proceedings, who is not a party to the present appeals.
Yes.
Item 160
And,
APR service.
and 160 affidavit of service, it is 159. Is affidavit of
Affidavits of service করে নিও ওটা।
I will only indicate, my
আর
lord, the
plural করে দিও, appeals are reserved for judge.
and I will indicate, my lord, the different
The
land
number of
measurement,
appeals
yes,
and date of what?
Yes, yes.
Date of the judgment.
judgment. The two
Any
different-
other
No,
difference?
land measurement, date of the judgment, and the number of the.
Instructor learned junior,
Judgment is দুটো।
please do that during the course of the day. Do that.
Yes, yes, yes. এক্ষুনি করে দেন।
If it's in handwriting, then it has to be your handwriting. Otherwise, it has to be printed. Yes. Next.
160.
Yes. Anything.
6, 7, 7. One.
7 ডাকলেন?
5 and 6. Sorry. 5 and 6 করলেন তো? Oh, sorry.
7 is different, but
My lord,
Obstruction in the administration of justice, Mr. Bo. Squarely. Yes, ma'am. What is your
my lord,
You're
in
for the-
acting number 7, we are for the respective corporation.
respondent? Mr. Basu is for the appellant.
No, no.
Then you don't have a case. Who is for the appellant? What is the matter about?
My lord, actually, on previous occasion, it is a very old matter. We don't have the brief. Our client also don't have the brief, and
You don't
we-
have the brief.
no, my lord, and we don't know who the.
Why did you take the matter?
Well, it is a very old matter, so there is a change
Why
in
did
the
you accept
panel.
the brief then if you don't have a brief? You have to accept a brief, not instructions.
No, my lord, there is a change in the panel in the corporation, so it is a very
Change
old
in the composition of?
panel in the corporation. So we
Oh,
don't
acha,
accept
acha.
the brief.
Oh, acha. You are a corporation. Don't have a brief, so what can be done? You also don't have a brief. The appellant is also. So let us allow the appeal ex parte if you don't have a brief. You are for the respondent.
Respond corporation.
Corporation. Then we are allowing the appeal ex parte. We find from our previous orders that none appeared on behalf of the parties on June 24, 2025, and only the respondents were represented on July 1, 2025, the two previous occasions when the present
My
appeal
lord,
was taken up for hearing. Full stop. Next para. Even today, at the time of call, although the respondents are represented through counsel, it is submitted that the respondents are not equipped with a brief of the matter in view of a change of panel of advocates of the respondent number 1 corporation. Full stop. However, be that as it may, however, redundant. Be that as it may, since the appellant is consistently absent and chooses not to argue his matter, MAT 1208 of 2019 is dismissed for default without any orders to cost. Full stop. Interim order, if any, stands vacated. You have anything to add, sir? You have anything to add?
No.
Yes. 8. Yes, Mr. Bhattacharya.
Give me 2 minutes to catch my breath.
No, absolutely. Please. You can take have your seat also, Mr. Bhattacharya. No difficulty. Oh, Shalimar.
Yes.
Don't take your breath. Quickly. You take your breath, you will take much more time.
Just to recapitulate, they say they have started using.
Both of you had argued you are in rejoinder. I mean, you had given your reply in this matter. Your argument was going on. Right?
Yes.
They just started.
Yes.
But there are plain cases from 1945. They have been using this mark.
Yes.
My lord, they've tin bottles as well as plastic bottles. And this unique trade dress. And over this unique trade dress and especially the shape of goods. Especially the shape of goods.
Yes.
They have acquired distinctiveness. And that's why.
Give us half a second. যে পেপার বুক গুলো আমার ওই স্লিপ লাগানো আছে সেই পেপার
without the labels দিবে
আর কোন উনি রেফার করলে তখন দেবেন আপাতত এগুলো তো সরি মিস্টার ভট্টাচার্য প্লিজ কন্টিনিউ
yes that I had shown what is registered in fact by them
Yes.
original which may have been injected না এইটা যেটা ছিল this is my original and this is their mark. Now pursuant to order of a division bench, apropos what fell from your lordship, we have suggested this. They are not agreeable to this. They are also aggrieved by the shape of goods. Well, as I have shown to your lordship, under the 1958 Act, if your lordship also considers the 1958 Act, mark did not, shape did not qualify as a mark.
You showed us that on the last occasion.
It came in only in 1999 Act.
Right. So all the registrations were during subsistence of the previous act.
No. even after that.
Even after that, but they have not applied
they
for.
applied it as device mark.
So no,
So
no
there's a-
application.
There's a difference between device mark that I will show, my lord.
And if there is a specific provision in the statute to apply for a shape,
Shape.
and they have not applied, so
they cannot claim
claim a
monopoly.
shape.
Now, my lord will also take.
Yes.
My lord, even for the first time, shape of goods qualified as a mark under the Trademarks Act 1994 of the UK. Your lordship, I have underlined that portion. England.
এটা পাবেন না। এই বইটা
My lord, it's,
UK,
it's slightly marked, my lord. I've just underlined that portion. My lord, because it received a judicial
এই
recognition.
বইটা জানিয়েছেন? ও 1356 পাতা বার করুন। কিন্তু ট্রেডমার্কস অ্যাক্ট অফ দ্য ইউনাইটেড কিংডম আছে কিনা? 1356 অনেক পরে। 56
This is for the first time.
আছে। না, অন্য এডিশন হয়ে যাচ্ছে। 56 দেখাচ্ছে কেন? এটা ফেরত দিন। Yes. It was introduced for the first time, this shape.
First time, it received a judicial recognition. And that judgment, my lord, today I am going to read in bit of a detail. Very interesting judgment with a lot of humor in it. And not all marks, all shape marks can qualify as a trademark. My lord, may I rely on, my lord, all three judgments, including the Chancery Division, the Court of Appeal, and the House of Lords approving the Chancery Division.
You show us either the
My lord, I will show the Chancery Division.
topmost court or the most humorous.
No, my lord, no. My
Either
lord, Chancery Division actually has all the.
Yes.
My lord, it's reported in 1990 RPC 341. This is the Gypsy Lemons case which I was.
Oh, yes, right.
And what can qualify as a shape mark? My lord, with your lordship's permission, if I'm. Running from your lordship's court to 41 and coming back.
41. Yes, you must have most of your cases there. The Chancery, yes, Chancery.
Well, it kindly takes to 347 of that report. My lord, under line 45. But first, I should say this was a quatime action, even before the cause of action arose. But the first line 40, these two actions, each between precisely the same parties, are both quatime actions for passing off. There is only one complication in each action, namely, it is alleged that the intended actions of the defendant were fraudulent. That is to say, that what would have taken place had the defendant succeeded in launching the rival products on the market would not have been unforeseen confusion of the purchasing public, but forcing and intending confusion. The plaintiff's product here in question is its Jif's brand lemon juice as marketed in its well-known Jif's lemon. These lemons have been on the market since about 1956. Each is in the shape of a lemon-colored lemon with a lemon-colored cap with the trademark Jif embossed thereof. My lord, the next three words are very important, but not embossed in such a way as to catch the eye of a usual consumer, shopper. Now, my lord, apropos this.
Thank God their bottle is not shaped like a coconut.
The bottle is not shaped like a coconut, and if I remove this label, this Shalimar embossed on it, would people be confused into buying it? That's the test, my lord. The size is dictated by the content, my lord. I am not troubling, my lord. There's a size, particular size. Now, if your lordship kindly turns the page to page 348, line number 40.
Yes, 40.
The logic of this is extremely hard to follow. Jif is not used as a trademark in respect of lazy lemons, but we are not concerned.
The GIF trademark duly registered is only applied to those products to which it is properly to be applied. It is perhaps my fault, but at the end of the day, I'm only unable to appreciate the force of the submission, and to tell the truth, I had comfortable feeling that Mr. Hobbs really agreed with the view. Now, I shall have to next slide, my lord. I shall have to consider the history of the defendant's attempt to break into this small lemon market in some detail later. But going straight away to the competing products, this consists of 3 lemon-shaped containers, which I have, for convenience, have denominated Mark 1, Mark 2, and Mark 3. Mark 1 consists of lemon larger than true Jif lemon of a subtly lighter shade of yellow plastic with green cap, with rather smooth stippling of the surface and containing a flat portion which enables the lemon firmly on a plain surface. It also bears the legend rare lemon. I'll not trouble your lordship with this. I'll straight away come to page 349, line 20. It is apparent from what, has your lordship got that?
Yes, yes.
For what I have already indicated, that there would be no difficulty whatsoever in a careful shopper coming to the conclusion that neither Mark 1 or 2 or 3, well, this is of the defendant's bottles. It would be merely a question of her, because in practice, it is usually a her reading the label. And it was also argued that in a daily or whatsoever shopping expeditions, today it would be called misogynist.
I was thinking so, but
Expeditions to
right.
the local market, the housewife was accustomed to reading labels with a view to ensuring that she was getting the brand of her choice. And among numerous other references, I see no point whatsoever in multiplying such references. It was pointed out that most brands of the instant coffee are in jars which are fairly similar in shape. Like here, my lord, all these jars, my lord, are fairly similar in shape.
Get your point, yes.
All this is perfectly true, but not to begin to touch the real problem in the present case. There is first of all a major fallacy in the use of the word label, because when the defendant refers to their examples, what they are really referring to are properly to be denominated surface graphics, which is, my lord, here in this case. This is the surface graphics. When they refer to, my lord, again, if I may read it, when they refer to label, because where the defendants to their examples, what they are referring to are properly to be denominated surface graphics. I will come to Narayanan as to what are the difference of trade dress, device mark, and, my lord, shape of goods will be here. Where, for example, a product is contained in a container of which there are numerous examples on the market, and soft canned drinks would be an outstanding example. The only way in which a housewife or anybody else can determine what is in the can is by being told by means of surface graphics what is in the can. So she has to read them. And in general, there may be examples where this is not the case, but without knowing the whole history of the two products, it is of course impossible to know why the situation it is as it is. The products have such graphics in such form and the shape that who runs may read. But in the present case, we are not dealing with surface graphics, as I have already indicated. The only item which might be said to fall into this class, the embossing of the word Jif on the true Jif lemons, is far from easily legible. Is it his case that KMP is not legible or Shalimar is not legible?
No, this is right. We get your point, but here it is not a question of the shape being of a particular nature or indicative of the product.
That's
in
what
your
the case is. That's what their case is.
Yes, exactly. That is what you are saying. I mean, your submission is that it's only on surface graphics.
Let them say.
And the bottles are all generic sort of.
What would qualify as shape mark? I will just come to this.
If their bottle was shaped like a coconut and they had a trademark on that, and you also use
different. That would have been different.
That would have been different. It's all on the surface graphics. Bottles are generic, so they cannot say just because the bottle is similar, you're violating there or passing off.
I'm grateful.
Get your point. Very clear.
May I just read on, because this is some. We are here, my lord, just above line 45. We are here dealing with something extra, something added on, which may or may not present itself to the housewife as something which catches her eyes. Even it does. And there cannot, in fact, be any guarantee that a label of the type here in question will stay on the produce. If not something at the rate in case of Jif lemons. Well, the labels are not important. It might be removed, to which she has in the past been accustomed to refer when purchasing. Unless accordingly the labels were to be something utterly novel, I threw out in the course of argument the admittedly absurd suggestion that they might be a yard long. But even then, of course, there would be no guarantee that they would still be there when the item was purchased. The housewife would pay no attention thereto. Now, my lord, next, my lord, is important. Next page, my lord, because all these companies do market surveys. They based on statistics. Okay, this particular shape of the goods has caught the imagination of the people, so we should spend more on this advertising and all. My lord, all those are taken into consideration. Now, my lord will kindly see this. All this, of course, proceeds on the theory, but I have had been 350. I have had extremely impressive evidence on this matter. An item of totally independent evidence, which was proved before me, consisted of a brochure produced by ABA Associates Limited, who are specialists in packaging design and brand development. This is headed the 1 billion question. Some brands fly, some die. Brilliant question, my lord. Some brands fly, some die. Why? And on the front page of this brochure, there were, my lord, this is very important, there were displayed 5 consumer products which, with no graphics at all for this where necessary, have been totally blanked out. So if I totally blank out Shalimar or KMP, inform at glance what they are. My lord gives your lordship the examples. The Perrier water bottle is of a distinctive shape. The twisted white stripe on the Coca-Cola can will kindly take a note. But this kind of distinctive bottles, my lord, are being capable of being protected. The shape of a label stuck on a Heinz baked bean can and the Jif lemon on nature, all are shown as example of the products which identify themselves in this way. They identify because of their shape. Now, my lord, the humor added here. I regret that the 5th item shown in a packet of cigarettes, I rejoice that I am not qualified to know what it may contain.
We are not, neither you nor I are qualified to know why he was rejoicing. It's the other way around, yes.
So as a start, here is entirely independent evidence to the effect. What housewife looks for is the lemon shape and nothing else to tell her the product is Jif. But this does not stand alone. The plaintiff carried out
But
series of...
we did not.
This was
We
approved.
get the point.
This
clear.
was approved.
Yes.
This was approved by the Court of Appeal. My lord, the Court of Appeal judgment starts from page 368. Same volume. Court of Appeal approves the Chancery, and this is taken to House of Lords, my lord, which starts at page 397. All concurs with this. Now, my lord, coming back to their plaint, if they wanted, even if I assume they are entitled in passing off, because I would be candid, I have applied for shape of goods as a trademark. So at best, they can say that I am entitled to passing off. My lord will kindly take their pleading in the plaint. My lord, entire Shalimar, my lord, because the distinctiveness, my lord, because to succeed in an action of passing off, I need to prove, my lord, Lord Diplock's 5 tests of passing off, which, my lord, for a moment, your lordship will give me. This has been quoted over here. I'll just take your lordship through that. The 5 tests of passing off in warning, my lord. my lord, will kindly take, my lord, the because I have marked the entire judgment. It's the difficulty.
You have already handed over?
Hmm?
You have handed over
That very judgment itself.
Acha, this one.
One naked voter wall. Judgment আছে copy তোর কাছে my lord, also, my lord, some more important parts, my lord, if your lordship may kindly consider. I know I have, my lord, also kindly comes to page 352 once.
Page 376, the 5 tests are given.
Yes. My lord, before that, your lordship kindly comes to page 352, line number 35. My lord,
352 of the paper book?
no, 352 of that report, my lord, of that report, of that RPC.
Yes.
My lord, line number 35.
35, yes.
The fourth matter is that the crucial point of reference for a shopper who wishes to purchase a Jif Squeezy lemon is the lemon shape itself. Virtually, if no attention is paid to the label which bears a label with which that lemon bears.
Yes.
So they are only concerned with the shape. And the 5 tests, my lord, they have to pass, my lord.
Page 376, those are quoted.
Yes, my lord. 376, also at 378, my lord.
All right.
376, my lord, line after line number 50. I'm grateful to your lordship. Misrepresentation which is calculated and which they can prove only by distinctiveness they have acquired. Now, my lord, takes page 378, German and Platt versus I. Burgert. Every passing of case at common law involves 2 propositions, each of which must be established by the plaintiff before he can succeed. The first proposition, the plaintiff has a legal right in the nature of a monopoly, an exclusive right to a particular name for his goods because their name was being considered, or a particular description or a trade or a get-up. In the present case, the property, the reputation claim by the plaintiff was in respect of get-up of Louis furniture, consisting of its appearance. The second proposition is the defendant has infringed that right by selling goods under a name or trade description or with get-up which is likely to lead to confusion. It is clear from many authorities, and it has not been challenged on behalf of the plaintiffs in this appeal, that the question of confusion, the second proposition, does not arise until and unless the plaintiff has established reputation. If a reputation is not established, the question of confusion does not arise. Now, apropos this, your lordship looks at the plaintiff. Okay. Now, how to prove, my lord, your goodwill and reputation? Your lordship kindly takes the paper book, page 10. This is on entire Shalimar. Not of these bottles per se. And I have shown, my lord, they have 5 different bottles.
Mr. Bhattacharya, one other thing, whether the trade dress or the trade
But there is a difference between a
trademark includes those coconut trees and the.
My lord, there is a difference, my lord, under the definition of a trade dress or a device. Your lordship kindly takes the definition of a device, my lord, of Narayanan. What is a device? 8.06 at page 147. Now, device has a very, very narrow constricted meaning. My lord, I can hand up photocopies of this.
That will be helpful later on.
If I may. Narayanan, 6th edition. 8.06 at page 147.
That's from the bottom.
The word device, I'm sorry.
Yes, yes.
My lord, Your Lordship. Yes. The word device has various meaning. In trademark sense, device includes pictorial representation of of any object or thing. My lord, like this coconut,
Coconut trees
and all
that's what we are asking. Yes.
my lord will pictorial representation of objects like animals, birds, landscapes, buildings, and so on, individually or in combination, are commonly used as trademarks. Such devices are obviously capable of being represented graphically. Many kinds of devices may be considered prima facie capable of distinguish goods of one person from those of others if they have no direct reference to the character. I am not
So you are using a similar coconut tree and all that.
no, my lord. Now mine is completely different. My lord, I am selling coconut tree.
Coconut oil. Coconut oil.
No, not
Coconut
tree.
oil, sorry, coconut tree.
Hair oil. That too.
Hair oil, that
Very difficult
hair
to
oil.
sell.
Yes. Now,
Ghosh is a ready buyer of coconut trees. He's bought
Coconut trees.
a dozen of them lately. I know this.
What coconut trees? What are you saying, sir?
Ask him. I do not know. Coconut trees. Not
or is Santiniketan house?
Wait.
But
So
youngsters
you purchased the land. The coconut trees were on that.
No.
I
But
bought a land,
youngsters-
my lord. I planted, my lord, 15 odd coconut trees.
But youngsters are always in a hurry. But we
Cannot
always buy
qualify as a
not
youngster
the
anymore.
seed and wait for something to grow. But they can't wait for 10 years to wait, have it grow. So get something ready and
Not ready, my lord. They will come up in 5-7 years.
So information can be used later on, maybe. So many
but as long
So many opportunities are waiting.
Grateful.
going of coconut.
Either this information or the coconut trees themselves. Yes, Mr. Water. So you are using similar things?
No. My lord, his is red. His is red. Mine is KMP.
No, the pictures.
Big picture. My lord, coconut tree, it is descriptive. So far as this is concerned, it is descriptive. His entire device would mean that red thing.
We'll look into the pictures with increased alertness when we come back after the copy.
দেখ
Yes, let us see the coconut trees.
Yes. No, my lord, just first let me show theirs. This entire label taken as a whole will be considered as a device.
We hope there is no oil inside.
No.
Or it's sealed at least.
আমাদের কাছে এমপি পরিস্থিতি আছে তাহলে।
Yes. And yours?
Mine is this.
এটা এখন
Complete different colors.
this is now.
No, no. This is at the time of filing. What about Kurish? বলছি তারা এক এক করে And
One
you
is
cannot
a
dissect.
one is a larger bench, one is a division bench.
Madam,
The
this is
coconut
by
trees.
another company called Boiddobuti. Now your lordship compares it with, it is not mine. Madam, the entire reason is
This is
only to
actually
stifle, my lord.
This is actually much closer.
This is
And this will be the next defendant.
no.
You target this.
No, unless they find that he is a competitor, he can be a competitor, they are not going after them. Madam will kindly
So
take,
they will be happy that you are bringing in all the products which now they'll file suits against.
they won't, they haven't. Madam will kindly take my what
So
is-
yours is a bit different, yes.
kindly take
Subject to what they'll be saying.
can 3 of 2024, if your lordship kindly takes my application under order 21 rule, order 41 rule 27, because this is what it means.
That is not a part of the paper book, Mr.
No.
It was filed later.
It was filed. But these are documents from the trademark registries, which they themselves should have. I am showing one of them. I am not showing all of them. There are several of them. Page 22.
Can two. If I left.
But the last line, registration of this trademark shall give no right to the exclusive use of all other descriptive matters appearing on the bottle.
No, sorry, this is can 22 you said.
No, my lord, it's can 3.
Can 22, sorry, can 2 is.
Can 3,
acha,
page
can
22. Can 2. Can 2 না আমার এখানে can 3 আছে ভাই।
Can 3 হচ্ছে তোমাদের
Can 2 is the order for 27. Can 2 page 22, yes.
Yes, my lord. Does it look something like this?
Yes.
No.
This.
Can 2. We were looking at can 3.
My lord, I am looking at can 3.
You're looking at can 3.
Yes.
modification application.
Can 3 there is no page 22. It is up to page 14 or 15.
Page 22 তাহলে আমার এটা কিসের? এটা কি? Page 22 আমার এখানে লেখা আছে can 3.
This is AOAR.
What is page 22? Just show us.
Position and reply.
Just show us that.
Lord, it is like this.
Oh, no, no, no. It's completely
Additional
different.
application.
Maybe a different, we are looking at a different appeal. There are two appeals.
No.
Only one appeal, yes.
Opposition. Oh, my lord, I'm sorry. It is the
Opposition and reply.
this is the opposition and reply to my application for additional
Modification.
additional documents. Yes.
Okay. এরকম দেখে নাও compare করো এটা 22 সঙ্গে
Opposition কোথায়?
22 টা কোথায় এটা অ্যাকচুয়ালি এই মাত্র
Opposition তো নেই।
এই তো
Opposition নেই, এখানে application রয়েছে। এখানে আছে?
এইটাই
দেখো তো opposition।
এটা কোথায়? এটা
এটা page 14 page 14 of can 2.
My lord takes page 14 of can 2. Page 14 of can 2.
আচ্ছা can 2 টা ততক্ষণ দিন। Opposition গুলো, opposition reply গুলো দেখুন কোথায় আছে। এইগুলো? না, এর মধ্যে ঢুকে আছে এগুলো। এইগুলো কি? We'll look at can 2, page 14.
My lord. And I will take your lordship, I will trouble your lordship once more with the plane because of the
Yes, same. Oh,
my lord, bottom of the page, registration of this trademark shall give no right to the exclusive use of all other descriptive materials. My lord, all other descriptive. My lord, if I am selling coconut oil, coconut trees will be descriptive. If I am selling mango fruity, I will have a picture of a mango. That would be describing. My lord, if I am selling apples and I use word apple, that would be descriptive. But if I am selling phones for Apple, it is not descriptive. If that be so, they cannot even claim coconut. I am my use of the word coconut also.
In a passing of case, if it is filed by Apple, the principle of once bitten, twice shy will apply.
My lord, so it will not give him the exclusive
this
right.
is descriptive matter, you say.
Yes. So, and then coconut for coconut oil is a descriptive matter. Now, my lord will kindly come to their plaint. I will trouble your lordship once more with their plaint. The case which they have run in the plaint and what they are trying to achieve. I am selling coconut oil. I am selling hair oil. My lord will kindly see page 49, paragraph 5. If he is using edible oil, the emphasis would have been on edible oil.
Page 49
of paper book, page 1, first volume. The emphasis would have been edible oil, not to use Hema Malini and her hair, that no, this is coconut oil. They would have shown that this is a means of medium for making good prawns or some good chettinad chicken curry. Their emphasis is on edible oil, and my lord, there is a reason behind it. I will hand up the manual. For edible oil, the GST is much lesser. For hair oil, the GST is much higher. I will show your lordship the manual. My lord, I haven't been able to lay my hands on that. I will show that. But my lord will kindly come to paragraph 7 of this plaint.
Why are you stressing on edible oil? Because yours is a hair oil. That's why.
Mine is hair oil. So he himself makes the distinction. Then mine is an edible oil, his is a hair oil. The classes are completely different. The products are completely different.
As you said,
Yeah, and this is his hair oil.
as we said on the last occasion,
Yes,
that
and this is
Bengali conundrum. Hai na mathay de. So theirs is registered as a yours is registered as a hair oil.
mine is
No, Ayurvedic oil.
KMP is registered for hair oil.
You?
Yes. This KMP mark is registered for hair oil. The bottle which they are complaining of, this bottle, this is for edible oil.
Right.
And this is what he uses for hair oil.
Right.
Now, but I should be candid that I had applied for shape of goods in respect. At best, he can get passing on. Now, my lord, even then, I can get away with this action of passing off. First of all, he has not proved his distinctiveness. He has not shown what is his turnover. 65. Durga Dacha. Now, your lordship will kindly take a decision of the Supreme Court reported in 65 Supreme Court. They cannot have a case for infringement whatsoever. AIR 65 Supreme Court 980. My junior has made a compilation. My lord, may I just hand up a compilation and just. My lord, AI first is it is reported in 1964 SCC Online Supreme Court 1-4. He cannot maintain an action for infringement definitely. Durga Datta Sharma, 65 Supreme Court 980. Now, if your lordship kindly comes to paragraph 28 of that report, compilation 28, but will be at page 14 of this internal page 14, my lord.
What is the paragraph number?
28. Paragraph number is 28.
Yes.
My lord, 14 lines from the bottom.
Which one are you showing?
Durga Datta Sharma, Baba.
I don't know like you.
You do more matters. My lord, these matters. My lord,
that if they have copies, they can give us what they are citing. Because your lordship will be seeing it from a compilation, so we will have difficulty.
Lord, these matters, which are a essence of the cause of action, has your lordship found that? My lord, paragraph 28, 13 lines from the bottom.
These matters. Have you got it, Mr. Bachawat? These matters, para 28.
We are not carrying these judgments, so not.
Device?
Okay, bolchi di. Come on, ye junior ke bolo.
You have a device. It's an AIN 1965.
I know, but we are not carrying these judgments. They have not given us copies, so that's all right. Not that.
If you have the device, your tab or something.
We will. Don't worry about it.
No, we'll give you time to find that out. I mean, in the meantime.
Please carry.
I
Not,
just
we know these
of it.
Not we know these judgments.
No, but a particular portion is being relied on, sir.
Not we know this particular portion.
You obviously know this judgment.
No, everyone in this room knows it.
On that side. Yeah. On that side of the bar, everyone knows.
But I tell you, lordship, in that case, a 30-second digression. Lord, I was watching him online, and Lord, I tell you, lordship, I thought it was a marvelous bit of argument he made. Lord, I really enjoyed it, which is why I dropped other matters to listen to him in this matter. Lord.
This matter?
He's been making very educative arguments and doing a very good job of it. Lord, and it's good to see that after his illness, Lord, he can not come do matters fully, not physically, and do it in a pleasant and a good manner.
Absolutely.
Grateful.
It's felt not very good to see him not back in form and action.
These matters, has your lordship,
Yes, we have got it. Yeah.
these matters which are of the essence of the cause of action for relief on the ground of passing off, but a limited role in an action for infringement of a registered trademark by the registered proprietor who has a statutory right to that mark. He does not have a statutory right so far as the shape of goods is concerned. Has a statutory right to that mark and who has a statutory remedy for the event of another by use of that mark or a colorable imitation thereof. Whereas an action for passing off is a common law remedy, being in substance an action for deceit, that is, passing off by a person of his goods as that of another. That is not the gist of action for infringement. The action for infringement is a statutory remedy conferred on the registered proprietor. He is not a registered proprietor so far as goods, shape of goods is concerned, of a registered trademark for vindication of the exclusive right to use the trademark in relation to those goods, vide section 21. The use by the defendant of the trademark of the plaintiff is not essential in an action for passing off, but a sine qua non in the case of infringement. No doubt, where the evidence in respect of passing off consists merely of the colorable use of registered trademark, the essential features of both the actions might coincide in the sense that would be a colorable imitation of a trademark in a passing off action would also be an action in infringement of the said trademark. But the correspondence, my lord, here it is the important line. But there the correspondence between the two ceases. In an action for the defendant's mark, in an action for infringement, the plaintiff's mark must no doubt make out that the use of the defendant's mark is likely to deceive. But where the similarity between the defendant's and the plaintiff's mark is so close, either visually, phonetically, or otherwise, does that KMP and Shalimar, is it phonetically, visually, anywhere similar? So far as these devices are concerned, and the court reaches the conclusion that there is an imitation, no further evidence is required to establish the plaintiff's rights are violated. Expressed in another way, if the defendant, the fact that the data packing and other writings or marks of on the goods or on the packets in which he offers for sale shows marked difference or indicate, my lord, very important, clearly a trade origin defendant from that of the registered proprietor of the mark would be immaterial. Whereas in a case of passing off, the defendant may escape liability if he can show that the added matter is sufficient to distinguish his goods from that of the plaintiff. Now, apropos this, your lordship now considers, I indicate my source of origin, KMP. Mine is in maroon, it is nowhere red, nothing. Even so far as his device is concerned, he cannot claim an order in passing off because my added materials are sufficient to distinguish my goods and my source. Because the purpose of trademark is, my lord, is to indicate the source. And this would clearly establish my source. Now, my lord had also asked me about I had forgotten the definition of a trade dress.
Yes.
Before I had gone to this judgment, I should have dealt with that, my lord. My lord, it's in chapter 33 at page 978 of 6th edition of, my lord, kindly comes to page 8 at my lord, on the right hand side at page 979, my lord, under the heading trademarks and trade dress infringement, the emphasis and thrust of a claim of a trademark infringement is in deciding whether a discrete symbol such as words, my lord, like 777 or something like that, word, number, or picture, in fact, functions as a trademark, and whether the defendant's mark is likely to cause confusion. On the other hand, a trade dress protection is generally focused more broadly. To determine trade dress infringement, if the plaintiff has defined the trade dress as a total image, that entire Shalimar, comparison, total image, as a total image or overall impression of the plaintiff's product, package, and advertising, then it is the composite image, my lord, because now the courts have, my lord, relied on something called an anti-dissection law. It has to be taken as a whole. I compare this with this. I compare this Shalimar with this KMP.
The total impression which comes.
Yes, total impression. Corresponding image or impression of the defendant's product. If the defendant's trade dress is likely to cause confusion with the plaintiff's trademark, then a finding of unfair competition is warranted. The ultimate protection desired is prevention of likelihood of confusion of buyers. Even if the defendant has not infringed, my lord, that is not important. Then, my lord, at the bottom of that page, under the heading, totality of elements considered, a defendant cannot avoid liability for unfair competition simply by segregating out the various aspects or elements of the plaintiff's product, packaging, and labels, and claiming that no one these is protectable per se. Similarly, it is not possible for me to say, okay, this part you should disregard, the overall impression, overall. The totality of the element is an issue. The first user group, for the purpose of denoting the origin of the products, has entitled him to protection. What is to be considered is whether the defendant's trade dress bear an overall similarity to the plaintiff's trade dress. If trade dress case, the focus is on the entire looks of the product or packaging of the plaintiffs of the defendants. Well, this is the difference between a trade dress and a device.
Overall impression of plaintiff's product,
Yes,
package, and advertising.
yes, my lord.
They have run a case of trade dress violation also. I mean, passing off.
Later, the Kellogg stuff. If your lordship now takes serial number 4, it is a decision reported in 1996, 36 DRJ. It's a Delhi 636 DRJ.
This you have to give a copy to them.
Yes, my lord.
Yes, no problem.
These were all cited in the code below, my lord. Because the judgment, my lord, it's a division bench, and both of my lords made it to the Supreme Court. One of them to ICJ.
Yes.
My lord will kindly see the matter before the division bench of the Delhi High Court, paragraph 2. The appellant Kellogg's company sells cornflakes with cartons, which defines the cartons as Kellogg's cornflakes, the original and the best. The respondent is selling cornflakes using a carton more or less similar in size, but with the title Ames Aristro Cornflakes written just at the place where the appellants display the words Kellogg's Cornflakes. This is done at the left-hand top of the carton. The appellant's grievance in the suit, as well as in the IA, that the carton was likely to confuse the buyers of cornflakes, and there is every likelihood of consumers purchasing the respondent's goods in the belief that they were that of the appellants. The learned single judge, referring to the case pertaining to trade dress of the appellant, dismissed the IA, observing, if the trade dress in this case, it was found in the above case, Colgate Palmolive versus such and such, I would have had no hesitation to accept the arguments of Mr. Anand. Applying the test laid down therein, I am of the view that the trade dress of the plaintiff in this case is entirely different from the trade dress of the plaintiff, and there is absolutely no scope for any confusion. It was contended, my lord, paragraph 5. It was contended before us that the learned single judge, having accepted the legal principle relied upon the appellant in respect of trade dress, erred on the facts in holding that there was no scope of confusion amongst the consumer. It is it was pointed out that the size and shape of the carton was similar, being rectangular, that it was the flakes in the appellant's carton and ale were joined together closely, or rather touch each other. The respondents also describes his goods as original and best, and that both maintain a picture of cornflakes. My lord, as I said, my lord, coconut trees. That these are small square on left hand top where the words Kellogg's cornflakes were written inside the square, and the respondent had also put a square on the left hand top with the word Ames Aristo cornflakes. It was further stated that in all cartons Kellogg's in regard to various commodities, there was a red band. My lord, I am skipping this portion, my lord. My lord, paragraph 6. Before we go into the above aspects, it is necessary to refer to few more facts. If we look at the appellant's carton, we find that the Kellogg's is displayed very prominently in fairly big letters above the word cornflakes in square on the left hand top. Then to the right of the words Kellogg's cornflakes, there is a picture of the face of a hen up to its neck. There is a bowl containing cornflakes and a cherry therein with a big spoon. Pouring of milk is shown into the plate. On the right hand side of the carton, it is stated prominently that the flakes are 99% free. When we come to the respondent's carton, we have in the left hand top rectangle the words Ames Aristo cornflakes prominently written. We have also ISI in the smaller rectangular bracket, but shown quite prominently below the rectangle on the top left, a plate blue in color with cornflakes and cashew, etc. There is no picture of milk pouring into the plate. My lord, paragraph 32. Taking a cue from that 65 Supreme Court.
Yes.
In a result on our, because the law has been discussed, I don't want to trouble your lordship with the entire law. And those days, my lord, we did not have much of PTC cases reported. So it was all RPC. And at our junior stage, both Mr. Devnath Ghosh and I used to find understanding, because there are different RPC, the way it is written, 5 judges, 5 different portions, very confusing for juniors to understand. In the result on our prima facie conclusions, we reject the plea of similarity or likelihood of confusion. We reject the plea of fraud.
Where are you reading? Sorry, Mr.
Paragraph 32.
Yes, please continue.
In the result on our prima facie conclusion, we reject the plea of similarity or likelihood of confusion. We reject the plea of fraud as well as the one based on imperfect recollection. We are of the view prima facie that even though the getup is similar, the different name Kellogg's and Ames Aristo prominently displayed make all the difference, and this is not a fit case for interference with the order of the learned single judge. But as rightly pointed out by Miss Lala, Miss Lala, that when I send somebody or I go, I will ask for parachute oil. I'll not say, look at this bottle, look at the color combination. There are products, depending on the products, what can be the confusion? What can be the level of confusion? But for a product like this bottle, anybody, even if I send somebody to get it, I'll ask him to get Shalimar. He can never confuse it with KMP at all. Priors to was on a different point, right? My lord, there your lordship will find what a kota number. In the compilation, there is a 2017 index, 2017 SCC Online Delhi 7391. Online Delhi 7390. These are all cases of passing off because he doesn't have a case for infringement. Britannia. Both the companies were big shots, Britannia and ITC. my lord, paragraph 10. It is, I'm sorry, but
Yes.
it is evident that a passing of action has to be examined from the standpoint of three factors: goodwill and reputation, misrepresentation, possibility of deception, and likelihood of damage. We must also note that goodwill and reputation do not refer to the same thing, though there could be some degree of overlap. There may be reputation, paragraph 10. There may be a reputation, and yet there may not exist any goodwill. He has to show his goodwill through sales and everything. What he has showed is the goodwill of Shalimar. As an example, a particular mark may have reputation worldwide, but there may be no sales under that mark in a particular territory, say India. Thus, although the mark would have reputation worldwide, it would not have a goodwill attached to it in India. I'll come to the next case, which has been discussed in Toyota's Prius case by the Supreme Court. Well, for a while, the view was different. Now, the Supreme Court has changed the view. Toyota might be known worldwide, but Prius was not known in India. It might have a reputation, but it did not have any goodwill in India. It would not have a goodwill attached to it in India. It is not just the reputation, but the goodwill which constitutes property, inasmuch as it represents a link between the business and the customer. Now, paragraph 17. From the above, it is evident that in a passing off case, it is the goodwill which is sought to be misappropriated. So it was incumbent on him to show what his goodwill is, even though if I have applied for the mark as a shape of goods. It is the misappropriation which provides a cause of action at common law. That thus, before a passing off can succeed, the plaintiff must establish that a goodwill attaches to the good he supplies in the mind of purchasing public by association with the identifying get-up under which particular goods or services are offered to the public. The connection between the get-up must be such that it is recognized by the public as distinctive specifically of the plaintiff goods or services. In other words, in the facts of the present case, ITC, in order to succeed at this stage, must establish at least prima facie the combination of yellow and blue that is used in its packaging for Sunfeast Farmlight Digestive All Good Biscuit has become distinctive specifically of its goods. In other words, whenever a possible customer sees a packaging for digestive biscuits using combination and yellow and blue, it is immediately recognized as being sourced from the plaintiff and not anyone else. Then, my lord, paragraph 25. So, but similarly, when I want somebody to go and buy some ITC biscuits, I will go buy a Sunfeast ITC biscuits. The use of a trademark, whether be it a color combination, my lord, has to be kept into mind, keeping in view the products which are being purchased. 25. The appropriation of an exclusivity claimed vis-a-vis a get-up and particularly a color combination. My lord, here they are claiming monopoly over yellow. I will show from the definition, it can only be a color combination, not yellow. The appropriation of an exclusivity claimed vis-a-vis a get-up and particularly a color combination stands on a different footing from a trademark or trade name, because colors and color combinations are not inherently distinctive. It should therefore not be easy for a person to claim exclusivity over a color combination, particularly when the same has been in use only for a short while. It is only when it is established, maybe prima facie, that a color combination has become distinctive of the particular product, that an order may be made in its favor. We feel the present case is not such a. When the first element of passing off is our view is not established, we need not examine the other elements of misrepresentation and likelihood. Well, again, so many colors for same thing. And this is for their coconut oil.
These are all coconut oil. These are all coconut.
না ওটা edible oil. Now, if your lordship kindly looks at the definition of mark, it is, they cannot claim monopoly over yellow per se or green per se. The lordship will kindly see, my lord, though I will admit for a fact that in the trademark manual, they are now saying that one should now also consider a single color, like for Nivea boxes. The moment we see a blue, indigo, as a matter of fact. A cold cream box in blue, we identify it with Nivea. So there is, the trademark registry is now putting emphasis that maybe it is time to consider.
We also have to take into account the section of society who are using that product.
Yes.
That is a very important test, I suppose.
Yes. Very important.
Very important. Whether it's a sophisticated elite sort of society or general masses or somewhere in between middle classes, quote unquote.
But my lord, the difficulty is,
yes,
today with social media, and almost everybody has a smartphone, people are becoming more and more aware of this. The awareness is growing much faster than it used to earlier because of social media. No, my lord,
There's social pressure also. For no real social pressure. Suppose people who are not of that financial capability, but they're interacting with people of that class of society.
As a matter of fact,
I'll give you examples. Gym trainers, or if you're a gym trainer or somebody who works as a domestic help in the home of somebody. I mean, you constantly get exposed to products which you cannot afford to use. So there's a heavy social pressure, Mr. Bhattacharya, on these sections who are, or somebody transitioning from one financial stratum to another. There's a heavy pressure, suicides leading. There are studies on these. So anyway, that's a different topic.
My lord, as a matter of fact,
but in economics, that's a major area of economics, not this factor of seeing wanting to buy what your neighbor has.
Right. Not a peer pressure. It's something else. I mean,
but it's almost like an envy or a jealousy, which is inbuilt into human beings. Our brains are programmed.
That's built into the selfish gene concept of Dawkins. I mean,
but there's a whole branch of economics on this, and advertising is also based on this.
Yes, totally based on that.
But your lordship will remember one classic advertisement, as he points out, when we were younger. I don't know whether the brand is there, Onida.
Yes, Onida. Yes. Now whether yes, that Satan was, I mean,
that's
really
that's right.
Very cute Satan.
So, my lord, as a matter of fact, I was watching some article. Palki Sharma, who was the journalist, the famous journalist. So she was explaining that we Indians have stopped savings that much as we used to do earlier. Rather, our expenses are diverted towards such products, electronic products, expensive cosmetics, and all that.
Right. Consumer items.
Not consumer items in the sense of 10 years ago. Today,
no, not utility items. I mean,
not for example.
Conspicuous consumption also.
Social media will not talk about narkel tail. No lady will be now want to seen dead with their hair well oiled.
No, nor would any man, and particularly people who are balding like me. I mean, it's reducing. So
that is
I won't be like to be looked at with coconut oil in my hair.
But that's when one uses it most, though, I thought. But I have a skin problem, so I have to use it.
Yes.
Well, just one thing I wanted to check. Yes,
homemade marriage.
We should.
Yes, Mr. Bhattacharya, you gradually try to wrap up now.
Yes.
Because other matters are held up for this matter.
But I will deal with their judgments. I think this would be enough.
Yes. Yes.
But you don't want to distinguish. But only other judgment, my lord. Skyline Education 2010, 2 SCC 142. Supreme Court.
Mr. Bhattacharya, you have marked only those judgments which you formally cited in this compilation.
Yes, my lord, this is the only other judgment which I want to cite, my lord. Excellent, excellent, my lord. Paragraph 24, a little journey into the backdrop of the case shows that the only ground on which the appellant sought temporary injunction, the respondent was using Skyline is a specific distinct word, and being a prior user, it was entitled to seek a restraint against the respondent from using the word in the name of Institute of Engineering and Technology. The learned single judge, after examining the rival before him, recorded a well-reasoned finding and finding that the appellant has failed to make out a prima facie case. The learned judge opined Skyline is generic word because the same is used by thousands of persons and institute. This bottles is being used as a part of their trading name or business. The learned single judge noted that the plaintiff is neither AICT such and such, but they are also not. Then paragraph 26, in our opinions, the findings recorded by the learned single judge and the division bench are crucial factors like prima facie case, balance of convenience and equity are based on a correct and balanced consideration of various facets of the case, and it is not possible to find any fault with the conclusions recorded by them. That it is not a fit case for restraining the respondents from using right in the name. It has not been disputed on behalf of the appellant that the word Skyline is being used as trade name by various companies, organizations concerned, and also for describing different types of institute. There are voluminous records produced by different respondents before this court shows as many as 117 companies, including computers such and such, are operating by using the name. So it is held that it is common to trade, because my lord, I have shown that there are so many other manufacturers who are using this bottle, my lord. And I have shown, my lord, the case which they have pleaded is with regard to edible oil, nothing to show their sales figure with regard to this particular shape of bottle or this device or anything. In any event, his device and my device are completely different. For the time being, my lord, I wanted to distinguish two of their judgments. I am sure they will cite it, but okay, let
not cite any judgment at all. Lord, I'll give you a lordship a quick overview before I get into dealing with my learned friend's arguments. Let me have the bottles.
Right.
And Lord, if I could request your lordship's officers to have can number 3 ready, Lord, because that is the one by which he wanted to change his labels. He size it down. Because টিপি ফেলে দিয়েছো আচ্ছা আমাদের ফ্যান থ্রিটা একটু দেখুন এখানে আছে ফ্যান টুটা আমার কাছে আছে ছিল একটু আগে তোমাদের বোতলটা একটু নিচ্ছি হ্যাঁ দাও এসে আমাদের বোতল আমাদের কাছে আছে আর কি আছে একবার দেখবো
আচ্ছা এটা খুব ইম্পর্টেন্ট কেন আগে এটাও ছিল ব্লুটাও আছে
হ্যাঁ ঠিক আছে রাখো না কোনটা কারেন্ট আমার দুটো
Yes, sir.
Now, before I take your lordship into that, now, my lord, before my lord, we get into any papers, my lord, let us look at what we are dealing with. Lord, the order in this case is a order restraining passing off. There is no order as far as infringement is concerned. There is no appeal by me on that. So, my lord, infringement is a purely academic, my lord, question. My learned friend had spent the whole day, last day, only dealing with infringement, Trademark Act, etc. None of which will be relevant, not because your lordship remembers, and I'll show the portion. The Trademark Act itself says that common law rights are preserved and not affected by the Act. And it is well settled that the Act has no relevance, not in the case of an action of passing off. Number one. So, my lord, all the registration certificates he has taken pains to distinguish, the disclaimers, all of that not pale into complete insignificance. They have no relevance at all. So, my lord, while it was nice hearing the arguments, it may have been important in an action for infringement, some other matter. Here we are, my lord, restricted to passing off. The question before your lordships, therefore, my lord, if I may put it very briefly, is has there been or is there any likelihood of one product being passed off as the other? Now, my lord, the test, as your lordships know, is not, my lord, to look at the two bottles side by side, no side-by-side test, no searching examination, no looking for what are the differences.
Recall value, comparison.
Recall value.
Yes.
Now, my lord, one looks at two containers. Not here in this case, I've got not separate size containers, but assuming that they are similar size.
Yes.
Not because everyone has containers, not with the same now statutory sizes or liters or whatever. Now, the question is, my lord, would anyone looking at this think that this is coming from the same source? This is the test. Now, color of the label, the contents of the label, this ribbed design on both. Overall impression, my learned friend has showed all those judgments, I'll rely on it. But the test is not to take the parts and say this is different, that is different. You look at the composite whole. Now, as a composite whole, my lord, what is the first impression? This is the question which your lordships have to address. Now, my lord, in this background, please remember two things. Now, my lord, I have a yellow, he makes a yellow. He could have made it any other color. He could have adopted any other color combination. He did not. Similarly, I have a green. But here, a green tag to the. Now, I have a green.
But soon the other competitors will be out of color.
And I'll address that issue.
There are only three basic colors and various combinations.
I'll address that issue. It's not even of relevance. I'll tell your lordship why. But my learned friend has been caught, let us say, using something which has been held to be an infringement of my design, of my blood product.
Yes.
It is not infringing my rights. By that, I don't mean infringement in terms of trademark or infringing my rights. He has been restrained. Now, he says, I want to change. Now, please remember, this is what that application is about. Now, what does he want to change? Not the color, not the shape of the bottle, nothing. Nothing. This is the question before your lordship. So, my lord, he admits there's a possibility of not passing off, therefore he wants to change. Now, my lord, in this context, please see what he wanted to do. Not please take his scan. But very clever use, I must say, but now, my lord, he says, page 7, page 7, this is the restrained one. Right? So, this is the one which was restrained. Now, the colors in mine are faded. They don't reflect the correct color, but be that as it may, my lord, skip that. Now, my lord, please turn to page 11.
That is what they now want to use.
They now want to use. Now, my lord, would this in any way, my lord, represent what his product is going to look once he puts it on this same bottle? What is the difference? None. If he retains the bottle. Now, my lord, please see. To compare, not this C with D without saying that, look, I intend to use the bottle. I may have agreed, I may not have, it's a different thing. But when we point out, look, why this fascination for this rib design, which no one else has? Why this? Not the intention which flows from there is only one thing. He wants to ride piggyback on this. Very clear. Because not, please go back to page 11. If this container be wrapped around this bottle, will it change anything? So, this is what he wants to do. He puts this and he gave it to the court to say, look, from this to this. Now, changing this sticker will not change the overall impression.
The identification in the public mind, Mr. Bachawat, with your brand is not linked with the ribbed shape of the bottle.
We'll come to that. We'll come
that
to
also you have to say, because otherwise,
I
if
will.
one says Shalimar coconut oil, say,
absolutely,
one does not think about a ribbed bottle connecting
Very
it
good.
to.
I'll deal with that. But I'll come to that. But there was one basic fallacy in his argument. I'll come to that. But all I'm showing is, so now, this is one case he made. Number two, he says that, look, you have got different bottles. Please take page 14.
Yes.
Now, please, see what this is. Shalimar's enriched
coconut hair oil.
So these are scented hair oils. These are not pure coconut oil. These are scented and we have variants. Your Lordship knows, people have an appeal for those scented hair oils. So your Lordship will find jasmine, this, that, and the other.
But this is in the same league as their product. They are selling hair oil specific.
No.
And this is also hair oil.
This is enriched. This is not pure coconut oil. Enriched.
But the other one is edible oil. So if one associates hair oil, it will be a comparison between this and their.
Now, so it shows that my learned friend, when I said he had done an extremely good job, he has. He has tried to draw a distinction between.
He doesn't know whether it's a compliment or a.
No, it is. It is. I tell you a lot.
An abuse.
No, it is. But I tell you a lot. So with colleagues, there's no.
There's no doubt that he does a good job. But
back.
Whether in this case,
come when we are in the bar library, not in court. If there's a compliment, there is one. If there is no compliment, I'll also say that. So, no backhanded compliments here.
No.
But what I'm on is this.
Yes.
He has managed to successfully draw a distinction between edible hair oil and hair
not
oil.
edible hair oil.
It is edible coconut oil.
Edible hair oil would be horrible.
No, there is
edible
no
oil and edible hair oil.
Not coconut oil. All coconut oil, if it's not mixed with something else, is edible. There is.
I would never take the risk.
Now the scam is this. The scam is this. He claims to be. Bolo, hair oil to.
No. Yes, he
hair oil.
Hair
oil. Right. Now,
So I hope you don't show a practical example by applying that. And
now, please come back to my bottle now. Now, please.
So the way you are threatening, it looks very, menacing. You'll use the hair oil on him and you're saying it's hair oil, then will.
Now, please have a look at this. Now,
at the end of the day, we'll be utterly confused of what out here. Yes. So this is Shalimar coconut oil, right?
Does it say anywhere that it's for use on hair only?
No.
Doesn't.
Right.
So, this can be used both for hair and for cooking. But any pure coconut oil can be used for both purposes. Number one. It can be used for both purposes. Is there something saying that one can't put this on the head? We'd all be bald by now. Because Shalimar has been selling it like this. It's a pure oil, number one. Number two, so much of halla about the difference. Has your Lordship been told what his sales are? 98% of what he sells is not hair oil, but edible oil. Why? As my learned friend said, he will show the difference in GST. It enables him to do a scam. And please also think, Lord, if he is right, Lord, this hair oil, if my consumer, Lord, ends up using it for cooking, what will happen?
So, but that the consumer should have been.
No, but he is drawing such a distinction that these are different products. He
No,
kept saying different
His
products.
label
different
says
products.
it's a hair oil.
It says so. It says so. But please not.
Your label does not. So you run the risk. It may be used for both
I
purposes.
run the. Mine can be used for both. But I have
Can
no
be actually
problems. I have no problems. I say so.
All right.
I say so. But his.
So you have classified in the trademark registration. Your
His labeling is right.
Achha.
His cannot be used for cooking. Should not.
Yes.
If there's confusion, and people end up using it for cooking. Now, the fact of the matter is, although he's run this case on this not huge, high, immense platform of not the difference between edible and hair oil, the fact is 98% of his sales are edible oil.
But have you got a
I'll show
sample
you.
of his edible oil bottle?
No, there is no difference. Now, yes, I'm coming to it. Now,
I'm sorry.
Now-
Here
now-
I need to make
now-
an
now-
interruption.
now-
My lord, to make it edible, you need to have a FSI registration. Your lordship will kindly see. FSI registration.
Correct.
Without a FSI registration, it can't be used as an edible oil.
So, who's
So
is not? I'm not.
No.
His is an edible
Yes.
coconut oil.
Correct.
Mine is a hair
Exactly
coconut
the
oil.
point I'm making. He does not have.
So without a FSI certification, it cannot be used. No, may not be, Mr. Bhattacharya, because people always don't
Look
distinguish.
for it.
I'll give you an example, particularly whey protein shakes for gym people. Without a FSI certification, so many products are selling like hotcake.
That's a violation, my lord. Serious violation.
Maybe.
Serious
It's a violation. You run a risk when you use it, but it goes on. So you cannot distinguish on that line only, that it requires a registration.
But I'll show that.
No,
GST
let
purpose.
me take his argument. It
As I
requires a
showed in the
registration.
plain, he has used it as a
But
hair oil.
if he's not
All right.
registered, how is his not 98% of
No,
his?
Mr. Bachchan takes away the premise of your arguments by cutting off the registration factor.
I'll show that.
That is the stratagem of Mr.
No,
Bachchan.
let us also look at.
Because it's a passing of action, he says it's in common law, so this
They have
registration.
not run passing of action before the learned trial court.
I welcome the interruption. If he does not have FFSAI registration, then how is 98% of his sale edible oil? How?
Have you disclosed that some
Yes.
materials are
Now-
produced in the code?
Yes, my lord. Now, please take my opposition to this application. To can 3.
Yes.
যাচ্ছি দাঁড়াও না যাচ্ছি আগে not number 1 now my lord number 2 before that my lord before I go to that please also take a few things take my opposition my lord. Now my lord the impression in his application is that this is his only product therefore his business is stopped.
Can see the opposition টা can আছে ওখানে আপনার ওটাই না অবশ্য ঠিক আছে বাড়িতে এই দশা হয় আমার ছড়িয়ে কাজ করতে গেলে না
My lord, it's an affidavit of affirmed by
it's not
No.
very thin.
my lord
Not
very
very
thin very thin very thin
So this
Very
can 2 opposition probably ওটা
no can 3
ওটা না এটা রিপ্লাই এটাও রিপ্লাই affidavit in reply there's an affidavit
7th
in
of September copy আছে দাও না copy দাও না দুটো
no this is the reply
আরেকটা দাও না নেই আমারটা
Ramesh Agarwal signs it
কার কাছে যদি থাকে
আমার কাছে আছে
no আমাদের দুজনের কাছে নেই কিন্তু ওটা আপনার কাছে যেটা হচ্ছে ওটা রিপ্লাই
not Mr. Somnath Banerjee
no it's we don't find it
but I'll
was
hand
it
up.
filed actually filed
Yes
check up just
There's
sometimes
been serious arguments on this earlier so this can was heard for
this was before Justice
Mukherjee
এই যে আমার কাছে আছে।
Justice Mukherjee. I'll just give your lordship 2 copies for the time being.
copy color.
Amata colored.
We don't find,
Dekhi.
yes, can two opposition we can find, but and reply.
But if your lordship will
This
do
is
only with only 1 copy for the time being,
that we can make do with, but
তাহলে আমি আছে তো বাস ঠিক আছে বার কর
এখানে
your lordship will
দুজনের কাছেই নেই, দুজনের কাছেই নেই। It was filed in the department or in court?
yes.
No, court in or department.
But we've made arguments based on this earlier. I know this for a fact.
That was looked into.
My lord.
The judge looked into this.
Yes. But your lordship will forgive the markings on my.
No, that's not. Anyway,
but there are 2 copies. Not, I'll just do it from the soft copy. Now, my lord, if your lordship, so my lord, first thing that they say is they don't have any other product, so their business is gone. I'll show that from his application. Now, my lord, please come to first. Page 16. Oh, my lord, please come to, these are clearer. Lord, please come to page 4 of the affidavit.
Page 4 of the
affidavit.
Affidavit, yes.
Page 4. Now look at the number of KMP products he has. Now, my lord, your lordship will be surprised. Please see those bottles once. Just not keep it in your mind. And my lord, then come to my lord, page 5, where there's a little enlargement. Now, my lord, come straight away to page 6. Each of these is a copy of some other manufacturer. Now, please see, my lord. KMP, Thanda Tel, Navratna. But why choose the color of a big rival always? Style of bottles, style of writing. Not, please see blue bottle copied from Parachute. But it's incredible. A habitual copier. Habitual. Please see, my lord, all of them. And my lord, see as also, my lord, at page 8. Habitual. So, my lord, intention is clear, at least. Let me ride on someone else's coattail. Intention is all I'm showing your lordship from here. Now, my lord, the advertisements I've taken out and these are next. That one. Okay. Now, my lord, please come to please come to page 1920, which is his balance sheet. And please come to page 21, or rather page 22. But please come to page 21. This is from his balance sheet.
Yes.
And my lord, if your lordship sees, Lord, right at the bottom of the page, principal business activities of the company, number 5, name and description of main products and services. Now, my lord, please turn the page. 2 things over there: refined edible oil. On the right hand side, 98.8%. Herbal products, which is talking about hair oil, body oil, 1.2%. And your lordship will see the percentage of that goes down in the next year. So your lordship,
why was Mr. Bhattacharya showing the hair oil bottles only? You harped on hair oil.
I have edible oil business. That's why my name is Edible Oil and Company. I import palm oil from abroad.
But Mr. Bhattacharya, then you also use these bottles for your edible oil product.
No. Hair oil is different. Edible oil.
You are harping on the hair oil, but what about the edible oil bottles?
Those are not edible oil in bottles.
Where is he saying so?
You don't sell edible oil in bottle at all. In bottles at all.
Where
can it be
case?
edible oil not in bottles?
Case?
It has to be in bottles. How can you sell edible oil in box?
Those are in pouch. I will get those.
Only pouch, no bottle.
Pouch, tin, pouch and tin. I'll get those. I'll get those. Those are nothing to do with this products.
Where is the pleading? Where is the pleading? This new case before the trial court, before the division bench?
And where is the case paid out?
It's all right. It's all right.
Where is the case paid out?
Mr. Bhattacharya, let me now finish. I had not interrupted you.
Yes.
It is given last.
You complete your discussions during the recess. We'll come back after recess and continue.
But, is it possible that I do it tomorrow? I have a matter fixed.
Tomorrow, because we take
Or
up this assignment.
Day after.
The assignment is only on Tuesdays, Mr.
Oh, I
So he has to go to
Go to
5th
Tuesday.
of August because we are not there for 2 weeks. Jalpaiguri bench.
Oh, not. I thought your lordship would go to Andaman, coconut hair oil territory, do some research and come back.
Right.
Not in
But
fact,
this will be Jalpaiguri.
in fact, not this argument produced quite a bit of laugh because the learned judges tried to persuade him that look, Mr. Bhattacharya, you don't use coconut oil. Otherwise, you would know in South they use it both on the hair and to eat.
This is not a
I know Kerala they use
hair oil.
Yes. No, coconut oil for as a food preparation.
Yes.
We generally use soshetil.
No, but the entire southern part of India that's rampantly used.
Yes.
Awful.
No, awful, but it's now being hyped as a very good fat.
Milord, in fact, they say you should take a teaspoon.
Yes, teaspoon in the morning, right? In empty stomach. Things are changing.
All these coconut oils might not have chemicals. Take
Oh,
yes.
At least mine.
Lord, Lord, nowadays one finds all kinds of labels saying cold pressed, organic, cold pressed.
Don't take the risk of filing a pill. Oh no, now it's before a different bench. Now you can file a pill on.
But I'm going
Should we continue on 5th of August then?
If it's possible, not if it's possible.
Possible for us, we have no difficulty.
Not, as long as your lordship
Whatever
no
they say.
difficulty, not otherwise I
In any event, it won't be over probably today also. So then we'll keep it on hard in part. Let the matter be listed next on August 5, 2025 for further hearing. There is no direction from the Supreme Court or anything in this matter.
no,
So then it will be difficult. We have to give reasons for this.
And my lord, would it be your lordship's pleasure to fix a time, my lord? If it's
Time it's very difficult because it's because you are regularly being assigned with.
Can it appear fairly at the top, my lord?
No, the whatever matters are appearing, they will not lose their chronology. So you've already probably heard a matter today. One matter we have already heard. So this will more or less retain its position. Should.
I shouldn't take very long, not because it's now a question of not going to the law. Facts I'll take 5-10 minutes, and then the law, not an hour.
The difficulty lies in the recapitulation. Sir.
Otherwise, not coconut hair oil. Not your lordship will not
Recapitulation will
forget.
argue the entire thing again.
But coconut hair oil, your lordship will not forget.
তাহলে
Hair oil versus edible oil.
এটা বাকি সঙ্গে দিয়ে একসঙ্গে করে থ্যাংক ইউ
Well, this was the matter where your lordship was pleased to give us liberty to correct the memorandum of appeal and the direction to the department.
Classification? Oh, that.
Yeah,
Right,
that criminal. I think the
Yes.
my instructions are that the defects have been cured and it has now been numbered as
CRA.
PRA.
Right.
Criminal appeal.
এই বইটার মধ্যে আছে কি ফুড সাপ্লাই
Well, we've got two books for your lordship.
then yes.
Prevention of Food Adulteration Act of 1954. The appeal provision 71(6).
Yes.
Well, this is a statutory appeal under the act itself.
This is Food Safety and Standards Act.
Yes, well, they are together. The both acts are usually together. The Food Safety and Standard Act 2006 and the Prevention of Food Adulteration 54.
Prevention of food adulteration is not there in this probably. In this book, is it there? Only food safety. Standards Act and the rules are there. And the FSSAI rules are there. Prevention Act is not there.
আমাদের তো 54 Act.
If you have one extra copy, that would do.
You have the wrong book with you.
Because I can find out from this.
Yeah, FSSAI.
Yeah.
হ্যাঁ
Why would I have the
ছোট
wrong
হয়ে
book?
যাবে মোবাইলে তাহলে দেখবেন
Does your lordship have the 2006 Act, my lord?
Yes, 2006 Act is
Yes, yes.
that would do.
Yeah, that will do. That will do.
আচ্ছা আচ্ছা
But this is a statutory appeal under section 71(6) of the 2001 Act, a 2006 Act. My lord, we are aggrieved by an order passed by the tribunal, the appellate tribunal.
Right.
The appellate tribunal is constituted under the Act under section 70. May I briefly tell your lordship the facts? Look, this relates to
Yes.
a rice bran oil which is manufactured by the petitioner company. Rice bran oil.
Right.
Now, my lord, there was a inspection, sampling was taken and an inspection was done by the food analyst. The food analyst took samples, examined it. Well, thereafter, my lord, he prepared a report. My lord, as per the report of the food analyst, he found the samples to be substandard and misbranded.
All right. Misbranded means branded under some other category.
No, my lord, misbranded to the sense, my lord, there is a labeling which is made, which contains certain declarations that we make that this has a high, like as your lordship is aware, my lord, this has a high smoke point. Rice bran oil has a high smoke point. It is rich in nutrients. It is antioxidants. It is anti-inflammatory,
you are guilty of
anti-diabetic.
Omission or wrong information?
Wrong information according. So it is classified as misbranded. There's a definition of misbranding under the Act itself.
All right.
So he says it is misbranding. And to the extent that we can classify a particular product, that is also provided in an act, well, which is the, what is the name of that act? Advertising Act. Well, that is provided in the order itself. Now, well, at this stage, what happened is that based on the report, well, a show cause notice came to be issued to us. We responded to the show cause notice. And under the Act, well, there is an adjudicating officer. Now, well, the adjudicating officer's order, I first wish to draw your lordship's attention to. Well, the adjudicating officer's order is at page 60. Well, of the stay application. Before that, well,
You are aggrieved by orders passed under which section? Section 51 and 52?
68.
Section 68.
68. Now, against the adjudicating authority's order, a part of the order, we went in appeal before the appellate tribunal. So the appellate tribunal confirmed the, well, two aspects was there in the adjudicating authority. He held that the misbranding was incorrect. He held misbranding in my favor. He said that the branding was correct.
But substandard he held against you.
Yes. He said that the report based on substandard, he said that is correct. It is in fact substandard because the acidity content was more according to him. So he fined us under the Act. So
the fining is under which provision?
my lord, that 52, 51 and 52. 51 is substandard, 52 is misbranding. So I was fined under 51.
51. Right.
Now,
yes. And
again-
68 is under that provision, the appellate authority passes the order.
No, then it goes up before the appellate
68
authority.
is the parent order, the
Correct.
first forum.
Absolutely, my lord. No, 51, 52 is the parent order.
The 68 is the appellate authority.
68 is the appellate forum.
Right.
So when we go before the appellate forum, we were aggrieved only by to the extent by which
Substandard.
substandard. My lord, before the appellate forum,
Yes.
and my lord, we could have paid that fine and that could have come to an end. But in appeal, we carried it so far as according to us, it was not substandard. In appeal, he confirmed substandard and he held the misbranding against me, where there was no cross objection or appeal by the department.
No, the first authority let you free on misbranding.
Yes, he held that there has been no misbranding, and the recommendation of misbranding made by the food analyst is incorrect.
So, food analyst first gives the report.
Right.
Adjudicating officer is the first forum as such. Adjudicating officer let you free on misbranding, but substandard was held.
Yes.
And the appellate authority castigates you on both.
Yes.
Substandard
Now,
affirmed.
I go in appeal. So
in your appeal, misbranding was
correct. My appeal was confined to only substandard.
Yes, yes.
Instead of my lord examining substandard, he takes into consideration the entire order of the adjudicating authority, and he holds misbranding against me as well. Which my lord, he could not have put me in a position worse than where I was before
He
I
doesn't
filed the
have
appeal.
something like order for 2 and rule 33.
Without cross objection or an appeal, he could not have held it in my favor. Well, that is the part of the appeal. Before that, my lord, I need to tell you, lordship, my lord, there is a time period prescribed under the Act for filing an appeal.
60 days.
60 plus 60.
Oh.
So we are within that plus 60. So we have filed an application seeking condonation of delay.
What is the reason given there?
My lord, that would be Can 1.
But for that, we have to hear the other side also.
Yes, my lord. The other side was here on the last
They have
occasion.
been served and all.
Yes, yes, of course. They were here. When your lordship passed the previous day's order.
If they choose not to remain present, then what can? Yes, FSSI. What is the ground taken in your?
My lord, if your lordship will kindly take paragraph 22 onwards.
Studying the order and giving it.
Well, in fact, technically from para 20, page 9. Well, order was dated 5th of April 2024. We received certified copy on 9th April. And thereafter, my lord, we had 60 days time. The person who was actually acquainted with the facts, he was not available, which is para 22. Thereafter, my lord, when we prepared the appeal, then we went to the department. This issue of, my lord, what kind of appeal it would be, my lord, that took some more time. Then eventually
we are allowing this application, then taking up the appeal on.
Very well.
Can 1 of 2024 is an application for condonation of delay in preferring the present appeal under section 71 within bracket 6 of the Food Safety and Standards Act, 2006 within bracket for short the 2006 Act. Next para. Learned senior counsel appearing for the appellant by placing reliance on the averments made in the application, submits that the delay was occasioned for reasons beyond the control of the appellant. First, the authorized signatory of the appellant, who was well acquainted with the facts of the case and was in charge of drafting the appeal, was not available due to some personal difficulty for a certain period of time. Subsequently, difficulties cropped up since the filing department of this court was itself in some doubt as to what heading the appeal would be classified under. Next para, we find substance in the said contention, since the matter initially came up before this court with a report of the stamp reporter in with regard to the correct classification, and this court had to ascertain as to what would be the correct category, comma, since no specific classification has been allocated for appeals under the 2006 Act. Full stop, next para. Hence, comma, we find sufficient cause for the delay in preferring the appeal. Full stop, accordingly, can 1 of 2024 is allowed, thereby condoning the delay in preferring CRA ja number hoyeche ekhon, CRA within bracket DB 268 of 2025. Full stop, the appeal, comma, being both on facts and law, is required to be heard on merits and on the grounds taken in the memorandum of appeal, and accordingly is admitted and shall be heard on such grounds. There are certain other defects you have cured, most probably.
Lord, that presiding officer's name.
That you have put in. We also find that the other defects pointed out by the stamp reporter have in the meantime been cured by the appellant. Push up. Yes. But then should you give another notice for hearing?
Very well.
Because final hearing, is there any scope of any interim order?
Yes, my lord. Now I'll tell you, Lordship.
Yes, then satisfy as prima facie. Yes.
Misbranding. I am only on misbranding. My lord, the rest is, my lord, so far as that is on a particular sample fine.
Misbranding, you say that there was no appeal by you on that, no cross appeal by them.
And it was held in my favor. I'll show your Lordship only that portion of the order.
So appellate authority took it up on its own?
On its own. I'll show you, Lordship, my lord, the relevant portion. My lord, kindly take page 61.
60, yes.
60. That is the adjudicating
Authority's order. Yes.
And kindly come to page 62. The order starts at page 60.
You want last paragraph.
28th of March 2023.
Yes.
Now, my lord, kindly take page 62.
Yes.
Now, my lord, towards the middle, there is a paragraph starting, my lord, whereas a corrigendum. The one immediately, the paragraph after.
Yes, where is the corrigendum?
The paragraph after that.
Yes.
Whereas the case under reference is examined by the undersigned and is of the opinion that the claim printed on the product label reduced bad cholesterol and increases good cholesterol is in accordance with Schedule 11A of FSS Advertising and Claims Regulations 2018 and not misleading the consumers. Hence, charges against Adani Wilmar Limited, which is the petitioner before your Lordship, under Section 52 of the Food Safety and Standards Act 2006 is dropped.
But the substandard part still remains.
Remains.
So you...
I have been fined for substandard under another section itself.
So that fine will remain, and you want to stay on the...
On the misbranding means what? I cannot sell. That branding is, my lord, for all times to come.
But substandard is also that.
No, but the substandard is on a sample. On a particular sample. That's why I have been fined. But that substandard is in rem.
All right. So
misbranding
you are expecting, if today we pass an order ex parte, you are expecting an order staying that
only that portion.
Misbrand.
Yes. Only the misbranding portion.
Let us see that how the appellate.
No, my lord, kindly take the impugned order.
We have to pay the fine. On substandard, we'll have to pay the fine.
My lord, kindly take
4 lakh.
impugned order 21.
Added to the litigation cost. Yes.
My lord?
No, it's between us. Mr. Bose, we told you, they're bothered with your concession on the not a concession.
Yes, of course. Yes.
We'll come to that later.
Yes.
Let us first see the misbranding.
Yes. My lord, kindly come to misbranding. My lord, the operative portion of the misbranding, the reasoning of the appellate tribunal's order starts at page 24. Well, so far as misbranding is concerned, my lord, kindly come to page 28.
Where does the order start? The
It
first
starts at 21.
Yes. And we will come to page.
Decision with reason starts at page 24. The misbranding, my lord, aspect has been considered at paragraph 28. Now, my lord, before that, my lord, may I just trouble your lordship with one paragraph? Kindly take page 26 once.
Yes.
Kindly take page 26 once.
Yes.
The second paragraph. Learned advocate for the respondent. So the department was the respondent before the first appellate tribunal. Has submitted that after submission of the report by the food analyst, the food analyst issued one corrigendum dated 10th of March 2023. Now, my lord, may I just indicate, I should have indicated to your lordship, this corrigendum issue came, the report said that the analysis has been based on mustard oil. This is a rice bran oil. So we took the point that the very premise of the report is erroneous, because you have arrived at conclusions of misbranding. I stand corrected, my lord. Substandard based on the parameters of mustard oil and not rice bran oil. So, my lord, the adjudicating authority appears had sought for a clarification from the food analyst, and the food analyst has given a corrigendum, which is reference of which is there at page 26. This is that corrigendum.
She says that it was on the standards of
No, he says it was a typographical mistake. Instead of rice bran oil, he has written mustard oil. I wish it could be as simple as that. The entire, the premise of the report, the entire basis of the report.
You did not file any objection to the report. That is also stated somewhere in the.
Yes, it is. It is. My lord, there is a provision in the act itself where I have a right to challenge the report. Section 5. I did not. I took this point in the reply to the show cause notice. And we made a representation also for the samples to be sent to the, my lord, there's a laboratory called the food analyst at the NF laboratory, NABL accredited laboratory. So there is a provision under the regulation, the act and the regulation, that the adjudicating authority has, my lord, sufficient authority to send the sample for further analysis and then come to a conclusion. And he ought to have done it. This is our contention, because the report itself proceeded on the basis as if it was mustard oil. So if only because of that, instead of seeking for just a corrigendum, of which of course we had no notice, he ought to have sent the samples to the accredited laboratory for further analysis, which he did not. This would be all, my lord, confined to substandard. Now, my lord, here it says
another sample from the same batch has turned out perfect.
Okay.
Accredited lab 89.
Now, my lord, kindly take one corrigendum dated 10th of March 2023 and corrected the said name of the sample.
Which page?
My lord, page 26. I was reading that paragraph.
There itself.
That para itself, where I stopped at corrigendum.
Dated and corrected the name of the
because
sample.
I gave you lordship the background of the corrigendum issue.
Under which provision the adjudicating authority can send it to an enable accredited laboratory?
Could have. He did not.
No, could have. Under which provision? Is there any provision?
Yes, there is a regulation. Give me that regulation under which, well, possibly it is 2.4.3 and 2. I'll show you, lordship. Well, since I was addressing your lordship on,
anyway, let us
on that misbranding part.
So should we go to misbranding first, then come?
Here, my lord, why I'll tell you, lordship, the misbranding could not have been done. That's what I want to show. Thereafter, he proceeds, and corrected the same name. Then she has further submitted that as per the report of the food analyst, the product of the appellant appears to be substandard and misbranded, and considering as well as relying on the said report, the learned adjudicating authority officer passed the impugned order, which is legal and valid. So the adjudicating authority's order, according to the department, is legal and valid. So if it is legal and valid, then the misbranding part has gone. So they support the adjudicating authority's order. Now, my lord, kindly come to the misbranding part, which is at page 28.
2.4.3. So show him page 89. Correct.
Now, my lord, here he starts at the second paragraph at page 28. On the basis of the unchallenged report submitted by the FA, adjudicating officer passed the
Sorry,
impugned.
this is page 28.
28. Second
On the
paragraph
basis,
of
yes,
page
second-
28.
second
Second
paragraph,
paragraph.
right. Yes.
On the basis of the unchallenged report submitted by the food analyst, the learned adjudicating officer passed the impugned order and held that the product of the appellant is substandard, but ruled out the allegation of misbranding. Then, my lord, I have gone through the impugned order. Thereafter, my lord, I'll take your lordship to the next paragraph. Therefore, my lord, kindly see, allow me to place this once again. I have gone through the impugned order and found therefrom that no plausible and logical explanation has been given by the learned adjudicating authority for ruling out the allegations of misbranding. My lord, pausing here for a moment, your lordship, I've shown your lordship. He has said the branding as per the regulations. So that itself is sufficient reasons for ruling out misbranding. Thereafter, he proceeds, therefore, on the basis of the report submitted by the food analyst, I am of the view that the appellant committed the offense under 51 and 52. Well, one is for misbranding, the other is for substandard, 51 and 52. Of the opinion shows that the sample does not conform to the such and such regulation, such and such. Thereafter, as it shows acid value more than the prescribed limit, this is substandard. It has been further opined by the food analyst that the sample not labeled as per regulation 2.2.2.1 of such and such regulation. Therefore, the food analyst opined that the sample is substandard under such and such and misbranded under such and such. On the basis of the above facts and circumstances, which led me to suggest that the products of the appellant substandard and is, and what is that word? And misbranded.
And is misbranded.
And is misbranded. So, and he holds that committed offense under 51 and 52.
So, but he completely overlooks the adjudicating authority's finding on it. Directly goes down to the food analyst report.
And my lord, the adjudicating authority, if your lordship looks at the
Categorical finding that it is in
Absolutely.
terms of that regulation.
and that is the prescribed rules, and it is been produced.
Page 62.
The page 62 top, he sets out the relevant rule.
No, these are your claims.
No, at page 62,
Oh,
the
following
adjudicating authority,
these are acha.
why before coming to the conclusion that there has been no misbranding, he quotes the relevant rule. And he says that under the advertising claims regulations 2018, what we have said is permissible. That reduces bad cholesterol and increases good cholesterol. Well, which is the problem of every single, almost every single individual in this country over the age of 40.
Right.
It's rice bran.
Very good.
So the whole object is rice bran oil. The very object of rice bran oil is this. High smoke point, antioxidant. And
What about this substandard? What was the appellate authority?
Substandard, he just affirms the order of the food analyst.
He says that elaborately that you did not challenge its uncontroverted.
Yeah, I did. I did not challenge.
The
Does not.
46.5 and all.
No, I did not challenge it, but this issue was taken up before the adjudicating authority. Now, at the final hearing, I have to satisfy your lordship that the adjudicating authority went wrong. There was another analysis which was made of the same sample. There were four samples are taken. So one sample he tests. The rule regulation provide the one sample, he sends it to the department, one sample. So the one of the four samples, one tested, one out of the other four was sent for analysis. And the report from that analysis were in order. Parameters were in order. So he could, what we say is that he could not have, well, come to a conclusive finding just based on the food analysis or the analyst's report without calling for a further report or having that same sample re-examined or the other samples taken at the time of inspection. He could not have come to such a conclusion and imposed fine on me. But so far as the misbranding is concerned, my lord, that is the immediate concern for which, my lord, we are seeking for an interim order so far as the misbranding held by the appellate tribunal.
Heard learned senior counsel appearing for the appellant, full stop. For the present, comma, learned senior counsel confines his arguments to the aspect of
Misbranding.
double inverted in the misbranding. Full stop. The short backdrop of the case is that there was an inspection of certain samples of the product rice bran oil sold by the appellant company by the food analyst under the 2006 Act. Full stop. The report of the said analyst indicated that the sample tested as substandard and misbranded. Substandard and misbranded single inverted মধ্যে দুটোই আলাদা করে। Full stop. Next para. The said report came up before the adjudicating officer who held that the sample suffered from being substandard, comma, although the food analyst's report marking the sample as misbranded was set aside. Full stop. Next para. However, comma, the appellate authority, comma, in an appeal preferred by the present appellant against the portion of the adjudicating officer's order whereby the sample of the appellant was termed to be substandard, comma, extended beyond its jurisdiction, and apart from affirming the portion of the adjudicating officer's order whereby the sample was held to be substandard, comma, also entered into the question as to whether there was misbranding and held and upset the finding of the adjudicating officer by reversing the same and holding that the sample was misbranded as well. Full stop. Next para. The first ground on which the appellate authority's order is challenged is that the appellate authority acted beyond its jurisdiction in taking up the issue of misbranding afresh, comma, in the absence of any challenge to the said portion of the adjudicating officers being thrown by the respondent authorities. Full stop. The appellant's appeal was confined only to the misbranding, to the substandard labeling of the sample and not on the misbranding aspect of it. Full stop. Learned senior counsel also points out from the order of the from the recording in the impugned judgment itself that the respondent authorities appeared and submitted that they relied on the order of the learned adjudicating officer, and according to the authorities, respondent authorities, comma, the said order was legal and valid. Full stop. Thus, comma, it is argued, comma, the legality and validity of the adjudicating officer's order in respect of the sample of the appellant being branded as, labeled as misbranded was also confirmed by the respondents themselves. Full stop. Next para. Upon hearing learned counsel for the appellant, senior counsel for the appellant, comma, we find that there is substance in such contention of the appellant. Full stop. First, comma, no appeal was preferred by the respondent authorities against the finding of the adjudicating officer that the sample of the appellant was misbranded, and the appellate authority acted prima facie beyond its jurisdiction in suo motu taking up the said aspect and reversing the finding of the adjudicating officer. Secondly, comma, the respondent authorities themselves had supported the order of the adjudicating officer in an unqualified manner, comma, thereby making it clear that they did not assail the misbranding aspect of the matter. Thirdly, comma, we find from the order of the appellate authority that prior to reversing the adjudicating officer's order on finding on the aspect of misbranding, comma, the reason therefore ascribed by the adjudicating officer were not even adverted to by the appellate authority. The appellate authority, comma, surprisingly, comma, went directly to the report of the food analyst and without an independent assessment, comma, reversed the finding of the appellate adjudicating authority on the count of misbranding. Next para. Accordingly, there shall be a stay of operation of the impugned judgment dated April 5, 2024, passed by the presiding officer, comma, West Bengal Food Safety Appellate Tribunal, insofar as the appellate authority held that the appellant's product is the appellant is guilty of misbranding its product within the contemplation of Section 52 of the 2006 Act, comma, till disposal of the application. Full stop. It is made clear that this court, that the other aspect of the matter regarding substandard is left open for being finally decided at the hearing of the appeal. Full stop. Next para. Is there any other document which is relevant? The other documents you have to also prepare an informal paper book.
Well, all documents are on record.
Order annexed here. Is there anything else? Report annexed here.
The stay petition, yes.
Yes, all of them.
What is not? What? Everything is there.
Well, if there is anything which is missing, we'll annex it in the informal paper.
Very well. We fix the appeal itself for hearing on August 12, 2025, when it will be listed under the same heading. First up, next for hearing along with the application on the next date, that is August 12, 2025. First up, next para. In view of all the relevant, substantially all the relevant papers being annexed to the connected application, as well as the memorandum of appeal, comma, the requirement of preparation of paper books is dispensed with. Full stop. Since the respondent has already entered appearance in the appeal, comma, formal notice of appeal on the respondent is also dispensed with. Full stop. The appeal is stated to be ready as regards hearing and shall be heard on the papers already on record. Full stop. In the event any other relevant document has been omitted to be placed before this court, comma, the parties will be at liberty to circulate the said paper, copies of the said papers to the other side and rely on the same at the time of final hearing of the appeal. The learned advocate on record for the appellant shall give a tender a server copy of this order on the learned advocate on record for the respondent, comma, indicating the returnable date as well, and file a receipt on the returnable date. Yes, what is the difficulty?
My lord, I was suggesting to my learned friend, my lord, so far as the substandard is concerned, my lord, there is only a fine which has been imposed of 4 lakh. So if we deposit the 4 lakh, your lordship can stay the entirety of the order, subject to the result of the appeal, of course.
No, the deposit is the order. It's a penalty.
Yes. So that's what I'm saying.
If you deposit it, where is the question of stay?
No, I deposit in court subject to the result of the appeal. Depositing, if I deposit the penalty, then to the department, then I accept the order.
Actor line add kore the penalty as directed.
Lordship can give us the liberty in the event I deposit.
We'll say without prejudice. The appellant shall pay the. It is to be paid or deposited as per the order.
Penalties to be paid. Penalties to be paid, but this we can deposit.
Order.
My lord, the operative portion of the order is at page 29. That 4 lakh is imposed. So for substandard. So what I was respectfully submitting is that if I deposit the 4 lakh in court, subject to the result of the appeal, if I succeed, because there is the consequence in
We'll
the,
have to attribute reasons for that also, Mr.
no, because my reason is
you confined your prayer to the.
no, if your lordship, then your lordship will keep that issue open, because my reason
We
is
have
page
already kept
89.
it open. We have already kept it open, and we'll just say something on the deposit part. Let us just see. The
Very well, let it, your lordship leaves it open, then we'll decide it at the final hearing.
no, we'll also say that you'll deposit the fine, but that will be without prejudice to your rights in the appeal. Should you say that? Nothing. Leave
The
it.
lordship leaves it. We'll decide.
Huh? Liberty is given to the learned advocate on record for the appellant to incorporate the reclassification of the appeal in the memorandum of appeal as well as the captions of the connected applications. That's why it's not showing in the list. FAT numbers, just CRA numbers, put the CRA numbers. During the course of the day, do it.
We'll do it. We'll do it in the course of the day.
আরেকটা লাইন অ্যাড করে দাও, প্রথমেই করে দাও, can one of such and such is treated to be on the days list. এটা
So section 5 was, my lord, the delay condonation application was can 1. That your lordship has
যেটা বললাম
disposed it of.
অনিন্দিতাকে বলে দাও। ওটার জন্য আসতে পারে না অনিন্দিতা, ওটার জন্য হতে পারে না, তাহলে অন্য ক্যানটাও তো আসছে না। Are treated to be on the days list.
Your lordship were looking at the papers from the stay application itself.
Not appearing in the list, they are saying.
Oh, I see.
That's why treated to be on the days list. এটা ওর মধ্যে ঢুকে যাবে।
Applied written objection to section 8, it is joined to injunction.
এটা ওদের বই, এটা আনিয়ে রাখতে হবে, ফেরত দিতে। উনি রয়েছেন, ওনাকে ফেরত। Yes.
This is my appeal from a composite order. My application under section 8 of the Arbitration Act has been rejected. Their injunction application thereafter taken up for hearing, and my lord, injunction has been made.
One appeal cannot be filed again.
There are 2 appeals, my lord.
Oh.
On the last occasion.
That's the same question.
Yes.
And it's for section 8?
Yes. But item 10, your lordship will take up first because that is the appeal from the section 8. And item 9, I have only filed the memorandum of appeal. Because the order is a common order. My lord, all the pleadings are part of the
Absolutely.
stay petition, my lord, in this. And my learned friend has also given me a copy of the written objection file.
You had cited 2 judgments on the last occasion.
Well, this was before the other division bench, my lord, where the question of admission of the appeal arose under the appellate side rules. My lord. That issue is now over, my lord.
Yes.
My lord, if your lordship takes the plaint, it is a very, well, the plaint which has been filed, my lord, I'll tell your lordship very briefly. I am the Jila Purishad. I have given this space on license to the plaintiff to run a diagnostic center from medical center. on the terms and conditions contained in the agreement. My simple case is there has been breach. I have terminated the agreement. I have thereafter held an auction.
You say it was a license.
It was a lease.
Lease, can you terminate like that?
No, my lord, it is
the contract itself
provides for termination on account of breach. But it is, though my lord, it says it is a lease, but it is in effect a license. Yeah, I will go into the agreement, my lord.
Is a public premises unauthorized eviction of unauthorized eviction act that is not attracted?
I will say that, my lord, because here I have not filed any suit.
Acha.
I have simply terminated it. He has filed this suit
Challenging the termination.
and praying for declaration that it is subsisting.
It's a determinable contract.
Yes.
Acha.
Now, my lord, my point is this.
Now here we are bothered with
Section 8 first.
Section 8 first, yes.
This agreement contains an arbitration agreement.
So let us see that what is your argument on that.
And so therefore I say that it should be referred to arbitration.
That was rejected in your case.
Yes, that was rejected.
Let us see that.
And my lord, they say
yes,
that there is a defendant number 2 whom they have implemented. Therefore, it cannot go to arbitration. Who is that defendant? Now, my point here is, my lord, it is the subject matter of the suit which has to be considered. Whether the entire subject matter is covered by the scope of the arbitration agreement. If your lordship sees the reliefs which have been claimed and the subject matter of the plaint, it is in effect relating to the termination and the relationship between the plaintiff and the Jila Parishad arising out of that lease agreement or license agreement, whatever we may call it. So the entire subject matter is actually covered by the arbitration clause in the lease agreement. Well, if your lordship sees the arbitration clause,
was 28.
no, before that prayer in the plaint, my lord.
Plaint starts as 25. but
Who is defendant number 2, by the way?
They all
Who are they?
They are
defendant number 3.
defendant number 3, not 2. 1 and 2 is the lessee or licensee.
In the plaint, there are only 2 defendants.
Plaintiff 2.
Page 28.
One second. I'll plaintiff number 1, my lord, is the lessee or licensee. If your lordship sees the plaint, page 27.
Yes.
Asia Healthcare, that is my learned friend's client, and number 2, both of whom are the lessee, director of the plaintiff number 1.
Director.
Yes.
Yes. The lease was given to 1.
1. Yes.
Now Murshidabad is you.
Yes.
Leela Hospitals, who are they?
They are, my lord, I say they are alter ego of the plaintiff number 1.
How do they implement that?
They say that this is the new auction
Purchaser.
Lessee, auction lessee.
Auction lessee.
After termination, I have floated a new auction. I have selected the defendant number 2, but I cannot give him because he is in possession. Now, my lord, kindly see the structure of the plaint. What is the prayer which has been made in the plaint? Kindly come to page 49. Prayer A. Decree be passed declaring the deed of agreement executed on 9th June 2004 and subsequent agreement 3rd March between plaintiff and defendant number 1 are still subsisting. Principal relief. For a decree passed declaring that plaintiff number 1 is still the lessee in respect of suit property on the basis of subsisting lease agreement executed between plaintiff number 1 and defendant number 1. So, when A and B fully covered by the arbitration clause. Decree for permanent injunction be passed restraining the defendants, their main agents, from creating any disturbance to the peaceful possession of the plaintiffs over the suit property.
But Mr. Shane, the subsequent lessee, their cause of action is also against them, and they have stepped into.
They have acquired no right because I do not have any agreement with them. They are simply a successful party in an auction who has acquired no interest until and unless an agreement is executed. Now, if your lordship sees the plaint, what is the cause of action in the plaint? Kindly come to Malad.
Yes, that we are seeing. Everywhere they have alleged that you will take forcible possession and hand over to defendants.
And before I can take forcible possession, They are asking for a principal relief of declaration.
That is it. So you,
If the principal relief is not decided,
no, if the reliefs cannot be segregated, Mr.
here, my lord, I say, my lord, principal.
Then there cannot be a partial section 8.
No, I say, my lord, the consequential relief will depend upon that principal relief. Today, my lord, the principal relief and the issue will be.
But if the consequential relief affects one of the defendants who was not a signatory to the arbitration agreement.
But may I say this, my lord? Consequential relief, first the principal relief has to be granted. The consequential relief will depend upon the principal relief.
True.
That principal relief.
Suppose principal relief is granted, consequentially the other relief is granted, which directly affects a third party. Then injunction will be given to the defendant number 2 also, not to disturb his possession.
But then, my lord, the
defendant number 2 is affected, not a party to the arbitral agreement.
Now that is the question, my lord. That is the question which falls for determination.
But we also find from the way in which the cause of action has been couched that it's not actually against the defendant number 2.
There is no.
Defendant number 1 will take forcible possession and give it to defendant number 2.
That
we
is why,
find that in 3 places we have seen.
That is what I want to show your lordship, my lord. That whether in view of the averments in the plaint, whether the defendant number 2 is a necessary party or has been joined to overcome the arbitration clause.
Right.
That is the point, my lord.
Para 21 and
My lord, if your lordship kindly comes to this paragraph of the plaint, my lord, kindly see. Paragraph 25.
21 or update concern. Defendant number 12. 21 and 25. These are the solitary paragraph which deals with.
Paragraph 21, my lord, kindly see.
(20)
21, my lord.
21, yes.
After receiving the reply, but if I may just place a paragraph before that also, otherwise the context may not be understood, my lord. Kindly come to paragraph 19 at page 41.
Yes.
That by a memo dated 25th January 2024, defendant number 1 through its officer informed the director of the plaintiff number 1 alleging inter alia that plaintiff have violated some basic clauses of the agreement regarding lease amount which they have to pay to the defendant number 1. It was informed to the director of plaintiff number 1 as per agreement, no monthly statement has been furnished by the plaintiff to the defendant number 1 after September 2022. Audited account has been furnished by the plaintiff up to financial year 21-22. It was also claimed that despite receiving communication dated 27 September 23, plaintiffs did not pay the shortfall amount of rupees 292.25 lakhs to the defendant number 1. Accordingly, defendant number 1 directed the director of plaintiff number 1 to pay such amount. In response to the letter dated 25th January, plaintiff number 1 informed the concerned officer of defendant number 1 that plaintiffs have already submitted their reply to the memo dated 27 September. It was pointed out by the plaintiff that allegations made by the baseless. Audit accounts prepared by chartered account were uploaded. Till date, no objection was raised. Stand taken by the plaintiffs while replying the memo dated 27 September had in fact been reiterated by the plaintiffs in their letter dated 30th January given in response to the letter dated 25th January. After receiving the reply on 30th of January 2024, defendant number 1 issued one notice on 30th was January 2024 inviting e-auction for Rabindranath Tagore Diagnostic Medical Care Center, which the plaintiff is now running. Plaintiffs have invested huge amount for development of the hospital. They are working within the lease period. In terms of the notice dated such and such, plaintiff number 1 participated in the bidding procedure and after technical bid, plaintiff number 1 became the sole bidder. Seeing the name of the plaintiff number 1, concerned authority cancelled the process. Subsequently, on 29th February, another NIT was issued by reducing the base rate with sole intention to give benefit to. Ultimately, defendant number 1 has not followed their own agreement, issued one after another NIT with sole intention to defraud the plaintiff number 1. Subsequently, on the basis of NIT issued by defendant number 1, several entities participated and after successful bidding, work order has been issued in favor of Leela Hospital Private Limited, defendant number 2. As on date, plaintiff has been running the diagnostic center, though work order has been issued by defendant number 1 in favor of defendant number 2. This is the first place where defendant number 2 comes. All of a sudden, plaintiffs received a notice from certificate officer.
Proceeding.
There was a certificate proceeding initiated that they had challenged by way of writ petition. I had claimed the amount. That was due to some procedural irregularity. That demand was quashed. So, I am not placing this here. Kindly come to
Has expired even otherwise.
22 and 23. This deals with that writ petition which they had filed. 24 also deals with that.
25.
Ultimately, kindly come to 25, para 25 at page 45. On the basis of the lease deed dated 9th July 2004 and subsequent agreement dated 3rd March 2005, plaintiff number 1 is in exclusive possession of the diagnostic center under name and style of blank. Plaintiff number 1 has been paying electricity bill for running the same. Plaintiff number 1 also bank account interest from the various tax invoice issued by say it would be evident that even as on 30th of May, plaintiff number 1 has been running its business as various medical equipments and other equipments were purchased by the plaintiff number 1 for running the medical center. The not be allowed to make profit by dispossessing the plaintiff number 1 from the said medical center.
So this is important. Tenure has expired
The
now.
tenure of the lease is yet to expire. Now it has expired. And till date, no proceeding has been initiated by defendant number 1 for evicting the plaintiff number 1. Simply by issuing work order in favor of defendant number 2, the defendant number 1 cannot evict the plaintiffs from the said medical center.
This is all. Nothing more about it.
Thereafter, your lordship is seat 27. Towards 5 lines from the top, there is no dispute that plaintiff number 1 is in possession of the property in question. Defendant number 1 and its officers cannot take law in their own hands to dispossess the plaintiffs from such and such. So, allegation of dispossession against defendant number 1. By letter dated such and such, defendant number 1 illegally terminated the lease agreement. So, again, my lord, direct dispute arising out of the lease agreement and subsequent supplementary agreement for breach of material contractual terms, defendant number 1 through its officer directed the plaintiff number 1 to hand over peaceful possession even after purported termination of the agreement and subsequent supplementary agreement. The
Para 28 and 29 they say one cannot dispossess plaintiff number 1 and give possession to defendant number 2.
Yes. So, my lord, the cause of action and my lord, subject matter which I am harping on, kindly see paragraph 33 also, cause of action. On 9th June, when we entered into a lease agreement,
32.
Then, my lord, cause of action arose on 28th September, requested the plaintiff number 1 to provide bank details, could refund. Cause of action on 13th June, issued a letter of acceptance for temporary lease rent for civil. Cause of action lastly 18th June, when local police representative verbally asked the plaintiff to vacate the suit property. Cause of action such and such. Now, your lordship will kindly see the arbitration agreement.
Page 88 is the agreement.
The agreement is at page
88, sir.
88.
Clause 28.
Relevant clause is at clause
Page
28.
number 96. Page 96.
Copy টা
আমি better confidence.
তো কপিটা পড়া যাচ্ছে না।
Absolutely illegible.
Yes, absolutely illegible.
Absolutely illegible.
কোনো কপি আছে?
Should not have been accepted by the department.
টাইপ কপি একটা দেন কেন?
সে accept করলে কি করে ডিপার্টমেন্ট আমি জানি না।
I thought your lordship's copy is all right. Should be all right. Exactly. তাহলে কি করবে?
তাহলে better type copy দিয়ে দেন এটা।
কোথাও সেট আউট করা নেই ক্লজটা?
Very well, we'll read somehow.
Very well, but I'll show your lordship from the section 8 application.
Relevant clauses, my lord, your lordship will get it at page 30. Page 30 of the application.
An application copy.
Some of the relevant clauses, my lord,
And I can,
set out.
there is a typed copy as
not type data. This is the copy. छोटी तो लोग partition. It's better.
somewhat better copy is there in an injunction application which was filed.
No, you have only one copy.
One copy.
But para 4, as Mr.
Yes,
Tiwari
page-
points out,
Page 4, para 4.
yes,
rel-
para 4 contains all the sets
all-
out all the right.
yes.
Thank you, thank you, thank you. You're right.
Stay petition.
No, the plaint itself
Sorry.
is 30. We come to page 30,
yes.
para 4 of the
Yes.
plaint.
Yes, sir.
Para 4 of
Yes,
your
yes,
plaint
I will.
sets out all the relevant. At least 28 is there.
May I come to 28 directly?
Let us do that.
Yes. In case of any dispute or difference arising between the parties herein or regarding validity and or interpretation of the agreement, the matter shall be referred for arbitration of a sole arbitrator to the district magistrate Murshidabad. Question is, what is the subject matter of the arbitration agreement? It concerns validity and interpretation. Here, my lord, they are questioning my termination of that agreement. Based on the termination, they are seeking the declaration they are entitled to continue in possession. So, my lord, the entire subject matter is covered by the arbitration agreement. So, my lord, if this is the subject matter and based on the pleading in the plaint, Lordship will kindly consider whether the defendant number 2 becomes a necessary party for the purpose of granting the reliefs claimed for adjudication of the issues involved, or it is just to say that there is an additional party who is not a signatory to the arbitration agreement, therefore the arbitration agreement cannot be made binding.
Only thing, Mr. Sen, the defendant number 2, you have already issued a work order in favor of defendant number 2. There is no doubt defendant number 2 would be affected by the outcome of the suit. Maybe collaterally, maybe consequentially, but will be affected because if it is declared that his lease is continuing and the termination is bad, then the tender is vitiated and defendant number 2 goes.
To that extent, my lord, my submission will
Could
be
the suit have been filed without the defendant number 2? It would be bad for non-joinder.
no, my lord, defendant number 2 at the most could be, I would say, my lord, he has not acquired any right in the property. He has got
Work order, you have issued
he has
work order.
got a work order. He can only
He can sue you for that if he is successful in a tender.
yes.
Work order is issued. You have to, then he can sue you for that.
Then, my lord,
Even before a writ court.
Lord, probably, my lord, that is a cause of action which the defendant number 2 may have
Against you.
against me.
But that is what we are saying,
But
that
today,
it gives him a right, an actionable claim.
but if your lordship is
Present right, if you say yes, but the way the suit is couched, if this relief is granted, defendant number 2's rights on the basis of the tender will just be effaced, obliterated. So it is an affected party, definitely.
my lord, it is not a necessary party. Because, my lord, kindly see
Rights won't be affected.
But kindly see to this extent. First is here, what would be the issue in the suit? Whether
Principal relief, only issue probably would be, not only issue, primary issue entirely revolving within the contemplation of the arbitration clause. No doubt on that.
yes,
Cannot be any doubt on that. Even they say that you will take possession and give it to defendant number 2.
so
Agreed.
they have not even pleaded a cause of action against the defendant number 2. That is what I want to say.
They have stated that work order, have 2 places they have stated work order. You have
What has been issued. But insofar as their right is concerned, in the suit is concerned,
all right.
they are not saying why will they add a defendant number 2 as a party? Because if something is going to happen at the instance of defendant number 2 which will affect their right, then only I will make that person a party. So the consideration with the greatest of respect will not be for the plaintiff that the right will be affected. Your lordship maybe is thinking of that on a wider scale. But I say defendant number 2 has been implemented to avoid the applicability of the arbitration clause. And that is what, my lord, lordship can take into account is a relevant consideration post amendment section 8. That aspect has now come. that even a non-signatory party,
Arbitration and Non-Conciliation Act, 96.
the basic purpose under the amendment is, strictly speaking, even if I am not a party to the arbitration agreement, I can still be made bound by the arbitration agreement. So that is the purpose. Well, if your lordship sees, what is the most important requirement now, my lord? 8.1, if your lordship sees, a judicial authority before which an action is brought in a matter which is the subject matter of an arbitration agreement. That means, well, if I may just pause here for a moment, the action which is pending before the civil court must be the subject of an arbitration agreement. That is the principal criteria. Shall, if a party to the arbitration of agreement or any person claiming through or under him so applies not later than the date of submitting his first statement on the substance of the dispute, then notwithstanding any judgment, decree or order of the Supreme Court or any court, refer the parties to arbitration unless it finds that prima facie no valid arbitration agreement exists. Fetter is, the court has to come to a conclusion prima facie that there is an arbitration agreement. And the second important requirement is the subject matter of the suit has to be covered by the arbitration agreement. These are the two main requirements. If a party to the arbitration agreement or any so applies, so who can apply? Either a direct party to an arbitration agreement or his successor. Here, my lord, plaintiff is admittedly a party to the arbitration agreement. Plaintiff cannot come to the court and say that you cannot refer the matter to arbitration. Plaintiff has to speak for himself. Plaintiff has to show that the subject matter is not covered. Plaintiff has to show prima facie there is no arbitration agreement. Only if the plaintiff says that I am not a party to the arbitration agreement, I cannot be referred to arbitration. Plaintiff cannot, so plaintiff's objections are very limited within the scope of the Section 8 amendment. He cannot espouse the cause of a third party. He can only say, look here, the subject matter is such that it is not covered. For that, I say, your lordship has himself found from the pleadings in the plain, there is no pleading which takes the subject matter out of the scope of the arbitration agreement. The objection regarding defendant number 2, if it is not bound, whether it is bound or not, that with the greatest of respect, it is not for the plaintiff to say. Plaintiff's objections will be limited to subject matter not covered.
Then if it is sent to arbitration, defendant number 2 also, as per the present frame of the suit, has to go to arbitration.
But he is defendant number 2 is an alter ego of the plaintiff.
Why do you say that?
Because the common directors.
That does not mean it's a separate juristic entity. It participated and you have recognized it to be a different.
Very well, Manoj. Even if the suit goes to arbitration.
If it was an alter ego, then don't terminate their contract. Give it to the alter ego.
No, but I have a serious grievance.
You cannot recognize them being an alter ego.
No, I have
They are a successful bidder in your tender.
Yes. Well, I have a serious grievance against the plaintiff. So, my lord, I cannot give it to the plaintiff. Now, question is, my lord, if the suit goes to arbitration.
What will happen then?
Yes. If the suit goes to arbitration.
Cannot be segregated against the
Lord, I tell your lordship, if they continue in possession, even if the arbitration proceeds, I cannot evict them otherwise than by due process of law and give.
Can they have a decree of injunction against the defendant number 2 from the arbitrator?
They have not prayed for that.
Permanent injunction they have prayed from the defendants.
That is first dependent upon the declaration. The declaration can be granted irrespective of the presence of the defendant.
You have to see it either way, Mr. Shen, whether it is granted or not.
Yes.
If the declaration is granted, we have to proceed on that premise also.
Yes.
You have to see take the entire picture. If it is granted, then permanent injunction may be granted by the court or authority, court or arbitrator. If their first relief is granted, termination set aside.
But they have, if I may come back to the prayers once, my lord.
Yes, please see the prayers. If the declaration is granted and a decree declaring that the deed of agreement executed such and such is subsisting,
Page 49.
then court may obviously give a permanent injunction against all the defendants, including you and two, because two will have two claims right through you to the property.
The permanent injunction has to be against me.
They have claimed against defendant number 2 also. And number 2 has accrued some rights.
Then
Have
I can
and
say
no cause of action has been disclosed against 2 is a different thing.
very well. I make this argument, my lord.
And that is the worst point, your worst point. All other points are in your favor apparently.
Defendant number 2, if it has acquired any right in the property, it is an acquisition of right through me.
We were thinking in that line also.
If it acquires a right through me,
we were thinking in
then
that line
defendant number 2 is bound by the arbitration agreement.
This is the argument we were expecting because
because of
the language of 8.1,
yes,
it's a converse.
Yes.
Application can be made by a party or somebody claiming through it. But by virtue of that, Section 8 recognizes the right of a party through right of someone, a claimant through a party.
Your lordship will get that in the definition of party.
Party is party to the
arbitration
agreement. Only that.
Yes.
We have
but Section
party,
8.
In other matters, we have sought help from party, but we did not get. Because in these matters, people do avoid arbitration by virtue of adding parties.
Defendant number 2's right is accruing in the property at present through work order. He has no independent right. But if he gets a right, if he claims a right, his right is through me. So he is even bound. If I am bound by the arbitration agreement, he is bound by the arbitration agreement as well. But this is one that I just show your lordship one
statement.
One judgment. Now, two grounds have been taken in the objection to Section 8. I don't think the first objection will be very seriously pressed. Arbitration clause is ineffective and redundant. The arbitration clause is ineffective and redundant because the DM is the arbitrator. That I say, that is with regard to the appointment mechanism. Arbitration agreement is not obliterated. Arbitration agreement continues to be valid. It is an arbitration agreement within the meaning of Section 7.
Intention to go to arbitration is clear.
There. The appointment procedure is not in terms of the present law. That, the parties will have to approach the court for appointment of arbitrator. That I am not. Second point is, Section 8 to be filed before filing first statement on the substance of the dispute. Here, they say that I have filed a written objection to the injunction application, and therefore
you filed your written statement.
Written objection to the injunction application.
That is not.
That is not the first statement. That
not first statement on substance.
On the substance of the dispute, exactly, my lord.
66 judgment.
Your lordships have also held, but there is a Supreme Court judgment, my lord, quite old judgment of the 2006-7 SCC. That my lord, filing a reply to an injunction application is not.
That is why the legislature uses the expression on the substance of
the dispute.
There is a purpose behind that.
Yes, that is the second point. Third point is, my lord, non-compliance of Section 8, subsection 2.
You did not file the copy.
But the copy has been filed by way of Filisti, certified copy. But even otherwise,
list of documents.
Kindly see, this is the agreement which has been relied upon in the plaint. If the plaintiff has relied upon this agreement, and
it is state in your application that it's not with you.
No, my lord, I did not.
Proviso is there. It is not available with you, then.
The Supreme Court judgment held paragraph.
But kindly see.
Not invoke the proviso if you did not say that in your.
85. Page 85.
Otherwise, we have to file it in original or a duly certified copy.
ওদের লিস্ট অফ ডকুমেন্ট আর আমরা ওই জাজমেন্টটা দেখাবো জেরক্স কপি থাকতে হবে
But I have filed a Xerox certified copy.
সার্টিফাইড টু বি ট্রু
Certified to be the true copy.
আনরেজিস্টার্ড ডকুমেন্ট ছিল
It's an unregistered
Who
document.
certified it?
My officer. That is the certificate because the original document is not there. The officer has certified it to be a true copy. But even otherwise, my lord, I will be relying upon one judgment where this objection was taken. There, this was held that if the plaintiff has relied upon the same document in the plaint and the injunction application, and the plaintiff does not say that the document which I have annexed to my Section 8 application is different from the agreement which he has relied upon, then, my lord, it is the plaintiff cannot take this objection that this Section 8 has not been complied with.
then it is xerox copies on record it same judgment রেফার করেছে
সিরিজটি দিয়ে ফাইল করেছিলাম সেটা কোথায় আছে?
ওটা আসবে যে অবজেকশনের পর আমরা দেখেছি তো এই প্যারাগ্রাফটা
My lord, kindly take this judgment, my lord,
2017
17 5 SCC, you know, 185. This will address both my points regarding non-party as well as the non-compliance of 8.2.
এটা কি দেখাচ্ছে? এখানে চিঠি দেখাচ্ছিল একটা আমাদের
এটা দেখবেন স্যার হ্যাঁ স্যার প্যারা
নিজে পড়ছিল
11.1
নাকি?
সেকশন প্যারা 16 অতুল সিং ডিসকাস করেছে প্যারা 17 এ ভারত সেবাশ্রম
Sorry, yes. Which paragraph?
Kindly come to
11.2
paragraph 11.2 where the questions have been framed.
Yes.
11.1, whether non-filing of either original or certified copy of the retirement deed and partnership deed along with IA number such and such entail dismissal of the application as
11.2 is also applicable.
Yes, both these points are covered by this judgment, my lord. Now kindly come to, my lord, section 14 has been quoted,
প্যারা 16
kindly come to paragraph 16.
আমার अगेंस्टे যাচ্ছে তাহলে ওটা ডিসকাস হচ্ছে দেখুন
The learned counsel for the appellants also placed reliance on judgment of this court in Atul Singh versus Sunil Singh. In this case, defendant moved the petition praying for referring dispute. Trial court dismissed the petition on ground that predecessor interest of the plaintiff was not party to the partnership deed executed on such and such. Hence, the main relief being declaration of the deed to be void, which could have been granted only by civil court. The dispute could not be referred. Defendant filed civil revision, which was allowed. One of the submission before this court was that as per subsection 2, application could not have been entertained unless it was accompanied by original arbitration agreement or duly certified. Court held that there is no whisper in the petition that original or duly certified copy has been filed. There was non-compliance with 8.2. Hence, the reference could not have been made. Then, my lord, kindly see after the quoted part, it is relevant to note that in Atul Singh case, submission of the respondent was noticed that copy of partnership deed was on the record of the case, but the court has not proceeded to examine as to when such copies are already on record, what is its effect. In this context, reference is made to judgment of this court in Bharat Seva Sansthan versus UP Electronics. In the above case, two-judge bench of this court has held that photocopies of lease agreement could be taken on record under Section 8 for ascertaining the existence of arbitration clause. The response, paragraph 24, quoted, respondent corporation placed on record of the trial court photocopies of arbitration agreements along with an application under 8.1. High Court, in our view, has rightly held that photocopies of the lease agreement could be taken on record under Section 8 of the Arbitration Act for ascertaining the existence of arbitration clause. Disputes raised by appellants, Sansthan of internal content is arbitrable.
প্যারা 19 অতুল
Kindly come to paragraph 19. In Atul Singh's case, which was also a judgment of two-judge bench, earlier judgment in Bharat Seva Sansthan was not cited. However, for the purposes of this case, we need not enter into the issue as to whether there is compliance with 8.2 if photocopies of the arbitration agreement are already on record and not disputed by the parties.
প্যারা 22 26 on the point of entertainment প্যারা 27 এ চলে আসে
Kindly come to paragraph 27.
27 20 and 29 এগুলো হচ্ছে পয়েন্ট অফ what means entertainment
in fact 28, my lord. Section 8(2) has to be interpreted to mean that the court shall not consider any application filed by the party under 8(1) unless it is accompanied by the original arbitration agreement or duly certified copy thereof. Filing of the application without such original or certified copy, but bringing original arbitration agreement on record at the time when the court is considering an application shall not entail rejection of the application under 8(2). In the present case, it is relevant to note that retirement deed and partnership deed have also been relied upon by the plaintiffs. Hence, the argument of the plaintiff that the defendant's application IA number 4 was not accompanied by the original deeds and hence liable to be rejected cannot be accepted.
This rate with Thara Shevasra.
So this is the first point. Lease agreement is on record in the plaint.
They're
And
relying on that. It's
they're
there.
relying on
Basis
that.
of their.
Yes. So my lord, next issue is, my lord, regard to the party, non-signatory party. Kindly come to, my lord, paragraph 30. Relevant facts and pleadings of the parties have been marshaled by the trial court and returned the finding that plaintiff number 1, represented by his mother and next friend for party to the retirement deed, mother of the plaintiff, namely such and such, has signed the retirement deed for self and on behalf of her minor children, plaintiff number 1, 2, and 3, claiming their rights to one of the partners, Gangadhar Bhakta, their father, who was party to the retirement deed. Then, my lord.
Para 32 is pat on the point.
Yes. That is the one. Plaintiffs admittedly are parties to the arbitration agreement. As noted above, it does not lie in their mouth to contend that since one of the defendants whom they have improved was not party, no reference can be made to the arbitrator. In the facts of the present case, it cannot be said that merely because one of the defendants, that is defendant number 6, was not party, the dispute within the party which is related to benefits arising partnership deed cannot be referred.
And the dispute essentially relates to the benefits arising out of that
deed.
Same point has been considered by the
Where
bench, same bench.
My lord, your lordship had the occasion to consider this issue also, my lord, in I think a very recent judgment, my lord.
25, so it was.
This is
20.
No, division bench.
Yes.
2025 SCC online, Calcutta 2380, my lord.
Single bole kati dibo.
This was also, my lord, section 8 appeal. Kindly see, my lord, paragraph 8. Cause of action in the suit is primarily against defendant appellant firm and its partners and defendant number 5, respondent number 2, the BPCL was.
That was a submission.
Yes, this was submission.
But still.
Then your lordship will kindly see the prayer your lordship has noted in paragraph 13. Plaintiff's prayer for decree against whoever was towards plaintiff's cap such and such. Then your lordship will kindly come to from paragraph 26. Your lordship has discussed the scope of section 8. Paragraph 29, if your lordship comes, my lord. On the other hand, in a section 8 consideration, the court is not merely an instrumentality under 90, akin to the role of High Court under 11. There is already a pending civil suit in an otherwise competent civil court, which is already in ceasing of the suit when the application is signed. Court, while dealing with an application, apart from considering the validity of the agreement, has to read the plaint and the pleadings of the parties, including the written statement if filed and of the application under 8 itself in a holistic, meaningful, whether relief claim in the suit come within the ambit of the arbitration agreement. Also to be kept in mind, section 8 does not create an absolute legal bar to the court taking up and deciding the suit in the sense right to have reference can be waived by the defendant simply by not filing a proper application. In such case, the suit would proceed. Then your lordship has discussed paragraph 30. After paragraph 30, whether reliefs claimed against defendant number 3 and 4 come within the ambit of section 8 of the 1996 Act. Paragraph 31, section 7 of the Act is wide in its scope, whereas the term party has been defined in 21H to be a party to an agreement. 7.1 provides arbitration agreement by parties to submit to arbitration all certain which may arisen or which may arise between them in respect of defined legal relationship. Section 8 provides that a reference to arbitration shall be made if a party to the arbitration or any party claiming through or under him applies under the said provisions. Then, my lord, will kindly come to 35. Hence, read in the context of 7.1, the dispute involved in the suit relates to a dispute between a plaintiff on the
Para
strength of
33 also probably because defined legal relationship
Yes.
also comes within.
defined legal
So
relationship.
that defendant number two's defined legal relationship is through you.
Through me. If I may read, Madam, 35.
Yes, 35, yes, right. You're right. 35.
The dispute
your
in-
argument is yes.
In the suit relates to a dispute with the plaintiff on the strength of his previous status as the partner of defendant number 1 firm, and the relief sought is against the partnership firm as well as its present partners after reconstitution, out of whom defendant number 3 and 4 were subsequently inducted, and defendant number 2 has continued as a partner from pre-reconstitution period. Thus, expression a party to the arbitration agreement or any person claiming through or under him as used in section 8 read in conjunction with section 7 takes within its ambit defendant numbers 1 to 4, all of whom are either the partnership firm or parties coming within defined legal relationship of partners within the contemplation of the arbitration clause in 1994. Then your lordship, 36, 37 and 38, your lordship, 3 and 4 are unequivocally consented to being subject to arbitration sought in the section 8 application.
Good.
Paragraph 43 is also important. In a section 8 scenario, nature of reliefs got to be looked into where the relief sought in a suit against non-signatories is in harmony with the relief sought against the signatories, particularly when the legal relationship between signatories and non-signatories are on the same platform vis-a-vis the cause of action of the suit. And the reliefs claim that non-signatories may very well be brought within the purview of the arbitration agreement. There cannot be any defendant, appellant.
So the relationship between 2 and 1 are on the same platform, because if
they
your
have
right goes,
independent right apart from me.
your right goes, their right also.
Yes, yes.
43, yes.
I am not placing, my lord, same view your lordship has expressed. Kindly see from 44 to 47.
59 and 60 tag 59 and 60.
Yes, that independent thing, pseudo liability and whatever. Yes.
Yes.
Very.
59 and 60
Huh?
59 and 60.
My lord, the one judgment which has been relied upon in the impugned judgment.
এখানে পার্টির এক্সটেনশন যেটা করেছে 2018 প্যারা 28.
Now kindly come to the, may I come to the impugned judgment first, and then I'll come to my lord, to Gujarat Composite, which has been relied upon.
Page 196.
Kindly see the impugned judgment.
Page 196.
Yes.
The next which is
196. Injunction order.
If you refer to the internal pages, Mr. Shen, we'll be seeing from the map.
Starts from kindly, I will
Just refer to the internal pages.
straight away kindly come to internal page. Page 3.
Yes.
Yes, internal page 3 at the bottom. In the present suit,
That is injunction.
plaintiff has prayed for injunction against defendant number 1, who is a party to the arbitration agreement dated such and such, and also against defendant number 2, who is not at all a party to the arbitration agreement containing arbitration clause. In my opinion, as the ambit of the arbitration clause of the arbitration agreement does not extend to defendant number 2 in respect of his claim over the suit property, the relief of injunction sought for by plaintiff against defendant number 2 cannot be heard and decided by the arbitrator under any circumstance. It is a cardinal principle of law that cause of action under any circumstances cannot be bifurcated into two different parts in such a way that one part of the cause of action may be left to be decided by the arbitrator, while the other part may be left for the decision of the civil court. This position has been enunciated in the decision reported in such and such Gujarat Composite, where Honorable Supreme Court has been pleased to observe the relevant language used in section 8. In a matter which is the subject matter of an arbitration agreement, the court is required to refer the parties to arbitration. Therefore, the suit should be in respect of a matter which the parties have agreed to refer and which comes within the ambit of arbitration agreement. Where, however, a suit is commenced as to a matter which lies outside the arbitration agreement and also between some of the parties who are not parties, there is no question of application of section 8, words in matter indicate that the entire subject matter should be referred to arbitration. From the discussion, it is crystal clear that arbitration clause does not apply. Let me show Gujarat composite to show how Gujarat composite will not apply. Okay.
একটাই কপি পাচ্ছি একটা ট্যাবে দিয়ে দিচ্ছি।
Problem is, I have one copy of that Gujarat.
Give one copy, I'll
take
follow.
If
you have one copy, that is
no, I have got.
Yes.
Lordship will kindly come to the paragraph 41 of the judgment. There are several agreements. Some contained arbitration clause, some did not contain arbitration clause. Kindly see. Just give me 1 minute. Yes, if your lordship kindly comes to paragraph 41, as noticed. Paragraph 41 is at page 223.
Yes.
As noticed, there had been multiple transactions in this matter. The learned counsel for the contesting respondent has placed before us in tabular form relevant agreements contracting parties thereto, purpose of the agreement, availability of arbitration clause therein. We may reproduce the same to facilitate an eye view of the salient features of the transaction. Kindly see, my lord, the next page. The table, serial number 1 has arbitration clause, serial number 2, 3, 4, 5, 6. These agreements do not have arbitration clause. Next, paragraph 42. Thus, except principal agreement, none of the other agreements contained any arbitration clause, even if they related to the same property and also involve the appellant and the respondent number 1. The later transactions involved other parties too, like the tripartite agreement dated 6 July, whereby respondent number 2 bank sanctioned loan to respondent number 1 and then supplemental to the tripartite agreement for dealing with the deposit of title deeds. Similarly, other deeds of conveyance involve the appellant and others. The aforesaid position of the dealings of the parties, when examined with reference to the reliefs claimed in the suit and the cause of action pertaining to the said relief, as extensively noticed by the High Court and extracted above, we are clearly of the view that the submissions made by the appellant with reference to amendment of Section 8 and the later decisions of this court in interpretation of the amended Section 8 do not inure to the benefit of the appellant. This is for the simple reason that no such conjunction can be provided to the original license agreement dated such and such and the tripartite agreement involving the bank, whereby arbitration clause could be held applicable to the tripartite agreement too. This is apart from the fact that in the frame of the suit and various other reliefs claimed involving subsequent purchasers too and the allegations of fraud, the dispute cannot be arbitrable at all. The present one cannot be said to be a case involve any doubt about non-existence of arbitration agreement in relation to the dispute in question. There being no doubt about non-existence of arbitration agreement in relation to the entire subject matter of the suit, and when the substantive reliefs claimed in the suit fall outside the arbitration clause contained in the original license agreement, the view taken by the High Court does not appear to be suffering from any infirmity. So now this is the distinguishing line. Substantive reliefs claim in the suit fall outside the arbitration clause contained in the original license agreement. This aspect has not been considered in relation to our case. even if by reference to remote pedigree, original license agreement is said to be the genesis of the contractual relation of the appellant and respondent number one, that does not ipso facto lead to availability of arbitration agreement in relation to the dispute in question, which emanates from the tripartite agreement. So there was some dispute other than the license agreement emanating from the tripartite agreement, where there was no arbitration clause, which cannot be determined without reference to the said tripartite agreement and without involving all the parties thereto. In other words, no dispute resolution process, including arbitration, could be undertaken in relation to the subject matter of the suit without reference to the terms of the tripartite agreement and without involving the bank. Well, this is the distinguishing feature of our case. Well, I think, well, these are my submissions. Well,
Yes.
Party
Yes, Mr. Tiwari.
Huh?
Parties includes anyone claiming only.
Defendant number 2 is claiming through me.
But kindly take not plain.
Will it be your lordship's pleasure to hear me together on the injunction also? Because the point will not be very different, because I have raised.
No, first we'll decide this. If we allow your appeal on this,
then
it has to be referred, the injunction has to go. And if it's to the contrary, then injunction will be taken up. Mr. Tiwari, do you agree to that? If we allow, yes. It's better to hear out the section 8.
Yes.
If his appeal is allowed, problem solved. Otherwise,
Well, let us take section 8 application, which was filed before the trial court. Page 194.
$194.
Annexure F.
Yes, yes.
May I just place it note?
Right.
Petition that the plaintiffs have filed the above suit against the defendant and other defendants with a prayer to declare the agreement executed on 9/7/2004 and the subsequent agreement dated 3rd March 2005 executed between the plaintiff number 1 and defendant number 1 are still subsisting along with other prayers. That the clause 28 of the agreement dated 9/7/2004 speaks, in case of any dispute or difference arising out between the parties herein regarding the validity and interpretation of the agreement, matter shall be referred to the sole arbitrator to the district magistrate, Murshidabad. The defendant number 1 has already terminated the agreement dated 11/1/2022 by issuing the nature under memo number such and such. The plaintiffs challenge the termination by filing the instant suit. So the dispute arose about the validity of the termination notice dated 11/1/2022, and the plaintiff also raised other disputes in the plaint filed by them. Under the provisions of the Arbitration and Conciliation Act 1996, the disputes raised by the plaintiff should be referred to the arbitrator under clause 28 of the agreement dated 9th of July 2004. The plaintiff.
Where are you reading this?
Now, will kindly see. Today, why I am reading this? Where is the pleading regarding the group of companies? Is there any single statement in the section 8 application?
That you are the alter ego?
He is claiming.
That argument?
Yes. The alter ego.
We are not accepting that.
Alter ego argument, my lord, he is making, my lord, there is not a single statement in the section 8 application.
On the basis of the material, at this stage at least, we cannot decide that.
Nothing has.
Cannot say that you are an alter ego.
Different number.
What about the merits? The main matter.
Yeah, so far as
Heat of the matter
so far as my lord, kindly consider my lord, situation today, my lord. My lord, what I am submitting before your lordship, my lord, different number 2 is not claiming through the different number 1. Now, once work order has been issued, he has an independent right. He has an today. Think about the situation. Today, my lord, different number 2 file the writ petition before this Honorable Court.
Mr. Tiwari, if one of the parties sells the property to somebody, that party is said to claim through the vendor.
Yeah, but here
the claim has to be through the vendor. Work order is on a much lesser footing. Claiming through does not necessarily mean that the original party still retains a right. Claiming through means the title of the party has devolved upon this person.
Yes, absolutely correct.
So the 2 is claiming entirely through 1. Because 1 floated the tender, getting the lease from there.
After the issuance of work order, whether 2 has any independent right or not.
Even if 2 has an independent right, a party claiming through another party does not necessarily mean that the other party is a subsidiary under that party.
I will be coming to the kindly.
Subsequent purchaser also claims through someone.
Yes, yes. Kindly see, what are the cause of action, against the defendant number 2? What I have pleaded.
We have not found anything.
Yes, yes. I'm just
Two things, work orders issued in two places. Paragraph 28, 29, you have said defendant number 1 will take possession and give it to 2.
no, my lord. Kindly text, my lord, what I have pleaded so far as defendant number 2 is concerned. What is the cause of action? My lord, kindly text, my lord, paragraph 33, page 48. Rather, my lord, kindly text, my lord, paragraph 40, page 49, middle portion.
Yes.
The further cause of action recently arose on 13th of June 2024 when the concerned officer of the defendant number 1 issued the letter to the Lila Hospital Private Limited regarding the letter of acceptance for temporary lease rent for the civil structure along with the furniture fixtures items such and such Murshidabad Jila Parishad in Rabindranath Tagore Diagnostic Medical Center besides such and such and such. So, my lord, 13th
Not a single allegation that defendant number 1 or its managers did anything
yes, yes.
to dispose you.
Yes, yes.
Not a single allegation
No, no,
throughout your plaint. Show us a single allegation defendant number 2 or its men and agents tried to disturb my position. Anywhere. Throughout the plaint in all these 34 paragraphs. We have seen most of these.
My lord, kindly turn, my lord, paragraph 26.
26. Yes. 26.
26, my lord, Your Honor, from the record.
Some act on the part of the defendant number 2.
From the records, it will be evident the plaintiff number is in possession of the services and such. Plaintiff number 1 had in fact issued the work order in favor of the defendant number 1. Defendant number 1 is trying to
20
dispose
is
the
missing. Page 20 is missing here.
20 is missing.
So that's why we could not find out.
Page 20 is there subsequently. A lot of kindly.
Probably that's why we missed out.
Yes.
Page 20 is there subsequently. Page 51. If you are kindly text the running page 51. 51. Running page 51. 51.
That is page 20.
Yes.
Yes.
That is
right.
the internal page 20.
Yes. 26 now we have got.
Now 26. From the records, it will be evident the plaintiff number 1.
Same thing. What has the defendant number 2 done?
Defendant number
1 allegation, defendant number 2 or its men and agents are trying to dispose us because your only relief against 2 is permanent injunction so that the defendants may not dispose you. Only relief in the suit against defendant number 2.
So far as kindly take another paragraph, page 48, paragraph 31.
Precisely.
My allegation is defendant number
1 will dispose you and give possession
to the defendant number 2.
So not a single, this plaint should be rejected on the ground of non-disclosure of cause of action against the defendant number 2.
I have stated, my lord, so far as cause of action is concerned,
what has the defendant number 2 done?
Defendant number 2, my lord,
you said defendant number 1 will take and give to 2.
This is my case. The defendant
Therefore, how do you substantiate your prayer for permanent injunction against defendant number 2? Then they may not dispose me. You have not alleged a single sentence saying that 2 is trying to dispose me. So how can you get you can get an injunction against 1 as per your pleading, restraining defendant number 1 from taking possession and giving it to 2 as per your pleadings. So then also it's against 1.
My case is, my lord, the defendant number 1 is trying to take possession without following the due process law.
It's written defendant number 1 is writ large over the entire plaint.
Yes.
Not a single allegation that defendant number 2 is trying to do anything. Anything. All, even passive voice. Even the work order was issued by defendant number 1 to 2. We have seen all the paragraphs which are visible to us at least. 20 we missed out, but it's similar. We have found, we could not find a single line of allegation against defendant number 2. They are trying to do this.
Allegation is defendant number 1.
All allegations. They are trying to take
from me and give it to defendant number 2. They are trying to...
cannot substantiate. We are thinking of whether we should reject the plaint.
No,
but we are not empowered.
So far as injunction is concerned, my lord, in the injunction...
Permanent injunction you have claimed against defendants.
Yes.
But that is not substantiated by any cause of action against defendant number 2. Cause of action is again defendant number 1 will take and give it to 2.
Now, my lord, kindly turn, my lord, page 80.
80?
80.
Yes.
Paragraph 34.
What is this?
This is the injunction.
This is the injunction application.
Yes.
Paragraph 34.
4.
Yes.
Now, my lord, what I have stated.
Now, this is something which is beyond the plaint.
Yeah, I have said, my lord, the opposite party number 2 started disturbing the position of the
This is,
petitioners
this
over
is
the
something
property.
beyond the plaint, Mr.
Yeah.
Theory.
My lord, kindly
We have to see, look into the plaint and the written statement at best to ascertain what is the scope of dispute of the suit. No issue can be framed on injunction application averments.
Absolutely correct.
Yes, you have written in the injunction application, there is a sentence that 2 is trying to disturb.
Well, then also, my lord, subsequent paragraph also there, my lord, regarding defendant number 2.
Opposite one number 3 is also trying to evict.
No,
there is no 3.
Mistake, my lord. It should be 2.
No, it should be 2, right, right.
Yes.
Again, the fall back to your old thing, one is trying to
yes
help, rendering all possible help to opposite partner. This single sentence in the injunction, that too. And even if this single sentence is there, 2 is, you are saying there, see, opposite party number 1, see the mode of your cause of action, Mr. Theory. 1 is trying to take possession from you and give it to 2. Therefore, still you are saying 2 is not claiming through 1. Your plaint says that entire basis of your claim against opposite party number 2 is through defendant number 1.
Kindly see, my lord.
They cannot even take their own possession. They have to depend on defendant number 1 to take possession from you and give it to them.
My lord, kindly take, my lord, section 8 once.
Yes.
Section 8, my lord, says, my lord, a judicial authority before which an action is brought in a matter which is the subject matter of an arbitration agreement shall, if a party to the arbitration agreement or any person claiming through or under him so applies not later than the first date of submitting the first statement on the substance of the dispute, then notwithstanding any judgment, decree and other Supreme Court, the court shall on prima facie no valid arbitration exist. The court shall refer it to the arbitration. Now, my lord, it says about, my lord, can you see the judicial authority before which an action is brought in a matter which is the subject matter of an arbitration agreement. Now, my lord, in this line, my lord, kindly consider, my lord, the 2 judgments, my lord, I will be citing to your lords before your lordship, my lord. One is, my lord, 2023 SCC online SC 87. No, 8 of the Sukonna holding. Next. This is 2003 5 SCC 531. Sukonna Holdings Private Limited.
Sukonna holding has been subsequently distinguished by many judgments.
Distinguished, my lord. It is not upset.
Sukonna is no longer good law.
It is, my lord.
Anyway, let us see which sections you.
Yes.
What has been amended?
Even in Gujarat, which you cited, there also it has been recognized.
Yes.
Sukonna has been
recognized.
And in which judgments distinguished, that has also been stated.
Yes. That is a Cox. Most probably.
You know those judgments, and Gujarat also says.
So far as that judgment is concerned, I will be citing that judgment also. Sukonna holding judgment, my lord. It says not
overruled.
Not overruled.
Right.
I'll refer on 3 pages of that.
Yes.
My lord, kindly take, my lord, paragraph 12. Page, my lord, 535.
Yes.
For interpretation of section 8, section 5 would have no bearing because it only contemplates that in the matters governing part 1 of the Act, the judicial authority shall not intervene except where so provided in the Act. Except section 8, there is no other provisions in the Act in a pending suit. The dispute is required to be referred to the arbitrator. Further, the matter is not required to be referred to the arbitrator tribunal if the parties to the arbitration agreement have not filed any such applications for referring to the dispute to the arbitrator. In a pending suit, such application is not filed before the submitting the first statement on the substance of the dispute, and such application is not accompanied by the original arbitration agreement or duly certified copy thereof. This would therefore mean the Arbitration Act does not oust the jurisdiction of the civil court to decide the dispute in a case where the parties to the arbitration agreement do not take appropriate steps as contemplated under section such and such. Secondly, paragraph 13. There is no provisions in the Act when the subject matter of the suit includes the subject matter of the arbitration agreement as well as other disputes
the matter is required to be referred to the arbitrator. There is also no provisions for splitting the cause or parties and referring the subject matter of the suit to the arbitrators. Now, my lord, kindly take, my lord, paragraph 15.
14 is also there.
Paragraph 15 says, the relevant language in section 8 in a matter which is the subject matter of an arbitration agreement, the court is required to refer the parties to the arbitration. Therefore, the suit should be in respect of a matter which is the parties have agreed to refer and which comes within the ambit of the arbitration agreement. Where, however, the suit is commenced as to the matter which lies outside the arbitration agreement and is also some of the parties who are not parties to the arbitration agreement, and there is no question of application of section 8. The word a matter indicate that the entire subject matter of the suit should be the subject matter of the arbitration agreement. The next question which arises for consideration, that even if there is no provisions for partly referring the dispute to the arbitrator,
Cannot be bifurcated.
they can. Now, my lord, my submission would be before your lordship, my lord, today, my lord, so far as, my lord, this defendant number 2 is concerned, the defendant number 2, my lord, so far as defendant number 2 is concerned, my lord, defendant number 2, my lord, acquired, my lord, independent right on the basis of the work order issued on, my lord, in June 2024. My lord, defendant number 2, my lord, defendant number 2, my lord, can enforce that work order. So far as, my lord, plaintiffs are concerned, my lord, plaintiffs are, my lord, deriving or claiming that this is a subsisting lease agreement. On the basis of this lease agreement, plaintiffs, and there are other issues are also involved. In that issues, my lord, defendant number 2 is a necessary party. Defendant number 2 is a necessary party, and so far as defendant number 2 is concerned, my lord, that this suit cannot be, my lord, decided in the absence of the defendant number 2, as because the work order has already been issued in favor of the defendant number 2. Now, my lord, I just refer, my lord, another judgment, my lord, that is, my lord, 2023 SCC Online Supreme Court 87878. 2023 SCC Online SC 878. If you will also, can you text paragraph 9? The narration of facts indicates that MOU dated 14th of September 2010 is between the appellant and the first respondent. The appellant instituted 2 suits. In the first suit, the first respondent has been implicated as the first defendant, while Sachdeva and Sons Industries Private Limited is implicated as a second respondent. Admittedly, the Sachdeva and Sons Industries Private Limited is not a party to the MOU, which is executed solely between the appellant and the first respondent. In the second suit, apart from 2 defendants who are the parties to the first suit, relief has been sought against the Canara Bank, while the relief which has been sought in the first suit in terms of an injunction simpliciter from the alienation of certain land, and relief which has been sought in the second suit is for permanent injunction restraining the Canara Bank from disturbing or releasing any loan or finance in the name of the first respondent and the second respondent in respect of the landed property. Certain consequential reliefs have been sought against the Canara Bank. Hence, it is evident that there are several parties to the suit who are not parties to the arbitration agreement, and the MOU which is executed between the parties indicate the Sachdeva family, comprising of both the appellant and the first respondent, was carrying on business several companies, partnership firm, proprietorships under the joint ownership of the Sachdeva family. MOU contains descriptions of the respective family units and their concerns. MOU indicate that there are certain non-family shareholdings. In this background, since the MOU was executed exclusively between the appellant and the first respondent, the reference to the arbitration under section 8 of the trial judge was patently in error. Neither the Canara Bank nor the company are parties to the arbitration agreement. MOU has been executed between the appellant and the first respondent, and the non-family shareholdings in any event cannot be bound by the terms of the MOU, since they are not parties to the document. So, my lord, my submission would be before your lordships. The defendant number 1, my lord, cannot be made bound to the arbitration agreement, my lord. More so, the defendant number defendant number 2 was not even existent. Defendant number 1 will not come much after, my lord, in 2013, my lord, incorporation company. When the agreement was executed, my lord, lease deed was executed, it was in 2004. But 9th of July, my lord, 2004. At the relevant point of time, my lord, defendant number 2 was not even existent. It was, so far as my information goes, my lord, it was incorporated in 2013. So, my lord, the defendant number 2 was not even born.
There is no question that it was not a signatory to the agreement. Nobody doubts that.
Yes, there is not only, there is no connection. There is no connection at all. So far as defendant number 2 is concerned, my lord, there is no connection at all. So far as defendant number 1 and defendant number, so far as, my lord, plaintiffs and defendant number 2 is concerned, there is no connection. There is no pleading to the effect, my lord, that these are all connected companies or group of companies.
Did the defendant number 2 file an objection to your application?
Yes, yes. Well, can you take?
What was that? We have to see their stand also.
Yes, can you see that their stand?
That is also important here.
Yeah. Vinod Kumar Sazja. Defendant number 2 defendant number 2 objection.
The defendant number 2 filed an objection to the Section 8 application.
Defendant number 2 filed an objection, my lord, to the injunction application.
That is different.
No, stand, your lordship would get the stand. So what is that?
Where, show us. That they oppose the Section 8.
Yes, yes.
Show us that. What is this?
Objection.
Their objection to your injunction.
Yes. Defendant number 2's objection to the injunction application.
Where have they stated they have objection to reference? Rather in para 12, they say that they have unnecessarily been impeded.
Yes.
No cause of action, rightly so, and respectfully submitted that the name of the defendant should be expunged from the array of parties.
Paragraph.
So if that is to be accepted, then they should be expunged, and your only your last straw for resisting arbitration goes.
Till now it has not been expunged.
No, they have neither have they prayed for expunction.
Kindly see,
they're right actually. No cause of action disclosed against them. But in the injunction application, there is a sentence. At the very next sentence, you dilute it by saying that they are giving, one is giving all possible assistance to them to do it.
Actually, defendant number 2, what defendant number 2 is saying, your lordship, kindly take paragraph 10. Paragraph 10, it says, in view of facts and circumstances, most humbly submitted that before this land court should direct the defendant number 1 to settle the dispute with the petitioner such and such, and take necessary steps to hand over the back end and litigation fee position to the defendant number 2. It is true that the work order has been issued in favor of this defendant.
Direct the defendant number 1 to settle disputes with petitioner. They also highlight that the dispute is between them. And obviously, he has nothing to do with
it. Between the, absolutely, there is no doubt. The dispute is between the plaintiff and the defendant number 1.
Complete the defendant number 2 just to get out of the purview of arbitration.
No, your lordship, kindly consider one
no,
thing.
Cause of action is disclosed in the
cause of action is issuance of work order. What happened today, kindly see. On merit, one hand,
the defendant number 2 does not say will be affected even. They say expunge us. We are unnecessary parties.
As because they are not
bothered with the outcome.
As because they are not getting possession, they have invested money. They are not.
They say we are not interested in the outcome.
Yes,
they happy you have impeded them. You have done a social work by impeding them so that their interest does not suffer. And they refute that social work by saying, no, please expunge us. We are not interested in being a party to the suit.
That's why, what is this stand? Can you see page 2, Roman 2, paragraph Roman 2.
Work order they say.
Yes, what they are saying. The defendant number 1 has failed to keep its promise until now the petitioner is in possession of the suit property. Instead of handing over the vacant possession of the suit property to this defendant, the defendant number 1 is claiming for the lease amount. However, having no alternative, the defendant number 2 by letter dated such and such informed the defendant number 1 that this defendant is ready to pay the entire lease amount, but this defendant requested the defendant number 1 to hand over the pre-vacant and unencumbered peaceful possession to this defendant, and the defendant number 1 failed to hand over the possession to the defendant number 2. The reason which restricted the defendant number 1 from handing over such possession to the defendant number 2 was not even to the knowledge of the defendant number 2 till getting the notice of present suit. Well, the stand of the defendant number 2 is clear. They are saying hand over peaceful possession to us, who will make the rest of the payment. But so far as I am concerned, my lord, my case is this, that defendant number 2, defendant number 1 is trying to take possession by ousting me without following the due process of law. Without following the due process of law, and so far as my lord, injunction application is concerned, I am not making any submissions so far as injunction application is concerned.
Not right.
Not necessary. Now, my lord, so far as section 8 is concerned, my lord, I shall not be repeating, my lord, something, that a dispute. And my lord, the party to this dispute, my lord, the defendant number 2 was not even at existence, my lord, at the relevant point of time when the lease agreement was executed. These are my subs.
Yes.
Just 2 minutes, my lord. The Sukanya holding, my lord.
So far as Sukanya, just time, just time. Judgment. Cox and Kings. Cox and But so far as Sukanya holding is concerned, Lord, it has been deferred in Cox and Kings. But I just now, if your lordship, my lord, kindly text. If your lordship, my lord, kindly text, my lord, page 39, paragraph 21.
Yes.
Lord, this Sukanya holding was referred. Paragraph 21 says, this court construed the parties by limiting it to the signatories of the arbitration agreement. In Sukanya holding, the applicant has filed an application under section 8 of the Arbitration Act before the High Court and sought to enforce the arbitration agreement against both the signatories and non-signatories to the agreement. The High Court rejected the application on the ground that non-signatories were not parties to the arbitration agreement. In appeal, this court upheld the decision of the High Court by observing there is no provisions under the Arbitration Act stipulating what is required to be done where some parties to the suit are not the parties to the arbitration agreement. Such and such, while dealing with the international commercial arbitrations, the party to the arbitration agreement mean the party to the judicial proceedings. This also expressly held to be erroneous in the case of such and such, wherein it was held the party has to be construed in view of section 21H to mean the party to an arbitration agreement. Now, my lord, if your lordship, my lord, kindly takes, my lord, page 33. Page 33, where also, my lord, page 33, paragraph 5, where, my lord, Sukanya holding was referred. In a concurring opinion, Justice Sujakant observed that the decisions of this court in such and such rendered in Sukanya holding private limited such and such adopted the rigid and restrictive approach by placing undue emphasis on formal consent. Surya Khan judge states the evolutions of the group of companies doctrine to observe that it had gained a firm footing in Indian jurisprudence. However, he opined that this court adopted the inconsistent approach while applying the doctrine in India, which needed to be clarified by a larger bench. Accordingly, he highlighted the following questions and matter was referred to the larger bench. Now, my lord, I just referred to your lordship, my lord, another page regarding Sukanya holding was discussed. If your lordship, my lord, kindly transfer on page 106.
Yes.
My lord, page paragraph 209.
Hmm.
The two decisions of this court preceded such and such, namely Sukanya holding and such, were based on strict interpretation of section 7 and consider the parties to an arbitration agreement are limited to its signatories. Now, my lord, Sukanya.
Read the next paragraph. The first sentence of the next paragraph.
There was a definitely shift to the position of such and such, arising out the construction of the multi.
Not to yourself.
The petition and the reference to arbitration agreement suit the despite parties, the contract of the arbitration agreement interpreting the what any persons and claiming to any persons shall in section 45. This court enlarged the scope of reference to the first non-binding signatories. But my response, my lord, Sukanya holding till late, my lord, has not been upset.
Sukanya holding might have been upset after the judgment, and the judgment has not been overruled.
No, judgment has.
Sukanya holding, as in the company.
Yes.
That company might have been upset.
Yes, might have been upset.
The judgment has not been upset. But yes, the apple cart has been upset because of this para 210, the very next paragraph.
Yes.
There was a definitive shift in this position.
Shift.
Arising out of conspectus interpreting the words and phrases any person claiming through or under and shall. In section 45, this court enlarged the scope of reference for the first time to bind non-signatories. This is the Cox and Kings
Cox
is
and
the
Kings.
last position.
Yes.
At least on this.
Yes.
And group company theory was floated. That's a different concept altogether.
Well,
Here group company, but it's not restricted to group companies.
No. It is not restricted.
The expansion is not restricted to group companies with a theory. But this is not a group company case at all.
This is not a group company. There is no pleading to the affair also. There is no pleading.
Company was rather argued in against you by Mr. Shen. Not group companies in these cases was in favor of expansion.
Expansion. There is no doubt.
But Mr. Shen's argument on your being an alter ego is not on the contrary perception.
Perceptions.
Anyway.
These are my thoughts.
Yes, Mr. Shen. Very short.
Very short.
1 minute.
Yes. Now, the last judgment which has been cited, 23.
Cox and Kings,
No, not the Cox
2003.
and Kings. I'm not going into that because
2003.
section 8 has been amended. It has specifically come in parties or anyone claiming through that.
That is for a party applying.
Yes. But
it does not say that non-signatories would also suffer from that. If non-signatories are parties to the suit, that has not been stated. We have to read something into that. Section 8 says a judicial authority before which an action is brought, if a party to the or any person applies, applicant may be. So we have to apply that analogy to the other parties also.
Other parties also. Well,
that would be the substantive relief theory, basically.
Absolutely.
Whatever we say, we now label as theories, doctrine theory.
The purpose
because it's me who is
purpose of the amendment.
The doctrine of substantive relief, Mr. Shen.
That is the most important thing, my lord. That is what my main case. Substantive relief covered, and my lord, the defendant number 2 is bound because whatever right he has got, he is claiming through me. My lord, the last judgment is distinguishable on fact. It is almost same fact.
Last judgment is Cox and Kings.
No.
Only 2 judgments were cited.
23 volume.
SCC online.
SCC online SC.
SCC online. 878.
Vinod Kumar Sajava.
That also you have yes, sorry.
That is, my lord, kindly take only 2 paragraphs. It is the same fact as Gujarat.
Para 19.
Yes.
Canada Bank and Company,
yes,
not parties to the arbitration agreements, but substantive reliefs to assert.
That is
Defendant number 2 was the company against whom permanent injunction was sought. That was the main relief in the suit.
exactly.
And Canara Bank was sought to be restrained from disbursing or releasing any loan. Main relief again.
They are not parties, my lord. But these are my submissions. my lord.
Which appeal is against the section 8 part?
Item number 10.
FMA?
8-1.
Sorry, this is yes, FMA. 816 or the other one? Or
160.
81, both are 816.
এখানে দেখো না।
দুটোই 816 গুলো। এটা 816. 10 is the first one. FMA 816.
নম্বর লেখা থাকে না।
আরেকটা 167 আছে।
Yes, my lord, 816.
Two appeals have been preferred. The present two appeals have been preferred against the same order. Full stop. In FMAT 167 of 2025, the grant of injunction in favor of the plaintiff stroke respondents, plaintiff stroke respondent number 1 has been assailed. No, sorry. You have, in your memorandum of appeal, you have not stated one to be plaintiff.
Did you memorandum of appeal?
Anyway.
Down.
Whereas in
may I take a lordship leave minute?
Yes. FMA 8 whereas in FMA 816 of 2025, the rejection of an application under section 8 of the Arbitration and Conciliation Act 1996 filed by the defendant number 1 stroke appellant has been challenged under section 37 of the 1996 Act. Full stop. The main premise on which the application under section 8 was refused by the learned trial judge was that the defendant number 2 was a non-signatory to the arbitration agreement, and as such, the parameters of section 8 are not satisfied. Full stop. Next para. Before the trial court, the defendant number, the plaintiff stroke respondent number 1 also took an objection to the effect that the original lease agreement containing the arbitration clause within bracket clause 28 bracket close was not produced. Full stop. Next para. Learned senior counsel appearing for the defendant number 1 stroke appellant argues that the principal relief in the suit has been sought against the defendant number 1. Full stop. Moreover, the entire gamut of the reliefs sought in the suit revolve around the lease agreement containing the arbitration clause. Full stop. Relief A in the suit is for a declaration that the said deed of agreement dated July 9, 2004 and subsequent agreement dated March 3, 2005 executed between the plaintiff number 1 and defendant number 1 are subsisting, and relief B is to the effect that the plaintiff number 1 is still a lessee in respect of the suit property on the basis of the subsisting lease agreement dated July 9, 2024. For the next para, thus, it is argued that the defendant number 2 was impleaded merely to obviate a reference to arbitration. For the next para, learned senior counsel for the appellant takes the court through the pleadings of the plaintiff and argues that no cause of action has been disclosed against the defendant number 2, and as such, there cannot be any hindrance in the court referring the matter to arbitration. Full stop. Next para. Learned senior counsel appearing for the appellant further contends that the entire claim of the defendant number 2, which was a successful bidder in a tender floated by the defendant number 1 for the purpose of granting a fresh lease, is through such tender and as such through the defendant number 1. Full stop. Hence, as per the plaintiff pleadings, no independent right of the defendant number 2 has been disclosed. Full stop. Thus, comma, since the defendant number 2 claims through the defendant number 1 for the purpose of the suit, comma, the agreement containing the arbitral clause also binds the defendant number 2. Full stop. Next para. At best, comma, it is argued that the defendant number 2 could have a cause of action against the defendant number 1 in the event the work order issued in favor of the defendant number 2 is not fructified. Full stop. However, comma, the same cannot determine the outcome of the Section 8 application within the conspectus of the frame of the present suit. Full stop. Next para. Learned senior counsel next argues that although although the original of the agreement was not filed with the Section 8 application, comma, a copy duly certified by an officer of the defendant number 1 stroke appellant was filed with the same. Full stop. That apart, comma, it is argued that in the event the original agreement is already a part of the records in the suit, comma, there is no further necessity to produce the document along with the Section 8 application. Full stop. Next para. Learned senior counsel for the appellant cites such and such namgulo debe reported at 2017 5 SCC 185, where the Supreme Court, comma, inter alia, comma, held that the plaintiffs therein were admittedly parties to the arbitration agreement, and it did not lie in their mouth to contend that since one of the defendants whom they had impleaded was not party to the arbitration agreement, comma, no reference can be made to the arbitrator. Push up. In the facts of the said case, comma, it was held that merely because one of the defendants was not party to the arbitration agreement, comma, the dispute between the parties which essentially related to the benefits arising out of the retirement deed and partition deed, partnership deed, could not be said to not being amenable to reference. Full stop. Next para. Learned senior counsel next cites coordinate bench judge. Next cites a division bench judgment of this court in Omuk matter, reported at 2025 SCC online Cal 2380, where it was observed, comma, inter alia, that the nature of reliefs claimed in the plaint are to be looked into in a Section 8 scenario, and where the relief sought in the suit against non-signatories to the arbitration agreement is in harmony with the reliefs sought against the signatories, comma, particularly when the legal relationship between the signatories and the non-signatories are on the same platform vis-a-vis the cause of action of the suit and the reliefs claimed, comma, the non-signatories may very well be brought within the purview of the arbitration agreement. Full stop. The court also took into consideration the definition of an arbitration agreement in Section 7 of the 1996 Act, which was held to incorporate defined legal relationship within it. Full stop. Next para. Learned senior counsel further relies on further places before the court Gujarat Composite such and such reported at 2023 7 SCC 193, comma, which was relied upon by the learned trial judge in the impugned order. Full stop. It is shown from paragraph number 44 and paragraph numbers 44 and 45 thereof that there was no doubt about the non-existence of arbitration agreement in relation to the entire subject matter of the said suit, and when substantive reliefs claimed in the suits fell outside the arbitration clause in the original license agreement, comma, the Supreme Court held that the dispute, comma, emanating from a tripartite agreement not containing arbitration clause could not be referred to arbitration. Full stop. Next para, as opposed thereto, comma, it is argued, comma, in the present case, the substantive relief sought revolves around the lease agreement containing the arbitration clause. Full stop. Next para, learned senior counsel appearing for the defendant for the plaintiff stroke respondent 1, comma, in reply cites such and such reported at 2003 5 SCC 531 and submits that as per the Supreme Court, comma, unless the matter which is in dispute in a suit is entirely covered by the arbitration agreement, comma, there cannot be a reference to arbitration, full stop. If part of the cause of action is amenable to the jurisdiction of arbitration, comma, there cannot be a bifurcation of the suit in two parts, and as such, the application under Section 8 of the 1996 Act should be dismissed. For sub next para, learned senior counsel next cites Omuk reported at 2023 SCC online SC 878 in support of his proposition that in the said case, the Section 8 application was rejected since some of the parties to the suit were non-signatories to the arbitration agreement. Full stop. Lastly, comma, learned senior counsel cites Omuk such and such reported at 2024 4 SCC 1 where Sukonna Holdings Supra was also referred. Full stop. Next para. Upon a comprehensive perusal of the materials on record, comma, we find that the dispute raised in the suit is entirely covered by the arbitration clause in the lease agreement between the plaintiff number 1 and the defendant number 1. Full stop. Next para, the plaintiff number 2 being a director of the plaintiff number 1, comma, cannot be segregated from the plaintiff number 1. Full stop. Next para, throughout the plaint of the suit, comma, we do not find a single disclosure, a single sentence disclosing any cause of action worth the name against the defendant number 2. Full stop. The averments in the plaint which come nearest to such allegation is contained primarily in paragraphs 28 and 29 of the plaint, where it is stated that the defendant number 1 cannot dispossess the plaintiff number 1 and give possession to defendant number 2 without lawfully taking possession from plaintiff number 1. Full stop. The plaintiff number 1, comma, it is alleged, comma, is attempting to forcibly dispossess the defendant number 1 is alleged to forcibly to attempt to forcibly dispossess the plaintiff number 1 forcibly দুবার হয়ে গেল কেটে দাও second forcibly take it from the suit premises and hand over possession to the defendant number 2. Full stop. Next para. Thus, comma, the entire allegation is that the defendant number 1 is seeking to disturb the possession of the plaintiffs and thereafter to hand over possession to the defendant number 2. Full stop. Hence, comma, there is no positive assertion on any overt or covert act, COVERT, act on the part of the defendant number 2 to comprise a cause of action in the suit. Full stop. Next para. Reliefs A and B are entirely based on the subsistence of the agreement dated July 9, 2004 and March 3, 2005 executed between the plaintiff number 1 and the defendant number 1. Full stop. The July 9, 2024 agreement is thus the plinth of the suit and contains the arbitration clause. Full stop. In the consequential reliefs, comma, permanent injunction has been sought against all the defendants, but, comma, as discussed earlier, comma, there is no disclosure of any cause of action against the defendant number 2 at all. Full stop. Hence, comma, the omnibus relief of permanent injunction against all the defendants is not supported in the plaint pleadings. Full stop. Next para. Insofar as the defendant number 2 is concerned, comma, it is only a collateral beneficiary stroke victim of the outcome of the suit. Full stop. Next para. The defendant number 2 having become a successful bidder in a subsequent tender floated by the defendant number 1, comma, does not have any direct connect with the dispute raised in the suit, but apparently has been implemented primarily to oust the effect of the arbitration clause and a reference to arbitration. Full stop. Even if, comma, for argument's sake, comma, it is taken that some relief has been sought against the defendant number 2, comma, the claim of the defendant number 2 can only be through the defendant number 1, comma, the latter having floated a tender in which the defendant number 2 participated and got a semblance of a right to have a lease deed executed. Full stop. However, comma, such semblance of a right is only an inchoate right at this stage, and there is no right, title, or interest in presentee of the defendant number 2 in the suit property, even as per the plain pleadings. Full stop. Next para. The purview of inclusion of non-signatories to arbitration agreement in arbitration matters has been broadened beyond recognition after Sukonna Holding Supra, which has been cited by the respondent. Full stop. In fact, in Cox and Kings Supra, comma, which has been relied on by the plaintiff stroke respondents, comma, the Supreme Court categorically observed that after Sukonna Holdings, comma, the law has undergone a sea change. Full stop. It was observed that the restrictive interpretation given in Sukonna Holdings has suffered a definitive shift in the position from Chloro Controls India Private Limited versus namta dekhe kore diyo, reported at 2013 1 SCC 641. Full stop. Next para. Although the group company theory, comma, which was laid down in Cox and Kings is not applicable in the present case, comma, the concept of substantive relief is still a guiding factor in case of Section 8 references. Full stop. Section 8 within bracket 1 of the 1996 Act has now incorporated, comma, after the 2015 amendment, comma, not only a party to the arbitration agreement, but also any person claiming through or under him as an applicant. Full stop. By necessary implication, comma, the scope has been broadened to bring within the purview of arbitration not only the parties to the arbitration, but also people claiming through them. Full stop. Next para. We are conscious of the fact that such leeway has been given only in respect of the applicant and not to the other parties. Full stop. However, comma, as discussed above, comma, by necessary implication, comma, and read as a whole, comma, Section 8 provides that any dispute which is the subject of an arbitration agreement shall, comma, if the parties to it or parties claiming through such original signatories to the agreement so wish, comma, the matter has to be referred to arbitration. Full stop. The court does not have much of a choice left in that regard. Full stop. We must take note of the fact that the legislature, comma, in its wisdom, comma, deliberately introduced the expression double inverted, a matter which is the subject of an arbitration agreement, double inverted clause, in subsection 1 of section 8, instead of restricting the subject matter only to the parties to the arbitral agreement. Full stop. Thus, comma, the legal position stands that if the dispute raised in a suit is covered by an arbitration agreement and a party to it or anybody claiming through it seeks a reference, comma, the court is bound to refer the matter to arbitration as in the present case. Full stop. Next para. The argument as to the original of the arbitration agreement not being produced is specious, comma, since the suit itself is based on the lease agreement which contains the arbitration clause. Full stop. If the existence of the said agreement is to be disbelieved, comma, the premise of the plaint case also goes, comma, thereby relegating the suit itself to the waste paper basket. Full stop. Next para. As such, comma, the plaintiffs do not have much of an option but to admit the existence of the lease agreement and as such, comma, the arbitral clause contained therein. Full stop. Thus, comma, the technical aspect of section 8 within bracket 2 cannot be put on such a high pedestal that despite both parties relying on an arbitration clause contained in a particular lease agreement, comma, the subsistence of which has been claimed by the plaintiffs themselves in the suit, comma, has to be discarded and a section 8 application on the basis of such document be rejected. Full stop. Next para. Insofar as the scope of the suit is concerned, comma, we have already recorded above that there is no substantive cause of action against the defendant number 2 and the defendant number 2 apostrophe s addition is a surplusage which has been claimed by the defendant number 2 itself in its written objection filed against the injunction application filed by the plaintiffs. Full stop. Thus, comma, this is a case where there is no resistance on the part of the non-signatory party to the arbitration agreement to a reference to arbitration. Full stop. Rather, comma, the non-signatory stroke defendant number 2 itself seeks to be expunged from the purview of the suit, comma, which would further facilitate a reference to the arbitrator, comma, since the thin thread on which the plaintiff's resistance to a reference, comma, that is a non-signatory being a party to the suit, comma, would also go. Full stop. Hence, comma, such tacit consent on the part of the defendant number 2 to keep itself away from the foray of the disputes and thereby facilitate arbitration also has to be taken into account. Full stop. Taking the spirit of section 8 of the 1996 Act, comma, read in conjunction with section 5 thereof, comma, which restricts judicial intervention except as provided in the 1996 Act, comma, we are thus of the opinion that the learned trial judge substantially erred in law in rejecting the application under section 8 of the 1996 Act filed by the appellant. Full stop. Accordingly, accordingly. Next para. In view of the above observations and conclusions, comma, FMAT 167 of 2025 becomes redundant, comma, since, comma, as we have held that the matter ought to have been referred to arbitration by allowing the application under section 8 of the 1996 Act, comma, the rest of the impugned order whereby injunction was granted by the court was without jurisdiction and has to be set aside. Full stop. Accordingly, FMA 816 of 2025 and অন্যটা FMAT 167 of 2025 লিস্টে দেখে নি ওটাও FMAT
167
FMAT 167 of 2025 are allowed, comma, thereby setting aside order number 14 dated March 21 2025 passed by the learned civil judge, senior division, first court at Berhampur, district Murshidabad, in title suit number 06 of 2024, and referring the dispute raised in the said suit to arbitration. Full stop. Anything else? This is sufficient. No orders to cost. আরেকটা লাইন অ্যাড করে দাও যে consequentially can such and such যা যা পেন্ডিং আছে যা যা লিস্টে আছে are disposed of, তারপর no orders to cost. Yes.
The memo, the affidavit of service in respect of the other matter.
ওটা প্রথম লাইনে করে দিও, affidavit of service file to take. Yes, please.
No, I mean, next matter. Next matter.
Waiting for us to rise.
Well, is there any way lordships can take it up before my lords leave for Andamans next week?
Which one? No, not Andamans. Not so good.
Whatever.
Jalpai. Let's see.
Lordship, next matter where we are opposing each other. Is there any way? I mean,
Before no. Because we take up these assigned matters, we have kept
that's
today
the-
only for. And you have ensured that we cannot reach these other.
I got another matter.
is fixed on the 24th.
Assigned it. সেটাই বলছে যে
Because the
Calcutta
Calcutta
matter is fixed on the 24th, that's why, my lord.
but then we can't leave your lordship because this is Arise of Lodha Billah.
you can legitimately say that you have asked for.
Please do not say that because this is only a lordship knows this subject. This is
No.
Yes.
An emphatic no.
Yes.
Subject means Birla and Lodha themselves.
Yes, my lord.
So this is
The families.
family.
That is that is the only commonality between the subjects.
Well,
So very well. Let us try. No, you cannot. Because the other matters will suffer. We are taking up so many sorts of matters that it's difficult now.